Item number 64 of your lordship's list was an urgent motion by the molasses and the jaggeries, my lord, for the Bengal Excise Act issue.
64.
Item 64. It was taken up last week, was an urgent motion. They filed a report to your lordship. Lordship has given us the said report, a copy was given. Lordship fixed it today, but it is appearing as an adjourned motion as per your lordship direction. It will not be taken up, my lord. My track and the loaded goods are lying on the street. I am praying this, but tomorrow at 2 p.m. lordship can take it up. I shall give notice to the other side.
Already by 2 p.m., 12 p.m. matters are fixed.
Item number 64 was a motion matter, urgent motion.
Okay, let it come as urgent motion.
Urgent motion tomorrow.
64, huh?
May I be
64 tomorrow urgent motion.
Grateful.
May I be permitted to mention, my lord, one matter, my lord. I am covered by your lordship's order, my lord. That order was passed on 13th of November, my lord, in my matter. Identical matter, my lord. The bills are not paying by the respondent authority, my lord. Let it be, my lord, appear.
Who is not paying?
My lord, respondent authority, my lord. We have completed the work within the stipulated period, but bills are not paying.
There is no urgency. Yes.
My lordship, consider this, my lord.
Here, my lord, item number 300.
Let one, yes. Yes.
This item number 322, my lord. Tender was floated for maintaining a park for 5 years. But my lord, while giving the work order, they had given me the time only for 3 years. I'll be seeking for the extension of the remaining 2 years. The 3 years is expiring on 11th December 2025. That is the urgency, my lord. My prayer will be that it should be extended for the more 2 years, being the tender. 322, my lord.
320.
22.
It may be 322.
22.
Let it be fixed on 8th as urgent motion.
Deep loose.
Yesterday, my lord, one blocking of each along case has been disposed of. One matter is remaining. That will be fixed on 5/12 as to be mentioned. I shall serve notice, my lord.
Please,
Permit to mention the matter.
5 तारीख को रख दो. 5 तारीख को urgent
As to
motion.
be
may I?
Restoration you give. Restoration and new motion you give all the
For non-prosecution,
give to my
My
court
lord, new motion for listing, my lord. For listing.
my lord, may
There
I?
is some urgency.
new motion and
lord,
application.
There is some urgency in the matter, however, my lord.
To my court office.
There is some urgency also in my matter, my lord.
Which one?
It is not listed. 26440 of 2025. My lord, my company has been debarred from participating in all tenders by DVC, my lord, without following the policy of DVC for debarment. And my lord, I am covered by this Honorable Supreme Court judgment saying that, my lord, if there is a contractual dispute, then the party cannot be debarred from participating in tenders. Now, my lord, the difficulties I found out about the debarment only recently when my bid was rejected for another tender. And now, my lord, many tenders are upcoming for which my bids are already pending. So, my lord, therefore, there is some urgency in the matter, my lord, because otherwise, if several tenders I'll be rejected in.
Which number you are
26440, writ petition 26440.
It is listed.
No, my lord, it is not even listed. My lord, I
What you
filed
filed?
11th of. But it was supposed to come up on 28th, filed on 14th of November. I found out about the debarment on 28th of October. So, my lord, within 2 weeks, we have filed the petition, but my lord, not listed. It was, my lord, the case status showed it will be listed on 28th of November, but did not get listed.
Okay, now where is your list?
My lord, 26440. Ekkuni dilam. Writ petition 26.
Give the slip.
But I have just handed up the slip 26440. Type আছে ওখানে আছে
Looking at
यही बराबर
उसको no 10 December में urgent motion में करो.
so grateful my lord, so grateful.
Lords, may I mention item 269 of today's causeless, my lord? Lords, your lordships are scheduled to pass a judgment challenge on the writs challenging the revocation of West Bengal incentive schemes and obligations in the nature of Grants and Incentives Act somewhere around 14th or 15th of December, my lord. My lord, my urgency and predicament is twofold. Firstly, that my SLP is pending on the 16th of December this year. Secondly, my lord, no notices have been issued in my matter ever since the filing. So I'm only praying that your lordships may kindly list it under the urgent motion hearing so that at least notices may be issued before your lordships passes a judgment.
What notice is required to be issued?
I'm sorry, my lord.
What notice is required to be
Notice the
what
state-
order is to be passed for what notice? If you file the writ petition, you send the notice to the other side, file the affidavit of service on the written.
That has been filed, my lord.
But
Everything
where is the requirement of passing an order for issuance of notice under the 226?
Calling for a reply, my lord. I'm only saying to
Calling
the
for the
extent of
reply,
calling for a
unless
reply.
the matter will be
How-
listed, the party will appear, party will ask for the time, then only
Very well. In that event, my lord, I'm just praying that the matter may be listed under the urgent motion heading.
What is the urgency? Tell me.
Because I was benefiting under the 2008 schemes.
Correct.
promulgated by-
all petition will be coming in the next week on.
No, I do not know the exact date. So in that event, I'll just circulate my writ petition number and it may be tagged with those matters.
Yes, that's what I'm telling you
Very
since
well.
yesterday.
Very well. Very well.
Lord, I may
So that will be listed.
Very well. I'm
Lord,
sure.
may mention,
So connected, this application may be placed along with the connected matters.
Lord, may mention item number 66 of today's list, my lord. There's some urgent, 66.
Ah.
There's some urgency, my lord, if your lordship could direct the matter to be listed, my lord, the
What is the urgency?
Lord, stay of the recovery of the money, my lord, by
Huh?
MS. Stay of recovery of the money, my lord.
What money?
It is, my lord, a non-conventional energy, my lord, solar and wind.
Ah.
They, my lord, the order has been passed, my lord, contrary to, my lord,
Ah.
the national policy,
Ah.
which exempts, my lord, the transmission charges.
Hmm.
And here, my lord, in West Bengal, they have exempted 1/4.
Hmm.
They put an artificial limit, my lord, now saying not more than 30%. Whereas, my lord, the national policy requires, my lord, minimum of 30%.
Hmm.
There's a complete, my lord, opposition to the each of the way the people are looking at it, my lord. If it could be taken up, my lord, anytime.
Who is for the other side?
Advocate General is appearing in that. We give a notice, my lord.
It is already there in the adjourn motion. So what is the urgency?
The urgency-
Matter will be taken, it will be decided whether 30% or 80%, whatever it may be as per your
Lord,
requirement.
in the meantime, my lord, they should not enforce the recovery, my lord. That's a difficulty.
When the notice was issued for recovery?
No, my lord, they have not yet issued the
They have not
notice.
yet
for-
issued the
not
recovery
yet issued.
notice. Okay, if the notice.
They are raising the bills, my lord, anytime they can.
Okay, if they issue the notice of recovery, come, I will hear.
May I leave to mention item number 171 of this
Lord, could your lordship, I'm sorry, my lord, could your lordship fix up a date, my lord, for this hearing, my lord?
Sir, unless until it is an adjourn motion.
Yes.
Let you take the chance because next week I think the adjourn motion will come up. Let us
Yes.
see.
My lord, 171, my lord, your lordship was pleased to hear the matter, and it was when it was about to be disposed of, it appears that stamp duty was deficited. My lord, your lordship was kind enough to direct that the matter is appearing today.
Hmm.
My lord, if your lordship, my lord, kindly give some precedent or
Which one?
171, my lord. Hearing was concluded, the matter is covered by the judgment of.
Have you paid the court fee? Have you paid the
my
court
lord,
fee?
it appears that the court fee was proper.
Court
Yes,
fine.
my lord, on last.
11 तारीख को रखो उसको अर्जेंट मोशन में. Yes.
Item number 19, by mistake, it was fixed on 27th of December. That was a Saturday and holiday. Yesterday it was 22 item, but after 21, original side matter was taken by my lord. So by mistake it was 27/12/2012. So tomorrow while it can be given tomorrow.
27/12.
12/12. That's a holiday.
Wrongly.
By mistake that is.
So what date it was given actual?
No, get ready. It was running in the day. By mistake, maybe I don't know why. 19.
What is the number? 19?
19.
19.
Yesterday it was on item 22.
19.
19.
Acha, 27. So how it has come? See the file? What order is there? What date is there in the file? Okay, I will see. I will recall. I will see then.
Another matter, my lord, it was 80 years old. His bank account has been freezed by the Punjab National Bank on the ground that he is a resident of Katua. Somebody impersonating him took loan from Siliguri, and his bank account in Katua has been freezed. And it was filed in 2023. It is under the motion stay. No hearing, no affidavit or this.
Not yet listed.
No, not yet
Not
listed.
yet.
No.
Put in the new motion.
Lordship,
May I be permitted to mention one matter, my lord? Lordship had directed the matter to appear on 6th of November, but till date it's not appearing, my lord. The agency is, my lord, the earnest money deposit will be forfeited and the penal action will be taken against the petition.
Why? Which number? Why it is not listed? 6th November?
Was taken up by my lord.
ये पास 6th नवंबर में क्यों नहीं आया? फाइल देखो.
5 of September.
इसको रखो. 10 तारीख को रखो.
My lord, may I be permitted to mention this matter? My lord, I have earlier mentioned this matter on 6th of November when my lord was pleased to direct my lord's officers to list this matter on the next Friday, that is on 14th of November. Thereafter, my lord, the matter has not come on the list, my lord. There is a grave urgency. It's a new motion matter, but just after filing, I mentioned
Has
it.
come.
My lord, everything is here, my lord.
Why you not listing?
My lord, it is not yet listed. I'm praying for inclusion only, my lord. New motion matter. Another matter, my lord.
It is new motion, urgent motion.
New motion matter, my lord.
New motion. Put the new motion.
I just praying for listing of the matter.
Put it in the new motion.
My lord, another matter, my lord. This matter is like quite similar to the other matter which my learned senior friend was mentioning, my lord. Bank account of a senior citizen has been freezed by the SEBI recovery officer pertaining to a case. My lord, in this connection, my lord, I have tried to serve notice yesterday to the learned advocate appearing for Union of India, who is Mr. Amit Sharma, but he is unreachable over call, my lord. I am praying for listing this matter. Thereafter, today I will again serve notice to him.
One thing, उसको 11 तारीख को रखो, urgent motion.
New motion, my lord.
Urgent motion में करो.
May I have your lordship's kind leave to mention one matter, your lordship, I mentioning.
Yes.
Like, your lordship, because the biological father will not be this lordship. The earlier officials also, the passport has been released, no such demand has been given, but this is a new.
So what you will do with the passport now? Naina?
Going for her higher.
So up till which date your passport is valid? So now when you applied for renewal or extension? There is any denial?
না
So what you want?
স্যারকে দেবেন একটু আমি বলবো জাজমেন্ট দিখাতে হবে
Your writ petition is filed. Where it? Which number? Not been included.
My lord, may I be permitted to mention
11 तारीख को करो. Urgent motion.
Lordship.
My lord, may I be permitted to mention one matter, my lord? This is below pertains to the circuit bench of Jalpaiguri. The urgency being, my lord, that this is a matter of national importance and defense preparedness. And my lord, as per the 2000 notification, all mining crushing plants were forbidden to be planted in the Mahananda Wildlife Sanctuary. However, my lord, because this project was Sivok Rangpo project of national importance, therefore this particular plant was allowed. In 2025, however, my lord, an NGT case was filed, and thereafter the some licenses were stopped.
So what you want now?
My lord, the matter has already been heard, my lord, and the directions has been passed as per the circuit bench over there, my lord. That my lord, I'll show I've got the order also. But after the holidays, my lord, we have not been able to get the matter listed, and my lord, the plant is closed, and it is even the IRCON's letter from the Ministry of Railways there that the project is also being affected. Still, the matter could not be heard over there. And my lord,
my lord, I am opposing the request, my lord. They have mentioned it before successive circuit benches at Jalpaiguri, and they have not been able to get the matter
my lord,
listed
he is
because
an
my lord,
intervener, and my lord,
the order says my application
my
be
lord,
heard
the order,
first.
no, my lord,
The government
the
agency
order
is saying
says
that
he
they are
has
able
no right.
because it is in violation of the Supreme
It is
Court's
not
order,
right,
the
my lord,
environment
we
matter.
are being protected by the Supreme Court.
So my
All
lord, one
that
second.
let me complete.
One
Let me
second.
complete first.
Let.
My lord, I just want.
Next week the circuit bench will be
Yes,
there.
15 December.
My lord, 15 December. And
Correct. 15 December. Only 1 week.
My lord, all that I'm asking.
So what is the urgency?
My lord, the urgency is that from last 2 months, my lord, during the holidays also, the plant is closed, my lord.
Government is getting it from elsewhere.
My
They are
lord, government is
unnecessarily
not.
raising.
Yes.
Government is
Lordship, may I be permitted to mention, Miller?
November, lordship.
Ah.
But on that day the matter did not appear. Now it is appearing as item number 205 in the monthly list. Lordship, there was on the last day your lordship directed that you will direct for affidavits. Lordship, kindly update this matter. And lordship,
What is the urgency?
Urgency is that the respondent number 2 is not getting the compensation amount. Lordship,
What compensation?
Yes, lordship, her mother died. in the R.N. Tagore Hospital, and there was a direction for direction by the West Bengal Clinical Establishment to pay rupees 5 lakhs to the respondent number 2, the daughter of the deceased person. Lordship, the order was passed in the year 2023, but still now she is not getting the compensation amount, Lordship.
Motion, Madam.
Lordship, kindly.
May I be permitted to mention, my lord? May I be permitted to mention, my lord, item number, my lord, T73, my lord. T73 under heading fraud hearing, my lord. This is the matter, my lord, which is claim about the LIC policy. Fraud has been committed by the staff employee of the LIC policy. That is the settled principle set by the Honorable 3 judges bench of the Supreme Court, Honorable Justice Nageshwar Rao, Honorable Justice B.R. Gabay, and
This court did want the name of the judges. Tell what is your
urgency is that, my lord, matter is pending since 2019, my lord. Affidavit already has been exchanged.
What is the new now you wanted to 2019,
Lordship,
2025 you have slept.
Lordship, several occasion, my lord, I request my learned friend to appear and about, there is the about disposal matter, my lord, yet to be disposal. My lord, she is avoiding, my lord. Kindly fix the matter, my lord. 8 January, my lord, he is convicted after
Let
vacation.
the matter appear after 26 January. Take. Let the matter appear in the combined monthly list of February 2026.
Lordship,
If you are dictating the court, which date is the court has to be fixed?
Lordship, no, my lord. It is.
So it is the way to submit the before this court for
Lordship,
mentioning.
Lordship.
This date may be fixed. This date may be fixed.
Lordship, it is my
You come here and sit here.
Request-
Give the date.
request made by the learned advocate of the LIC, my lord.
Yes.
My lord, kindly, my lord, pardon me, my lord.
February 2026.
May I permit, but the petitioners has been declined at electric connection for so many years. And the case was serial number 134. Kindly, my lord, taken by urgent.
Madam, it is all the thing be taken in urgent motion. Why when the new motion will be taken? Henceforth, I will not list any urgent motion. All the new motion, if chance will come, and I will hear the matter. No, yes.
Lordship,
You already argued, yes.
Lordship, I am paying for application for one.
No application, yes.
Your Lordship, you have heard the matter on 19th last month, and the returnable date is on 3rd 12th. So, mentioning for listing the matter on 3rd December. You have already.
3rd December is tomorrow.
Yes.
Lordship,
Obligement.
Adjourn motion, madam.
Obligement.
3 matters for inclusion in the list. The banks are offered the loan application. They have not taken a.
It is not in the list. New motion, madam.
My lord, I am taking for inclusion in the new motion. My lord, the petition.
Give new motion. You need not to submit. Yes, sir.
Notice to the other side, I was mentioning item number 124 of the day's list.
Yes.
My lord, I am the landlord. I stay in the house with my octogenarian mother, 124.
Yes.
I stay in my house with my octogenarian mother and 2 minor daughters and my wife. My lord, the electric meter is located in the tenant's portion, and the tenant is resisting access to the distribution licensee. As a result whereof, my lord, the meter could not be read, the meter cannot be repaired, and the electric connection has been disconnected. My lord, a coordinate bench has sought for a report by the order dated 12th of June 2025. My lord, may it appear as an urgent motion, my lord.
Just the urgent motion.
My lord, may I be permitted to mention, my lord? My lord, item number 342 of this.
No upgradation. Only urgency.
My lord, kindly. My lord, award was passed by the National Lok Adalat. Only spelling mistake of the, my lord, awardee, my lord. My lord, amount.
Go to Lok Adalat, not this court.
My lord, may I be.
Cannot go to the Lok Adalat. Next Lok Adalat, you mention before the SLS, then they will take the matter in the. I will not. If other court is interfering. When the Lok Adalat pass an order, that cannot be corrected by the sitting in the writ court.
May I be permitted to mention one? Lordship, it is a new motion matter. Never. It was the date was 27th, but never come. But the urgency is this: I was selected in a recruitment process, but the recruitment process has been cancelled, and a new advertisement has been given, and the 8th is the last date for applying. Is
So what is your?
I don't want to apply for the new recruitment process. I was already got a chance to be selected in the old recruitment process.
That is cancelled.
We have we have filed a writ petition to challenging that cancellation only. That is.
May I be
Deeply obliged.
Malad, may I be permitted to mention, Milord, it's a tender matter, Milord.
Mr. Default,
Malad, may I be permitted to mention, WBSEDCL has come up with a requirement that to participate in a bid, Milord, I have to submit a declaration that there is no litigation pending against WBSEDCL, Milord. I have been carrying out contracts for WBCDS for last 25 years, Milord. I have challenged the office order, Milord. The bid starts from day after tomorrow, Milord.
What is your challenge? What you prayed for?
Well, I have prayed for, Milord, quashing of the office order, Milord, which mandated the submission of the affidavit that there is no claim pending against WBSEDCL or there is no litigation, Milord. Now, Milord, my point in the writ petition is, Milord, I am registered under the MSME Act. That office order cannot override the provisions of the MSME Act, Milord, which otherwise entitles me to have a claim against WBSEDCL, Milord. And, Milord, the office order that has been published by them is subsequent to the claim that I had, Milord. So I've challenged that office order, Milord. The bid starts from 4th.
Bid start from 4th. What is the last date of the opening? Opening of the bid.
Malad,
the last date of the submission and opening of the bid.
It is still 26th, Milord. 26th December. Milord, pre-bid meeting is tomorrow, Milord. But the bid starts from the day after tomorrow, Milord. I'm praying, Milord, any day if your lordship can fix it, Milord.
Not this week. Come on, 11th.
May I be lordship's kind leave to mention a matter, my lord. This is a fresh filing, my lord, new filing. It has not appeared, and there is some urgency, my lord. The urgency is, my lord, my electric connection has been disconnected.
Haven't you? So many 2000 electric connection disconnected. That is
Your lordship, may I be permitted to mention for inclusion as extension of interim order, your lordship? Extension of
when the interim order is to be extra?
12th of December, your lord.
12th of December. So 11th ko so fix karo to be mentioned for extension.
May I be lordship item number 281 of your lordship's list, my lord. And earlier your lordship had directed to appear as motion, my lord. However, for some reasons it did not appear, my lord. But my lord, in this matter, my lord, the urgency is, my lord.
21 is there. So what is the urgency?
281. 281. So my lord, the urgency in this matter is, my lord. I am the father of an unfortunate child. My lord, because of the medical negligence of the doctors, my lord, she has lost her hearing capability. Now, my lord, I had approached the medical council. The medical council has directed me to treat it with their doctors, with their designated doctors, instead of giving me compensation, my lord. Now, my lord, on that reason, my lord, no doctors are treating my daughter. So, my lord, that is the urgency, my lord. I have challenged that order, my lord.
What your daughter is suffering from?
My daughter is suffering from hearing incapability, my lord. Hearing incapability.
So, no.
My lord, she went through a BERA test, my lord. That BERA test was wrongly done. That is, and on
so what do you want from this court now?
I for washing of that order, because my lord, medical council has asked me to treat doctors of their own, the doctors that they suggest. Medical council has passed an absurd order of saying that you will be getting treated with the doctors that medical council suggests, and not the doctor of my choice, man. And has denied compensation to me. No doctors are treating my daughter.
Deny compensation, that will be decided. What is the urgency on that?
My lord, the doctors that of their own choice, my lord, how will I trust the doctors of the medical council's choice?
15 तारीख को रखो उसको.
May I be permitted to?
What has happened in this position? Punjab National Bank is not releasing the funds which they have been directed by the coordinate bench on numerous occasions. Last payment direction.
Why the banks will release the amount?
Actually, the father of my husband was the owner of the account holder. Thereafter, he passed away back in 2000.
Correct.
Thereafter, my husband had applied for releasing of the funds.
Your husband?
The husband was the simple
Illegal here.
Yeah. After what happened, my lord, they filed a title.
Who filed?
There are other things.
Correct. Bank has filed the civil suit.
So what happened? That particular what business was involved. After we honorable asking for that is lying there. Thereafter, my lord,
What dispute they are raising?
they are not raising any disputes. They are right now making turns with regard to different documents that are to be submitted. Last week, we were asked to submit documents with regard to the Aadhaar card of an individual passed away back in 2000.
So what do you want now? What is the urgency? Yes.
My lord,
May I be permitted to mention, my lord?
On earlier occasion, my lord, your lordship directed me in this matter, this urgent matter, to serve a notice upon the WBSCDCL to take up the matter as urgent. This is regarding the installation of a transformer. Already money paid, some parts of
Yes,
the...
yes, what you want now?
Yes.
What you want?
I want that immediate installation of transformer.
16 को रखो urgent motion 16 urgent motion
My lord, this the matter, my lord, we are participating and we are trying to deliver the product, but this one has cancelled the purchase order and issued the recovery advice, and they had already taken some amount from another tender, my lord.
so there is no arbitration clause. You sure? Check it. If there is an arbitration clause, how the writ petition? How? You first you check. If you find the arbitration and you mention, then you will be in difficulty.
My lord, may I be permitted to mention?
New motion, my lord.
May I be permitted to
Yes.
mention, my lord?
The client mentions, my lord, this matter is appearing as item 371 in today's list. My lord, the urgency being, my lord, the petitioner has been called for a proceeding, which is after 27 years.
What proceeding?
My lord, before the Deputy Director of Foreign Trade, my lord, we had obtained advanced license for exemption in 1998. Thereafter, show cause notices were served upon us in 2006. We were not provided documents. We came to High Court, Honorable High Court had directed them that you give them opportunity and issue fresh show causes. That was in 2006, my lord. In 2025,
So now what you want?
2025, my lord, they have issued fresh show causes without documents and they have called us for hearing on 10th, my lord, and they are inclined to pass an order. Your lordship, this is appearing at 371.
And the court will do. Notice has been issued. Go and appear before the authority. If they will pass any order against you, challenge that.
My lord, this is absolutely beyond jurisdiction. The authority who had issued, my lord, he is being the judge of his own cause. And my lord, he is only the adjudicating authority. And I have asked for documents.
Adjudicating authority will only issue the notice for hearing. Who will issue the notice for hearing? Adjudication is to be taken place after the hearing the parties only. So that's why notice is given to you. Go and appear.
And my lord, without providing necessary documents, my lord, nothing has been provided.
Okay. If any adverse order is passed, you challenge that in terms of the law.
Yes, Lordship. The matter was mentioned by my senior on 11th of November. It was supposed to appear under the heading urgent motion on 18th. Notice was served. It didn't appear, so I mentioned again on 27th. It is appearing at monthly list number 299 and today's list 317, but under new motion, not under urgent.
What is the urgency?
It is a doctor. The petitioner is a doctor.
New motion में रखो.
May I?
My lord, for inclusion of a hearing.
New motion.
It is appearing under the heading new motion. It was supposed to appear under the heading urgent motion, but it is appearing under the
Yes. Mentioning under upon notice, my lord, for inclusion of a hearing, the petitioner had a set of antique collections, which was, my lord, seized by the authorities without following the due process of law. No notice, nothing, my lord. Now, my lord, since 2023, they have kept the antiques in a very bad condition. Day by day, they are deteriorating, my lord. If my lord doesn't dispose it of, my lord, I will say irreparable loss. If my lord may be kind enough to include the matter and hear it out.
So what order you want from this court?
Release of the antiques, my lord.
Huh?
Because the antiques are mine. They have been seized without following the due
Who has
process.
seized? Archaeological?
My lord, archaeological are part of their department. On the pretext that they want to use those antiques in a museum collection. Without any notice, nothing. No consent from me taken.
Under what provision they have taken seized your article?
They have not issued any notice, my lord. They have just come to my house with a group of
16 December को रखो urgent motion.
May I mention one matter?
Yes, call.
My lord, may I just mention this matter, my lord? My lord, I've been waiting. My lord will kindly consider, my lord. My lord, this.
Yes, call the.
My lord will kindly. দাঁড়িয়ে রয়েছি ডাক্তার
On the ground, my lord, the matter is related to my lord, national local, the matter.
Item number 1 for judgment. CRR is dismissed. Yes, next. Item number 4.
My lord.
Yes.
4 and 5.
4 and 5, my lord, I am
Madam.
appearing on behalf of the respondents.
Yes.
My lord, I appear for the
Complete. So I will be beseeching your lordship kindly fix a date. My
Who
lord,
is for the petitioner?
My lord, I am for the petition. My lord, today I am physically not
We are
well.
requesting-
Only thing, my lord, the interim order has expired on
I will not extend the interim order.
My lord,
If you
30th
are ready to argue the matter, I will take the argument on merit. I will not extend the interim order. This is not the way mentioning the matter and taking time.
No, no.
The other persons are
don't
debarring
my lord,
mentioning the matter.
don't misunderstand me, my lord. I'm saying
There is question of no misunderstanding will not there. Already interim order is till end of November. That is over. I am not extending any
your lordship
interim order.
kindly see why. Kindly allow me, my lord. My lord, at least 400 to 500 people are there.
Yes, I am giving the
No, no.
4 weeks time.
Your
Though the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner prays for extension of the interim order. This court finds that by an order dated 15th of September 2025, the interim order was extended till the end of November 2025 or until further order, whichever is earlier. Now we are on 2nd of December 2025. By the end of November 2025, none has moved the petition for extension of the interim order. Full stop. Today, when the court has requested the learned counsel for the petitioner to argue the matter on merit, but he fails to argue the matter on merit and prays for 4 weeks time. Accordingly, interim order is not extended. Let the matter appear in the combined monthly list of January 2026.
Kindly appreciate one thing.
Next, call.
My lord, one prayer I can make, my lord, subject to correction. My lord, it is a long pending matter. So if
That's why I put the
no,
other
I'm
one.
grateful.
No, who are you?
My lord, I am
Petitioner is not interested to proceed. Then why you are putting the shoulder, taking shoulder of the petitioner?
very well. I understand. I
Next
understand.
call.
My lord, your lordship will kindly listen to me. 4 and 5 are together. Kindly listen to me. It was appearing before my lord Justice Parthasarathi strategy, my lord, because of non-availability break of bench, my lord, it could not be heard. It was appearing all along.
Yes, next.
But the bench was not available.
Who is for the petitioner?
6 minutes, I appear for the petitioner.
This court, the practice will not do. If you mention the matter, you have to argue the matter. The mentioning and adjournment, that is, it is a last court. That you yes.
I shall argue. Your lordship kindly grant me some time.
Sorry. I already granted. Let it come in the month of January 2026.
No. Only thing, my lord, in the event, my lord, then there no coercive steps be taken.
No, sorry.
Kindly protect to that effect.
No.
Then, my lord, what will remain if they are thrown out of the
So
court?
you have to think. You are for the petition. You have to think. Your interim order is going to already expired in November. You are not mentioned today. You have mentioned the court is ready to argue, hear you, but you are not ready to argue the matter.
As my lord is saying that on November 30th.
Yes. What is the matter, Mr. Bose?
My lord, it was mentioned on 27th of November before my lord.
Yes. Okay. I pass the order. You go. Yes.
My lord, may I proceed with the main writ, my lord? There is a restoration application as well, my lord. It was dismissed for default because of our fault. May I proceed with the writ petition, my lord? That's a formal application.
I am appearing for the West Bengal Pollution Control Board led by Mr. Bihani.
So
I'll tell you, lordship, my lord. I'll tell you, lordship.
I'd be praying for some accommodation, my lord. It has come up for restoration.
This is, my lord, the West Bengal Chemical Limited. My lord, this originally the company was Paul Lohman India Limited. Well, this was taken over by the government of India under the Industries Development and Regulation Act 1951. Well, thereafter, well, under the Acquisition Act, well, kindly come to once page 43. Well, this is where it starts.
But other side is not ready, Mr.
My lord.
Probably I'm not the answering respondent as well.
Well, basically, my lord, it is the state and the my lord, Asansol Durgapur development. I'll just briefly tell you, lordship, my lord, it will come. My lord. Now, my lord, what had happened is government of West Bengal, my lord, took over the company. After government of West Bengal took over the company, my lord, this is a company which is in the manufacturing of life-saving drugs. It's a unique company, and in the state of West Bengal, this is the only company which is engaged in the business of manufacturing of life-saving drugs, and there are certain patents, as your lordship knows, in manufacturing of medicine, patents are there. There are certain exclusive patents which is only attached to this company. Government could not run it. So government entered into a joint venture. Well, under this joint venture, 89% of the shareholding of the company was transferred to a group of companies known as strategic partners. So now we have been running it. So my lord, we turned it around, and thereafter the company successfully started making profits. Now my lord, the issue is not there. My lord, the issue is the original manufacturing unit of the company all along was in Lake Town. Now Lake Town is, my lord, on way to airport on the left hand side. My lord, when the company was operating in the 50s and 60s, Lake Town was technically an industrial area. Over the years, Lake Town has become a residential area, and Calcutta and greater Calcutta has expanded. Now, my lord, at that point of time, in 1965, I stand corrected, in 2004-2005, government allotted 8 acres of land in Asansol for the purpose of setting up Durgapur, my lord, for the purpose of setting up an expanded, more technically advanced unit. In the meantime, Lake Town became a residential area, so the pollution issues came. So Pollution Control Board said that I am giving you the consent to establish so far as your Asansol unit is concerned, and I am giving you limited permission to continue with the business. You have to shift. So my lord, I have shifted 60% of the business to Gujarat, where from Gujarat I am manufacturing several of the patented drugs from there. Now, for so far as the land in Asansol is concerned, 8 acres given to the company. Now, my lord, 8 acres of land, we want to shift the Lake Town unit and keep it at minimal stake so that there is no pollution, and shift it to Asansol. Now, this is the issue. For the last several years, nobody is doing anything for the purpose of, my lord, there are certain permission and approvals which are required to be given by certain departments of the state of West Bengal and the Asansol Development Durgapur Authority. My lord, innumerable letters written, no response. This is the situation. This would be not only for the benefit of the state, this industrial development, but for the people at large. This will going to generate thousands of employment as well, apart from the fact that we are engaged in manufacturing of life-saving drugs.
Yes.
So this is not like an adversarial litigation. I am challenging any particular order. Nothing has been done for years together.
So the main is the pollution control and the state.
No, pollution control is taken care of. Pollution control is given me. Now I want to shift to Asansol, but I am not been able to shift unless they give me the approval and permission.
Who will give?
One is ADDA, Asansol Durgapur. So
that they will go to set up there.
I have already started setting up. I've already applied for permission. I have done everything. So they have to give me the permission to start construction of my factory.
Correct.
So Pollution Control Board has already given me the consent to establish.
So one ADA, then another is?
Another is the state government, the effective department of the state government.
Who will give the permission for shifting here from here to Asansol?
No. Shifting here I will shift the manufacturing. Here from here I will do the marketing, administrative, other work, so that the pollution doesn't happen. If your lordship will see the array of parties.
That's why. Respondent number 2 and 4.
But effectively, it will be the respondent number 3.
No, prayer A is the 2 and 4. Permission for occur to the respondent number 2 and 4. 2 and 4. All 2 and 4.
Yes.
All 2 and 4. You come to the prayer portion. 3 is not there.
Well, at page 37 are my prayers.
Yes, 37 prayers. All 2 and 4.
May I just say this, my lord? Your lordship can consider my restoration application since they are in difficulty, and my lord, direct the respondents to take effective instructions, or because if this closes, so I have to leave the state of West Bengal. So this is not going to benefit the state. So I am effectively a state undertaking. So this is for the benefit.
Why you not appeared on date fix?
Purely a lawyer's fault. But I was on legs and he was sick.
The petitioner has filed the present application being Can 1 of 2025, praying for recalling of the order dated 19th September 2025, wherein this court has dismissed the writ petition for default for non-appearance of the petitioner at the time of court. Counsel for the petitioner that at the time of call when the learned submit that when the matter was default from the petitioner, the learned advocate appearing for the petitioner was unlike before. The court from the time of the advocate reached this court, the matter is already, this court has already passed an order for dismissal. Accordingly, immediately on 24th of September 2020, the petitioner has filed the present application for the the learned counsel for the parties for the application. This court find that sufficient cause has been shown for non-appearance of the petitioner on the date fixed. Accordingly, the order dated 19 September 2025 is recalled. WPA 20938 of 2024 is restored in its original file. Full stop. You are appearing for?
For the West Bengal Pollution Control Board. For the Pollution Control Board, Your Lordship.
But yes, learned counsel appearing. Only the learned counsel appearing for the respondent number 7 is present.
Service.
But in spite of service of notice, none appears on behalf of the other respondents. This court find that a report is required to be filed by the state respondent as well as the Asansol Durgapur Development Authority. According, the petitioner is directed to convey and inform the next date of hearing to the respondents, and the respondents number 2 and 4 are directed to file report by way of an affidavit. Why in the instant matter within 10 days from the date of receipt of the notice, list the matter on 16th December under the heading urgent motion can dispose of.
Grateful.
Grateful.
I'm appearing for response numbers 4 and 5.
Yes.
And for the petitioner,
For restoration.
beg to be excused, my lord, on the last occasion when the determination was changed on 3rd. My lord, the matter was mentioned, but your lordship was pleased to direct to come out 3rd.
Record.
On
the
4th, it has
petitioner has filed the present application being Can 1 of 2025, praying for recalling of the order dated 4th November 2025, wherein this court has dismissed the writ petition for default on the ground of non-appearance of the petitioner on call. At the learned counsel for the petitioner, for the application, the court find that the petitioner has shown sufficient cause for non-appearance of the petitioner before this court when the matter is called. Accordingly, order dated 4th November 2025 is recalled.
Any preferential
WPA number 1416 of 2025 is restored in its original file. Can number 20 will be disposed of. Yes.
Lord, any preferential date.
What is the matter?
Matter is that it is practically the cyber crime. The petitioner entire money has been hacked from the bank, and that has been detected. Yeah, one person has been arrested.
My lord, may I just indicate one thing?
The WPA be placed in under the heading urgent motion. Urgent motion on 17th.
Urgent motion, it was appearing.
17th.
My lord, apart from 17th, if first and foremost I'm in difficulty on 17th, any other day subject to your lordship's convenience.
24th, I will be not in Calcutta. From 18th to 24th, I will be not in Calcutta.
Okay, I am 15th December.
Grateful. Apart from that, I have already taken instruction from Banking Ombudsman, because this is a peculiar circumstances where under the Banking Ombudsman scheme, although a personal hearing was afforded, but because the petitioner is an old person, he's 95 years old, and he did not participate naturally. I have requested my client to take a compassionate view of the circumstances, and if so, some relative of his could represent him, then probably the matter could be resolved, because already 70% of the entire amount pursuant to the intervention of banking ombudsman has been disbursed by the bank to the petitioner. The petitioner is aggrieved by those 30%. He is claiming that he is entitled to get 100% reimbursed because of the transaction. So if this could be worked out, there is a high possibility of the matter could be getting worked out. So if your lordship kindly keeps it as per your lordship's convenience on a particular time, then I'll come back with instruction and it could be resolved on that date itself.
Okay, it's a urgent motion on 15th.
On that 15th, on that
day it will be made. In the meantime, you inform your client to give any power of attorney or authorize any persons to meet the ombudsman.
Yes, I think that will shorten the process.
Record an order. The pending writ petition, comma, the petitioner shall be at liberty either to approach herself or with
through his close relative. Lawyers are not allowed under the scheme, so close relative. Yes.
Or power of attorney holder before the ombudsman for settle the issue.
Grateful, Judge.
My lord, in the meantime, no statement, no account should be maintained and
nothing. Yes, they are wanting to settle they want to settle the matter. You advise your client.
Bank has admitted to the 70%.
Okay, with regard 30% you send to your client to the ombudsman. Let what the decision they will take. Then we'll see that I am not disposing of your writ petition. Let come on 15.
The matter would be appearing on
15 as urgent motion.
As you know.
Ombudsman, OMB. ठीक है?
My lord, it is my petition for the restoration, my lord.
Your lordship, I'm for the state.
Yes. Why you persons are not appearing and every day the court has to deal with the restoration application?
My lord,
what is the matter about?
This is the securitization matter, my lord.
Securitization, why here? This court find that the writ petition is connected with the SURFACE Act. Accordingly, the WPA number, accordingly, CAN number 1 of 2025 is released from the list of this court with the liberty to the petitioner to mention before the appropriate court having determination.
Much obliged.
Yes, next.
Nine, I am for the petition.
9, I am appearing for the respondent 4.
Matter relates to disconnection of electricity. My lord,
to be dismissed. Only application will go.
Yes, my lord.
Okay,
But
application.
when I was coming from court, yes, Lord. My lord, when I was coming from my chamber, no one was engaged during hearing. Lord, that is the reason for default. But actually, my chamber is little bit of distance from the High Court, Delta House. So I was blocked by the traffic signal, and that is the reason actually.
I am appearing for the respondent number 4, my lord, private respondent.
The petition has filed the present application, being CAN 1 of 2025, praying for recalling of the order dated 18th September 2025, wherein this court has dismissed the writ petition for default on the ground of non-appearance of the petitioner at the time of call. Counsel for the petition submitted the petitioner was on the way to reach court, but due to the heavy traffic, the petitioner could not reach the court. Accordingly, the matter was called in the meantime, and the court has passed an order for dismissal. At the land counsel for the parties peruse the application, this court finds that sufficient cause has been shown for non-appearance of the petitioner on call at the time of hearing. Accordingly, order dated 18 September 2025 is recalled. WPA number 22059 of 2025 is restored in its original file. Can so disposed of. What is the matter?
Well, the matter relates to disconnection of electricity bill. Well, actually, the dispute between landlord and tenant. But the electric line, but the CSC will have disconnected my line.
Let the matter appear on 18th of December 2025 under the heading adjourn motion. Petition is directed to inform the next date of hearing to the respondents and to file affidavit of service on the returnable date.
My lord, the only predicament is that the tenant herein has not installed his own meter. There's a sub meter.
That's why I am not passing any
Well,
order. Let all the party come, then we'll see.
Grateful,
Yes.
Lordship.
Next.
My lord, in item number 10 and 11, my lord, Miss Afrin Begum is appearing in this matter. My lord, kindly grant a short passover for 10 minutes, my lord. She is before her legs in court number 8, my lord.
Once you persons are not having the time to appear before the court, why you are mentioning and getting the matter
My lord,
listed?
my lord, kindly,
Depriving the other advocates.
my lord, kindly grant a short passover, my lord.
Passover. Yes. Any problem?
My lord, actually, your lordship on the last occasion wanted me to take instruction. This is a case of Rohingyas who are illegally residing in India, detained, prosecuted, and after the expiry of the term of prosecution or sentence, they are now coming before your lordship for an order in the prayer is misconceived and malified for staying in India at Delhi Rohingyas camp, which is contrary to the order passed by the criminal court, number one. Number two, FRRO is a necessary party. They have not been added as party here. Therefore, this is absolutely misconceived. No fresh cause of action. After the criminal court judgment, there are two orders. One is conviction. Subsequently, they wanted to modify that. That was rejected. No representation is made to the government of India, Home Ministry. This is a misconceived and malified application.
Yes. I have taken note of the objection of the respondents.
My lord, I will pass this.
Take note.
Have you taken the objection? What the senior advocate stated? You are not having the brief.
My lord, I have the brief.
You take note of the argument of Bennett ASG.
Today you are having problem. Passover.
Today I have got so many matters. Keep it
That's why I'm
tomorrow.
asking you. Why?
Kindly keep it tomorrow.
Not today.
My lord.
As per the Leonard ASG appearing for the Union of India has raised the question of maintainability of the present date application. Leonard counsel for the petitioner prays for accommodation. According cases adjourned, let the matter appear tomorrow under the same heading.
Yes, 10 and 11
10,
both.
11.
Both are
Your Lordship, I'm for the respondent and I pray before Your Lordship for a short Passover, but right now just he's on his legs, my counsel.
Who is for the petitioner?
So
let me hear.
with your permission, can I call him? Thank you so much. I mean, I'm grateful, Your Lordship.
My lord, this is with respect to a scheme which is floated, my lord, by the respondent number 2, who is, my lord, the Eastern Coalfields. Now, my lord, what happens is they take our land, and in terms of that, my lord, they give us, my lord, employment and then money, my lord, in terms of that. Every 2 acre of land, there is one employee. My lord, there are 4 petitioners before your lordship. Everything, my lord, is over. Even the medical is over, my lord, way back in 2022. One of the persons in this area whose land was also taken, my lord, he has already been given employment. But we 4, my lord, they are not proceeding, my lord, after the fitness certificate has been granted. I won't trouble your lordship. These are admitted facts. I'm sure my learned friend, my lord, would agree with me on that. It's just that they need to finish the process. There's nothing beyond that. The fit for employment, my lord, if your lordship sees, rather, my lord, it's better your lordship first sees the synopsis which is uploaded, my lord, on the website. That your lordship will find at page, my lord, 257 at the second volume. Because the deeds are annexed, my lord, it's become voluminous. It should not have been annexed in my respectful submission, but whatever. That they are land losers, there is no dispute on that. Have a look at 257.
257.
Number 5, yes. He's number 5, my lord. The first one is Kenda.
257.
257. Lord, kindly turns over to 258.
Yes.
Starts from 57. Sees number 5.
Amit Das.
Amit Das. Siddharth Sinha is not the petitioner before your lordship. Turns over, my lord. Uttam Nondi is a petitioner before your lordship.
Uttam Nandi. Yes.
Nandi. Then turns over to Deep Mondol. They are, my lord, petitioners. Their particulars have also been given, my lord, by them, not by us. It's their document. Then kindly turns over, my lord. Police verification is done at 262. Does not, my lord, might not be relevant, but sees 263 that there is no adverse report against me. 263.
Yes.
Then turns over, my lord, to the fitness certificates at 264. Uttam Nondi, Deep Mondol, and then 268 below is Shubhendu Ghosh. There is one fitness certificate we could not annex, but it's also there. This is what the matter is, Miller. I'm sure my learned friend can take instructions and say, Miller, when they are going to finish the entire process and give employment.
In that case, Miller, if that is the prayer of my learned senior friend, I have no difficulty. Or she can either dispose of the petition, directing me to Miller consider their petition as their representation, or Miller, I can come back with instructions.
Let him come back with
instructions. Report.
I will come back with the report.
Affidavit, report by way of short affidavit.
Very well. Only one thing, kindly, I have not, although I should have asked that point at the beginning, there is a maintainability issue. Writ court is not the first forum. There is another tribunal which is the first. Kindly keep that
sorted out.
I know. That is the reason I did not hinder. I just say which instruction coming from the authority. So that I am saying, kindly record.
Find that a report is required to be called for from the respondent number.
The respondent number 2 is the
respondent number 3.
Officer 3.
Chairman come managing director.
Chairman come managing director.
3.
Required report is required to be called from the respondent number 3. Respondent. Accordingly, the respondent number 3 is directed to file report by way of an affidavit after serving the copy to the land council for the petitioner within a period of 2 weeks.
The 2 weeks. So 3
1 week.
It will be vetted by the department.
2 weeks. Exception, if any, be filed within a week thereafter.
Miller, I don't want to file anything. Let me first see, Miller, if they agree.
2 weeks, let the matter appear. Exception should go. 2 weeks, let the matter appear on 16th December.
So great.
Only at one line, Miller, maintainability point is kept open. That's
council for the respondents raise the point of relatively, the same is kept open.
Grateful.
As adjourned. 16 December, adjournment. Affidavit of service filed by the petitioner be kept open. Yeah, 7. Adjourn motion. Okay. Urgent motion. Yes, next.
13, I'm for the petitioner, you lord.
Yes, I'm for the union of India.
I'm handing up.
Capital Limited, we have not received the copy of the petition.
Yes, I'm handing up. May I? I will address that.
Point number 10, my lord. I have also not been served with the entire set of writ petition.
I'll just clarify.
Prayer portion, up to prayer portion, my client has.
I'm handing up the affidavit of service. What has happened is they're quite right. Insofar as respondent numbers 3 to 14 are concerned, only the writ petition without the entire annexures have been served. That's because the writ petition runs into 10 volumes, your lordship. My apologies for that. And there is a reason for that. I was helpless because all my representations to each one of the lenders I have annexed. I had to. And I'll just briefly explain what the matter is. At the outset, they're not wrong. What has happened, your lordship? The petitioner runs a transportation company. Main activity is for export in Bangladesh. For the purposes of this transportation activities, the petitioner has obtained various loans from 14 bank and NBFCs. That is enumerated at para 4 of the writ petition. Now, the petitioner happens to be a registered MSME. Now, because of the turmoil, the political scenario in Bangladesh 2024 onwards, the consignments ran into problem and I started suffering cash flow issues. So even at the incipient stress stage, even much prior to the classification of the accounts as NPA, etc., as per the IRAC and prudential norms, I invoked the framework for rehabilitation and revival of MSME. Under the aegis of RBI, I applied as per the procedure to each one of the lenders that, look, I wish to avail the statutory mechanism for revival and rehabilitation as per the terms of the guidelines. I received no reply. Instead, immediately upon receipt of this representation, they started recalling the loan and start taking coercive actions. Though I must point out, at this point of time, NPA, it has not been classified as NPA. And the SARFAESI proceedings, etc., the consequent proceedings, that has not been initiated. So I'm only at the stage of the availing of the benefits under the MSME framework. Now, Your Lordship, recently, this has been a vexed issue, whether this is a binding regulation, etc., or not. Recently, by 2 decisions, the Honorable Supreme Court has confirmed. Previously, there was a Bombay High Court decision saying that those are directory. They may not be binding. So it is up to the discretion of the lender whether to give you that or not. But very recently, 2 decisions have been passed by the Honorable Supreme Court where they have absolutely clarified that these are binding guidelines. And if at the appropriate stage, much before the securitization, etc., have been invoked, an application is made in accordance with law, then it is mandatory for them to avail me that benefit. May I hand up those 2 decisions?
Serve the copy.
I will serve the copy, Your Lordship. No problem.
At present, what you require?
Only issue is, Your Lordship, only issue is, if in the meantime I have filed the writ petition, let them not take any coercive steps, because I can show prima facie I'm absolutely covered by the Honorable Supreme Court's decision.
What coercive step they will take?
They have already recalled the loan.
Correct.
If they right now initiate 13.2, 13.4, then then this entire writ petition stands to become infructuous. That's the only issue. They are also initiating arbitral proceedings, etc. Yes, certainly I'll serve the copy.
Next week.
Yes, madam.
How soon you will serve? I will keeping the next week. I will hear the matter.
May I just only seek to impress upon Your Lordship that they have already, several of the NBFCs have already initiated arbitral proceedings. That's a separate issue. I'm challenging those initiation, etc., in the appropriate forum. If the banks today mark my account as NPA pending this issue, Your Lordship, then I will be irreparably prejudiced.
NPA cannot be unless an inquiry is to be conducted under the 2017 guidelines.
Correct.
So you will get the benefit of that 2017 guidelines, and that has been covered by the Honorable Supreme Court judgment, Justice Bela Trivedi judgment.
That is exactly what I'm referring to. I have made those representations, Your Lordship. Your Lordship will kindly see.
It is a 3-stage MSME.
Absolutely. SME, that is precisely my cause of action. Your Lordship is referring to the Pronate's decision. Pronate's decision subsequently upheld by another judgment by Justice Dipankar Datta.
Yes.
So I'm completely covered. I have written to them, but they are not following it.
That's why in the meantime, without following that, so you will get the order. No problem.
My cause of action might get altered. Anyway, at the earliest occasion, I'll serve and come back. Your Lordship will kindly keep it. I will serve within 3 days' time, Your Lordship. Early next week, Your Lordship.
Petition is directed to serve the copy of the writ application along with the documents to the respondents by 5th of December 2025. This is the matter on 11th of December under the same heading.
Oh, to everybody. May I indicate, Your Lordship? I'm sorry. That is the postal service I was talking about. Insofar as the email service is concerned, they have been served with the entire 10 volumes, Your Lordship.
My instruction is that, my lord, it has.
I'm handing up a copy and my.
Oh, no.
No attachment was there and only.
No. Writ petition, Your Lordship, may I hand up? I have already.
Service.
Very well. I have filed the affidavit of service. Your Lordship, I have filed.
That track report is not complete.
Very well. I'll check that out. By 5th, I will conclude the necessary formalities.
Come on, 11.
Very well. I'm deeply obliged.
Can I take your phone numbers and addresses, please?
Next.
Lordship, I'm for the state, Lordship.
Lordship, I am for the petition. Affidavit of service. May I please, your Lordship? Lordship, this could be a perfect example that what a common man can suffer under the political duress and muscle power. Though the judiciary tried its level best to protect my interest, but unfortunately, till date I am at a mess.
Yes.
My Lord will see. I am a very small plot owner, residential plot, being plot number 452. It is at the cross junction of Tapan Road and Naya Bazaar Road at North Bengal, my Lord. Lordship, I am a very poor person, and being my plot at the adjacent to the road, at the veranda, I used to run for last 25 years a small tea biscuit mineral water shop, and by virtue of that, I arranged nourishment of my family for last 25 years, my Lord. My Lord, what happened in the year 2023? Sorry, my Lord. In February 2023, some local influential persons, your Lordship will understand, they tried to exploit the adjacent area, which is the PWD, beside the road area, PWD land. They tried to commercially exploit. They ordered me to close my shop. I refused, and what they have done, they have covered the entire my veranda, my ingress, my egress by constructing structures, wooden and tin sheds. And my Lord, I preferred a complaint, written complaint on 12th February 2023 before the Gangarampur PS. Your Lordship will find the complaint at page 36 of the petition.
So now what you are
But without any avail, my Lord, kindly look into the thing that without having any relief, I filed a petition under section 147 CRPC, being MP case number 28/2023 before the learned SDM Gangarapur. My Lord, now kindly comes to page 41 of my petition. It is an order passed by the learned SDM in that case. Page 41, my Lord. Your Lordship got the page 41. This is an order of that proceeding 6th March 2023. Your Lordship may directly come to the paragraph number 6. The BL and LRO Gangarampur is hereby directed to cause field inquiry and submit report regarding the present status of the said land as per proper format and submit report within 24th March 2023. Now the most interesting part, my Lord will kindly come to page 42 once. Report submitted, your Lordship will find at the very bottom part, Tapan Kumar Pal is the revenue inspector on behalf of the BLLRO. It is submitted on 23rd March 2028, and your Lordship will see in the format at point number 8. The point is, was the disputed land used as pathway by the petitioner? The answer was yes. Now, my Lord, kindly turn over the page. At page 43, the same person, Tapan Kumar Pal, revenue inspector, the same date, 23rd March 2023, and the same question, was the disputed land used as the pathway by the petitioner? My Lord, will see no. Answer is no. Now, how this could happen? It cannot happen in the real world. Now, my Lord, will turn the page and come to the proceeding noting part at page 44 of my petition.
Page
44, next page, my Lord. Only next page, page 44. It is an order dated 5th April 2023 by the learned SDM.
Yes.
It is saying, I am reading from the third line, the report of the BL and LRO was challenged by the petitioner by submitting photo. Here I am pausing for a moment. Therefore, initially the report was against me, against the petitioner. That's why I challenged. I submitted current photographs. Now, my Lord, I am going on. RI attached to the BL LRO Gangarampur was asked to appear and submit proper field inquiry report. RI appeared and submits report. Now comes the second part, my Lord. As per report, the disputed land is in the front side of the petitioner house, which has been used by the petitioner as pathway. Therefore, my Lord, under complete political influence, the first report was given, which was false. When I produced those pictures before the learned SDM, the report changed, and my Lord, the learned SDM directed petitioner will use the way for egress and ingress, respondent to remove the temporary structure so made by him in the front side of the petitioner land, which is obstructing egress and ingress. Case disposed. Now, my Lord, what happened? After this passage, after passing of this order, nothing happened. They didn't do anything. Now, I filed another application under section 107 CRPC.
So you are before the petitioner. So
My
it
lord.
is in your favor. Page 44.
Yes. It is in my favor. It is in my favor. But nothing happened over there. The petitioner, the respondent didn't remove that structures from the front side of my home. Now, my lord kindly comes to page. My lord, page 56.
Yeah.
I prefer that application under section 107, which was registered at MP case number 74 of 2023. And this is the order sheet, collection of order sheet, first page, my lord, at page 56. This is an order of 11th May 2023. My lord, may kindly come to the second paragraph. My lord, got it? Yes. Page 56, second paragraph. The allegation is that respondents have not complied the order number so and so, that order, my lord, that removal order of 5th April 2023 in MP case so and so till date. And whereas this court has prima facie satisfied and proceedings under section 107 is drawn up against the respondents, issue summon upon the respondent directing them all to appear in person for hearing on so and so date and to reply show cause notice as to why they should not submit bond of rupees so and so under section so and so CRPC before this court for this kind of activity. So the learned SDM took exception that it was not complied. Then my lord kindly comes to the next page. That is an order dated 26th May 2023. Respondents found present and submit bail bond. Respondent further prayed another date for submission of show cause reply. Now, my lord kindly turns the page. This is the most crucial part at page 58. My lord will see type copy at page 59. My lord may kindly come to page 59 directly. This is a type copy. It is an order dated 28th June 2023. The case is taken up today for hearing. Respondents found present and submit peacekeeping bond with a condition, that is undertaking. They will remove the temporary structure within 2 weeks of issuance of the order. Respondents are directed to remove the temporary structure from the disputed land within 15th of July 2023. IC Gangarampur is directed to send an observation report within 15th June 2023 whether the respondents complied the order number so and so dated 5th April 2023 under of MP case number so and so by removing the temporary structure from the disputed land. Even after passing this order, the respondents didn't comply. And my lord may kindly come to the next page. That is the final order that was passed on 15 July 2023. My lord will see, I am reading out for your lordship's convenience. Learned lawyer of the respondent submits a time prayer for next date for third time without acceptable reason, hence not allowed. Whereas the respondents had given a bond under section 107 CRPC for complying with this court's order dated 5th April 2023 in case number MP 28 of 2023 with a conditional time period of 2 weeks for compliance. The stated date of compliance was 15th July 2023. Whereas information has been obtained that the compliance has not been made, thereby the conditions of the bond stands violated, resulting in invocation of CRPC 122(1) subsection B. Based on documentary evidence, photograph and report of the court's DMDC, it is proved that bond has been breached on the basis of the same. Court is satisfied that the bond has been breached and the court's order was willfully been violated. 2 extensions for compliance had been given and respondent has actively endeavored to undermine the majesty of the law with disrespect and nonchalant attitude. IC Gangarampur PS is hereby directed to arrest and keep the following in 3 persons in custody of Superintendent Balurghat Central Correctional Home. The respondents are Bikash Pal, Abhishek Pal and Shobhan Pramanik. And my lord, the next page, the above named 3 shall serve the remainder of the bond period in Balurghat Central Correctional Home till 27/6/2024. Yes. Now, my lord, after that, the most unfortunate part, these respondents preferred an appeal before the learned ADJ Balurghat, challenging that order of removal of 5th April 2023. Your lordship will find the order at page 60, my lord. But your lordship may kindly directly come to the operating part, page 81. My lord, the order is legible before the lordship at page 81.
Yes.
Lordship, at page 81, your lordship will find at the middle portion, my lord, the paragraph starts with the record consists of 2 reports. Yes. The record consists of two reports submitted by the same person which are completely contradictory to each other and both appear to be submitted by the same officer on the same date because the date of the report is the same. And if one of the report was submitted later, there is no indication or endorsement in the report to show which was submitted later. Therefore, there is no clarity as to which of the report is earlier. Even if we hypothetically accept that the report stating that there is a pathway in the disputed land in the later report, because the order reflects that this report was relied on in the order, thus the one negating the contention of the petitioners would obviously be the one which was challenged by them. There is no finding in the order of the learned SDM Gangarampur at Bunyadpur as to why he relied on this report instead of the previous one. Where there was such a glaring inconsistency in the report and the authority directed to inquiry in the matter, then the best way forward for the learned SDM Gangarampur would have been to call for further evidence. And my lord, ultimately this was the reason that without adequate reason, that order was set aside. My lord, now the thing is, what they have done, your lordship may kindly take, I am before the court of equity and justice, my lord. My life, my right to profession has been not only infringed, I have been literally starving because that was the only means of my fooding. My lord, may kindly see the present condition. I have been dated. I have used the timestamp for your lordship's convenience so that I can appraise your lordship the condition of the things over there. My lord may kindly find the first picture. It was that point of time when I used to run the shop. Your lordship will see some tea, biscuit and mineral water, this kind of stationery shop. What happened, my lord, 2023, my lord may kindly come to the second page. Two constructions of wood and tin that was covering my front. My lord may kindly come to the next page. Page number 3, third one, covering my ingress egress. Fourth one, my lord, those unauthorized construction on the PWD land, they are being used for commercial exploitation. I cannot even open my veranda. And my lord may kindly come to the last fifth part. Your lordship will see a small green patch over here, roughly perhaps 1 foot, that has been only left for my ingress and egress. That is the situation now I am suffering. My lord, my elder son, he was studying in a diploma college. His study has been stopped. My younger son, he is a student of class 11. And my lord, this is the situation. I am before your lordship with folded hands, my lord. This is the PWD land. They are willfully, deliberately using political and muscle power, entirely obstructed. Even I cannot open my throat properly. And my lord.
So once the learned additional session judge,
my lord,
has set aside the order of the subdivision magistrate, why you are not approaching the subdivision magistrate? How the writ court can interfere with that?
Lordship, the thing is,
once the authority has decided the matter, that they challenge the order of the concerned authority before the revisional court has set aside the order.
Lordship,
whether by sitting in a writ jurisdiction can override the
Lordship, I have narrated these things only to demonstrate before your lordship what happened. But my lord, my contention is, can a man's sustenance can be stopped in such a manner of hooliganism, my lord? That is my that is my.
But they got the order from the competent court of law.
And that is
the order passed by the subdivision magistrate was set aside by the sessions judge.
Lordship,
either you agreed with that order, you could have been prepared a revisional application.
Lordship,
before the High Court. Or if you are not, then you could have been again approach the concerned authority what you approached earlier. Yes, that because of the session judge has set aside the order because of the contradictory report, call a fresh report and take appropriate.
Absolutely, my lord.
What the writ court will do here by sitting in this, you have whether they have encroached, whether that's a footpath, whether that is the PWD land, whether you are the recorded, and how the writ court can.
Lordship, I bow down to your lordship, whatever fault to your lordship. But the thing is, I am not before your lordship challenging the additional session judge's order. I am before your lordship only on the point that my right to liberty, my right to profession has been infringed upon. That is guaranteed under Article 21 of the Constitution, my lord.
A person has to take appropriate,
my lord,
step before the appropriate court, not directly.
My lord, here I must bow down before your lordship that he could have been taken recourse of the proper legal action after the ADJ's order was passed, my lord. But as I have came to know, my client was not properly guided, my lord. My lord, may kindly my matter may be as because the order was passed by the learned ADJ for non-reasoned order. Only that. Though
You cannot say non-reason order.
No, not I am saying, my lord.
The additional session judge rightly set aside the order because there are two reports. How you can say this is the first report, this is the second report?
Yes, that reflection was not there, my lord.
Only condition.
Yes, yes.
That is the only reason the order.
Reason was the SDM's order was not reason. That I was saying, my lord, can I am praying with folded hand before your lordship. Can the matter be remitted back before the learned SDM so that he can take stock of the issue afresh? And
I am dismissing with the liberty to take appropriate dismissal of the writ petition.
Lordship,
Not prevent you to.
Lordship, dismissal will affect my rights. This is a High Court. Your lordship knows. Order dismissal from High Court. It affects entire my rights, my lord.
You have taken the chance before the court. You have taken the chance before the court. You know, you could have been taken. Withdraw the matter. Could have been gone. You argued the matter for about 20 minutes.
Lordship, I am only lordship. I am only upon the point, my lord. My right to life has been infringed upon. Here, this court is a court of equity and justice, my lord.
Total 25 courts will hear the right to life. Every person will come to
Lordship,
the court filing a writ petition right to life without going to the appropriate court where you get the benefit. You approach that. It is not the case. You don't know where is the authority.
Lordship,
you see who is the authority. You approach the authority.
Lordship, I have approached.
Some order which is not, we can say, reasoned order. The one competent court has dismissed, set aside that order. You could have been approached the authority.
Lordship, I have approached the government authority who is the owner of the property.
And before the session judge, you could have been argued the matter. Yes, if it is certain, let the set aside remand the matter. You are not played before the session judge.
Lordship, that lacuna is on my part, my lord, because I am an ignorant client. Your lordship will understand. I run a small tea shop. So as I was advised, I proceeded, my lord. Only I am begging before your lordship, without dismissal, my lord, kindly remitted back this matter to learned SC for.
Why remitted? There is no application. How the court will remit the matter, remand the matter back? There is no application.
My lord,
there could be an application, then court can only as application is pending, let the authority decide.
Lordship, what happens, as I have not proceeded after the ADJ's order has been passed, your lordship may kindly give me that liberty, because I will be time bound, my lord. I will be time bound, my lord. Only that part liberty, my lord. I may be proceeded before the matter with before the learned SDM.
And after order of secretary lordship, police is keeping shop decent lordship to maintain peace and tranquility, that no disturbance will occur.
Lordship, existence of those shops infringes my right to earn. I have a family to maintain, my lord. That was my only source of income for last 25 years. I don't know anything how to sustain my family, my lord. After 25 years, upon the PWD land, they constructed structures. I cannot even open my veranda and my door, my lord.
Initially, the petitioner has made a complaint before the Learned Sub-Division Magistrate, Gangarampur at Buniapudur, Gangarampur Subdivision, against one Vikas Paul, Abhishek Paul, and Sovin Pramanik. On the basis of the complaint made by the petitioner, the report was called for. The revenue inspector of the concerned circle has submitted two contradictory reports. In one report, it is mentioned that the disputed land used as pathway by the petitioner. In the second report, it is mentioned that the disputed land was not used as pathway by the petitioner. The Learned Sub-Division Magistrate, considering the report wherein it is mentioned that the petitioner has not used the pathway, accordingly, the Sub-Division Magistrate has passed an order on 5th of April 2023, directing the private respondents. The private respondent of the party here?
Yes, my lord. Party and sir, I have already handed over the affidavit of service.
To remove the temporary structure so made by them in front side of the petitioner's land, which is obstructing the egress and egress of the petition. Subsequently, on 28th of June 2023, comma, this sub-division magistrate Gangarampu find that the private respondents have not complied with the direction passed by the sub-division magistrate, comma, the sub-division magistrate directed the IC Gangarampur to send the private respondents an on 28 June 2023, London Magistrate passed an order directing to see the private respondent complied with the order dated 5th April 2023. Police. Again, the matter was taken on 15th of July 2023, wherein it was found that the private respondents have not complied with the order by removing comply with the order dated 5th April 2023. Accordingly, the sub-division magistrate directed the IC Gangarampu arrest the private respondent and to send to the correctional home till 27th of June 2024. In the meantime, being agreed with the order passed by the London Sub-Division Magistrate dated 5th April 2023, the private respondents have prepared a revision application before the London Court of Additional Session Judge Gangarampu, and by an judgment dated 22nd August 2023, the order passed by the Sub-Division Magistrate dated 5th April 2023 was set aside and quashed. Now the petitioner has filed the present application praying for a direction upon the private respondents to vacate the public land in question and for taking appropriate steps. This court finds that initially the petitioner has made a complaint to the Sub-Division Magistrate, and the Sub-Division Magistrate has taken appropriate steps and passed appropriate order. But the same was set aside by the London Additional Session Judge by a judgment dated 22nd of August 2023. After the setting aside the order of the Sub-Division Magistrate, the petitioner has not taken any steps either before the Sub-Division Magistrate or any other competent authority for taking any action against the private respondents, and has directly filed the present date application. Considering the above, this court finds that there is a disputed question of fact, and if the petitioner found that the private respondent have made any encroachment due to which the egress and egress of the petitioner has been affected, the petitioner has an alternative remedy to approach before the appropriate authority. Sitting in the writ court, this court cannot adjudicate whether the private respondent have occupied any government land or whether the egress and egress of the petitioner has been affected. Accordingly, this court finds that the writ petition is not maintainable. The writ petition, thus the writ petition number so and so dismissed. However, the dismissal of the writ petition will not prevent the petitioner for taking appropriate step before the appropriate authority for taking action against the private respondent if the private respondents are found in illegal occupation and construction of any shed in the path which the petitioner is using as egress and egress to his residence, his shop.
Lordship,
State authority.
Lordship, one indulgence, my lord. Lordship, petitioner may not be time barred to take such step. Only that part, my lord. Petitioner may not be time.
Not prevent to take appropriate step before the appropriate authority.
And not time barred if law prohibits such.
What time barred?
The lordship knows order from High Court gives the effect on the
Yes,
judiciary, my lord.
Next.
Grateful, my lord.
Lordship, the 12 p.m. fixed matter.
Grateful, Lordship.
Yes, next.
Is that matter where I had
See compliance of payment of 5 lakhs.
payments have been made.
Huh?
Payments have been made.
Payment has been made.
Yes. Finally, I'm relieved.
You made the arrest court as the executory court.
Payments have
I'm
been
glad that Lordship kept it today. The payment we have reached.
I suggested that's why it's easier for us to also prevail over the petitioner in the event.
My lord permits us to use an affidavit, my lord,
Yes.
1 week after the vacation because other issues have to be decided now.
Correct.
And kindly records that this 5 lakhs is, my lord, in terms of Lordship's previous order, yesterday's order.
Yeah, Learned Counsel for the petitioner submit that the balance amount of rupees 4,99,999 has been paid by the petitioner.
Handing up the
been paid by the petitioner to the respondent authorities. The payment receipt filed by the petitioner be kept with the record. Full stop. As the petitioner has paid the total amount, total outstanding due amount, total
On account of areas. On account of, because I have already issued another disconnection notice because they are, my lord, in default so far as the present, my lord, outstanding is concerned.
Outstanding forming the subject matter of this.
In connection with this present case.
Yes.
Comma. This court hope that the respondents will not disconnect the electric connection.
On this account.
On this account. Full stop. And this court also hope that the petitioner will regularly pay the monthly consumption charges to the respondent authority as per the bill raised by the petitioner.
Very good.
And the respondents. Full stop. The counsel for the respondent prays for time to file affidavit in opposition. That affidavit in opposition be filed.
1 week after the vacation.
1 week after winter vacation.
A reply within 10 days.
Reply within 10 days. Please the matter on 22nd January 20.
Great.
Maybe 2 weeks, your lordship. My
2 weeks.
2 weeks.
Let the matter appear on 28th of January 20.
Great.
Very well.
Great.
I'm deeply obliged.
Thank you. Next.
But I appear for the petition. My lord, in my read petition, my lord, I have, my lord, 3, my lord, points. First point is, lordship would remember, it is that USG machine matter in which, my lord, my USG machine was shifted from Boranagar, my lord, to our unit in Daihat, Bardhaman. Now, my lord, the CMOH, my lord, has initiated a proceeding and sealed the meter, completely sealed. Now, my lord, my first prayer before your lordship was that, my lord, it's a very costly machine. Now, my lord, this machine, my lord, requires a periodic servicing. My lord, if I tell your lordships, my lord,
Instruction?
Yes.
Yes. What is section?
I have serious objection to that, my lord. There are procedures, my lord. There are procedures and guidelines when a clinical establishment purchase a machine, like a very sophisticated machine like this, they have to take certain permission. They have to, as per the guidelines, they have to do certain things, which they did not. First of all, their establishment has to be a registered establishment where they try to shift or try to install the machine. That is not there.
perhaps this is not correct.
May I? It is there. And then, my lord, it was installed at Baranagar and they tried to shift the machine to the Katua establishment there. And for that, they had to take prior permission from this is at in the district, not 24 Parganas. And the machine they wanted to shift is at Purbo Bardhaman, my lord. There they have to take prior permission that they want to shift the machine from the. There are certain procedures. There is a committee, my lord. Committee consisting of 3 people: district magistrate, the CMOH of the district, and another officer of the concern. And what the very alarming thing is this, my lord, your lordship kindly see this writ petition is suppression of material fact. Your lordship kindly come to para 5 of the writ application.
Okay, you filed then report.
Yes,
my lord, may I say this? Perhaps, my lord, my learned friend.
I shall file report by
Mr. Koron, please. It is not only you who will.
Your lordship kindly.
My lord, may I, my lord, whatever my learned friend has submitted.
Let what you want to show.
Para 8, your lordship kindly, may I read? Your petitioner states that after the said USD machine was reached to Daihat, that is Katua, the petitioner clinical establishment did not operate the said machine. This is their statement.
Yes.
They did not operate.
Yes.
Your lordship then come to
let him say something with responsibility.
page.
This is not a responsible submission.
Page 49. Page 49, it is started from page 47. Your lordship, there's a resolution taken by the DDA. Page 47.
Yes.
A resolution taken by the district authority. A Zoom meeting was held on, date is very important. That is 9th of March 2023. And with the following member of the district appropriate authority, that is DDA, OPC and PNDT Act. What is this act? Your lordship kindly see, this is the act is pre-conception and prenatal diagnostic technique.
That is what an USD machine is used for.
Prohibition of sex selection. This machine is a very unique machine where one can come and detect the prenatal baby sex, that is whether the baby is a male or female.
May I present my case?
That is the
Will you allow me to present my case?
Here I am not.
He is making irresponsible submissions.
It is found that the petition is not interested, but let the matter release from this court.
Lordship would hear it. Lordship would hear it. Kindly. But I stand corrected. I apologize. But I apologize. Lordship would hear this matter.
This court has asked the question. Lordship. Let he giving the answer. The court is not going to pass any order.
But I apologize. I apologize. Lordship would hear this matter.
Then, my lord, your lordship kindly come to page. I was referring page number, my lord, 47. The following district authorities, that is the parasecond. The following district appropriate authority member was present. The district magistrate, the chief medical officer, the district
maternity child
and child health organization. This is the 3-member committee.
Correct.
When they asked they wanted to shift the machine from Boranagar to Katua. So this is the two-way transaction. One, no objection has to be taken from this 24 Pargana district committee.
Okay, that's why. Whatever.
You lordship kindly see the date, my lord. May I?
Yes, 2023.
2023, and the last page 47, my lord. That is the from in the box. This is number 2. This is from SCAC Sanjeevani. This is my learned friend's machine.
Where?
Page 49. Page 49, your lordship kindly come to.
Yes.
2 is the machine.
Yes.
For which, my lord, permission, for which it has been considered, when it was considered, 9/3/2023.
Correct.
Your lordship kindly sees. Then, my lord, your lordship kindly come to the.
What is the decision?
Yes, it was, my lord, permission. Then your lordship kindly come to page 60.
Now, what is the decision of this meeting? 9/3/2023.
Yes, you can shift the machine.
Correct.
Yes. Then your lordship, they have to take prior permission from the district where they want to install the machine.
Correct.
But they haven't taken.
60.
Page 60.
Yes.
Is the first so-called notice. Your lordship kindly straightway come to the why my learned friend is very much eager to repair the machine. What is the reason behind? Your lordship kindly first para, second, third, fourth, fifth. That is Roman 3.
Yes.
According to the record obtained from the USD machine.
Page 60.
3. Page 60. Roman 3.
Yes.
That is paragraph number.
Yes. Continue. Yes.
Your lordship got it. According to the record obtained from the machine, the most recent date of usage of the machine, USD machine, was 22nd of March, August 2023. That means, your lordship kindly see page number 47. When it was released on 9/3/2023. It was shifted on the very date. It is from Calcutta to Bardwan is not very far. Even I Even if I assume that the machine was shifted the very next day, that is on 10th of March. 10th of March, it was stationed there. The machine was shifted to the facilities, Badwan facilities, and there they have not taken permission. Not even DDA, not even given permission. They started operating the machine. This they cannot.
Yes.
And this is a very sophisticated machine, my lord. Whatever work is done, it has been recorded inside the machine.
Okay, next.
My lord, this is a very criminal offense, my lord. So the DDA has taken a step. They have filed a case against him. They seized the machine, and they did not. This is a very grave offense. They cannot, without the permission of the authority, they cannot.
Correct.
My lord, your lordship, I have the, my lord, may I file a report, my lord? This is a very volume.
That's why I'm telling that you file the report, serve the copy.
Yes, my lord.
Decide the matter.
My
No
lord,
problem. Since beginning, I'm telling that only.
No, my
You're
lord.
telling that now you will show the document, you will show the
Yes,
document.
my lord. There are guidelines. There are.
Your report is ready.
It is the department has sent it to me. It is not in the form
My lord,
that I can.
kindly
Kindly give me time. my lord.
Yes. Yes.
Now, my lord, what my learned friend has submitted, my lord, he has not stated the correct status. What had happened was, we had purchased a USG machine. USG machine was initially in the Boranagar unit at Kolkata. We had set up a unit at Daihat, Purbo Bardhaman. Now, my lord, we wanted to shift the machine. My lord, we applied for permission. Lordship has seen the permission at page 47. My lord, a 3-member board considered and allowed us shifting. Before the machine reached Daihat, takes up page 50. We applied for permission before the Daihat authorities.
Yes.
Kindly takes up Annexure P6, page 50.
Yes.
Now, my lord, Annexure P6, page 50.
Whether the authority has given the permission.
No, what they did was, এটা বলেনি দাদা, আমি একটা কথা বলিনি.
Yes.
They accepted the money even.
Correct.
They kept quiet. My lord, we shifted the machine to Daihat. Thereafter, suddenly, without granting us any approval or permission, even after accepting the fees for it, the authorities conducted an inspection. Now, kindly sees the nature of show cause which they have issued. Everything is based on assumption. They themselves say we are unclear. Now, my lord, at this stage, kindly comes to Annexure P7 at page 61.
Yes, that I am there on.
According to the records obtained from USG machine, the most recent date of usage of this USG machine was on 21st August 23. No client register was maintained. As you have kept a functional USG machine and performing USG without obtaining prior approval from the licensing authority, it is unclear. So they are not sure that whether the machine was actually operated on 21st August 23 or not.
No. It is unclear whether USG
Yes,
has been
there is no conclusive proof for that.
for the sexual determination.
Yes, there is no conclusive proof. Who is the patient? How much I have used the machine? Nothing.
Correct.
Now, my lord, what I was only beseeching your lordships, this is a very costly machine. Now, my lord, at the end of the day, if I succeed in my writ petition, my interim order, my lord, these issues all have to be decided on affidavits because, my lord, I have to answer it on affidavits. Now, my lord, the machine requires a servicing because, my lord, my lord, if this writ petition succeeds after 5 years and this machine is not, my lord, allowed to be serviced in the meantime, the machine will turn into scrap.
Where is the document when the service is due?
Kindly comes to.
Where is the warranty document? Where is the servicing document? So, servicing is due.
My lord, what they want.
Dada, একটু বলেনি দাদা. Kindly comes to the purchase receipt of that machine, page 43. ওখানে তো কোন তো থাকে না. এই মেশিনটা ওয়ারেন্টি আছে কতদিন পর সার্ভিস হবে? But it requires servicing after every 1 year.
That's why. So there is a voucher, there is a warranty period. Where is the...
Now, my lord, we have the purchase challan of that machine, page 43.
Correct.
Now, my lord, we have purchased this machine. Now, my lord, every machine, my lord, the warranty document is not annexed to this writ petition. But it's a machine, my lord, it requires servicing. Any machine would require a servicing. So, my lord, what I was only beseeching.
Where is the application requesting for servicing?
Lordship. Kindly comes to annexure page 76.
Yes.
My lord, we had written this to the Chief Medical Officer of Health. Kindly comes to 1 to 3rd paragraph. As you know, sir, the machine required regular servicing, but we are unable to do the same.
76.
So, my lord, we had written to the CMOH. My lord, what I was only beseeching that let the CMOH, all officers who are present there, be present at the time of servicing, so that no data of the machine is manipulated in any manner whatsoever. But after 5 years down the line, my lord, if this
What has happened to the SOCOS report?
but we have replied to the show cause notice that has been kept pending since 2023. Our application for grant of license is pending since
What has
2023.
happened to the SOCOS reply? You have given the SOCOS reply?
Yes, I have given the show cause reply.
The reply to the paragraph 3, 4, and 5.
But kindly comes to our show cause reply
In performing without
on page 66. Page 66. No, Malad, it's page 62. Malad, in any event, Malad, if we are at fault, let us be penalized. But only that case, Malad, the machine cannot be turned into scrap.
So there is an allegation you have used and they are not unclear. If they are proceeding with this so-called notice and proceeding on against you, then they have to obtain the report. If in the meantime the court will allow you to service the machine, so all the things.
Malad, may I say this? There was a particular date in which, according to them, I have operated the machine. That was on 21st August 23. They must have the reading of that machine. Malad, they must have parameters in which, Malad.
Let them submit the file the report.
But only thing is, Malad, if servicing is not allowed.
Let it file. How soon you file the report?
Within 2 weeks, my lord.
You're telling that you're ready to for the what?
My lord, it is there. My lord, they have haphazardly, my lord, sent the, my lord,
Within 10 days
documents and
you
all
file
that, my lord.
the copy?
My lord, today I am not giving, my lord. I shall file within a week, my lord.
Correct. After having the copy,
yes,
the respondents are directed to file a report by way of an affidavit after serving the copy to the land council for the petition within 10 days from date. The petition is liberty to file exception to the report, if any, within a week thereafter. This is the matter on 17th December.
But at the same position, my lord.
Under the same heading. एकटा record करो. The respondents are directed to indicate in the report what has happened after whether the authorities have taken any action in terms of the against the petition in terms of the so-called notice.
Grateful.
Lordship, item number 16, this is my writ petition.
Yes.
Lordship, this writ petition, your Lordship, in its connection with an illegal mining, your Lordship, in the district Birbhum.
Abrogated matter, my lord. Notice was not, this is abrogated matter. Notice was not served upon me, my lord. My senior has not come. I am paying not today.
Served. What is not served?
Notice not served, my lord. Notice. Abrogated matter. This is abrogated.
Have you you are having the subscription of the this cause list? You are taking the cause list every day.
Stated the
You are taking the cause list every day. You are checking the cause list every day.
Where is this?
So we are appearing.
No.
We are appearing for the private respondents, my lord. Matter initially appeared under the heading for hearing. Every Wednesday matter was supposed to be taken up, but suddenly now the matter upgraded without serving any notice. That's why this is happening.
Yeah, that's what I'm telling. Whether you are taking when it has been, you have seen since when it is fixed for urgent motion. When from which date the matter is listed as urgent motion? Only today. Yes, why you not issued the notice?
That is my mistake.
When?
My mistake. It was appearing in the list as under
appearing,
the
but are you mentioned?
I did not. That is my mistake. I completely.
So when you will be ready?
Tomorrow, my lord.
Tomorrow? Sure.
Yes, my senior.
If you test, then I will not grant time. That's why I'm asking. Tomorrow, as per the submission made by the counsel for the petitioner, respondent schedule, let the matter appear tomorrow under the same heading.
I'm apologizing.
Yes. Next.
Item number 17.
I am for the petitioner. Lordship, the matter was moved before His Lordship Justice Kaushik Chando and His Lordship directed to file a report by the CSC authority. Lordship, in this matter, what has happened, petitioner is the occupier in the premises, Lordship. For that, Aadhaar card or residential documents are there. Applied for a domestic connection before the CSC authority, and thereafter they have rejected the petitioner's application by letter dated Lordship 26 June 2025. That's splitting of load. Lordship, annexure P2, page 10. It is annexed. Now, Lordship, during the hearing, Justice Chando directed the CSC Limited to file a report.
You are having the meter.
No, that is in my father's name, Lordship.
You are residing with the father.
No.
That is the report. Have you received the report?
Yes, I have received, Lordship. I am a different occupier of the said premise.
See, during inspection, we found the petitioner residing in a small shed room along with the father.
No, Lordship, I am not residing with my father, Lordship. And a second paragraph of the said report kindly comes, Lordship.
Yes.
We have already provided 25 meters in the existing common meter board. Landlords have strong objection against installation of another meter in favor of the petition. I am the tenant, Lordship, occupier, permanent occupier under the landlord, Lordship. Lordship, now if the landlord has objection, Lordship, we can pray for police help. Lordship, this is...
You are having the meter.
No, I don't have any meter, Lordship.
You are residing with your father?
No. Father resides separately and I reside separately, Lordship.
That the report says.
That is that there I
have not taken the exception to that.
Lordship, just tomorrow, yesterday I received the report, Lordship. Yesterday, Lordship.
Two line, you could have been filed the exception to the report.
My lord, this is a hard premises, my lord. Hard premises, my lord.
Lordship, as per section 43, Lordship,
correct.
I am entitled to get the connection. And if
Kindly see your hurt. Who will take the risk?
Lordship, already they have provided 25 meters. Lordship, they have stated, Lordship.
Yes.
In the heart, they have stated provided 25 meters. For my meter, it will be, Lordship, dangerous.
Yes.
My lord, kindly look at the paragraph number 3, my lord. How we can convert the existing meter to a block meter, my lord.
Paragraph 3.
My lord, first page report.
Not advisable to multiple connection. We already provided 25 meters. Because that we can convert the existing meter to block meter.
Yes, my lord.
Lordship, father is residing separately in his own room, Lordship. 25 meters already been provided. I am praying for only one domestic.
Now, what is the block meter?
My lord, block meter is same as individual meter, my lord. Same as individual.
No, Lordship. Lordship, block meter, one meter will be installed in several persons' name. That is the block meter, and bill will be raised in one person's name, and all the.
You take the connection from your father's meter.
Lordship, I will come up with the exception. Lordship, I am not residing with my father. Father resides separately, and I am an individual occupier. And as per section 43, Lordship.
Your premises is also well.
No. Already 25 meters, Lordship.
Correct, 25 meters. It is
Lordship,
that again you
that I have to take instruction whether the petitioner resides in this, Lordship. I will come up with the exception, Lordship. And Lordship, if the landlord objects, Lordship, it is the settled law of the land.
That's correct, but your
Supreme Court has also directed without the consent of the landlord, I am entitled to get the connection. Lordship, on the first occasion, they have rejected on the ground of splitting of load. Now they are saying that landlord objected.
Yes. You consider the provisions, clause 18 of?
Lordship, whether it is a hard premises, Lordship, I have to take instruction. Lordship, kindly gives me 2 days time, Lordship. I will come up with the exception. Any day next week, Lordship, I will come up with the
District Engineer CSC has filed report after serving the copy to the Learned Counsel for the petitioner. Let the same be kept with the record. Counsel for the petitioner prays for 2 days time. According the case is adjourned. Let the matter appear on 5th of December 2025.
Lordship,
5th December.
Lordship, on Monday, Lordship.
Okay, then 9th of December.
Lordship, grateful.
It's a book de do.
My lord, it's a declaration, my lord.
For me,
Yes.
keep it.
Number 18.
My lord, my petition.
My lord,
Lord, affidavit of service is there.
Yes. What is the prayer?
my lord, the advocate appearing for the state. My lord, the learned advocate Sombhuddha Datta appearing for the state is
Learned advocate?
Sombhuddha Datta.
Ah.
He is engaged in another court, my lord.
Okay, no problem. Yes.
My lord, my application for conversion of land. My lord, what had happened? In 2024, I purchased the land. My lord, that land was being used by me to make construction for a go down because I am a fair price license
What
holder.
is the nature of the land when you purchased?
My lord, Danga. Danga, it is there. I'll indicate the page. Page 28. I'm sorry, my lord, it is in Bengali, but it is written Danga.
Dang.
Danga means land, my lord.
Hmm.
I'm sorry, my lord.
What is the nature?
The nature is Danga.
Danga.
Yes, I wanted to change it to Danga and Bastu. That is homestead. But that was rejected, saying that there is a order from the NGT which prohibits them. And under that, the additional district magistrate had passed an order. Well, he had passed two orders. Well, I'll show the NGT also, order also. And he had passed two orders, one restricting registration of deeds in 5 mojas, one restricting change of conversion. My lord, for the first notification for restricting registration of deeds has been struck down. I'll produce that. I have that judgment, my lord, the Justice Bhattacharya. I'll rely upon that and I'll show, my lord, why this should also be struck.
Affidavit filed?
No, my first time coming up.
First time.
Lord,
Yes, where is your advocate?
My lord, he is engaged in another.
I am allowing the writ petition.
My lord, kindly gives a pass.
What?
Kindly, my lord, gives a Passover, my lord.
What Passover? 1227, when Passover?
my lord, my application is in page 36.
Yeah, tell your senior I am allowing the writ petition.
Yes. My lord, kindly sees item number 9, existing classification of the plot is Danga. Applied classification of the plot is Danga and Bastu.
Yeah.
My lord, application date is 13th May 2024.
Hmm.
My lord, acknowledgement receipt is on page 38. We had submitted it on that same date, 13th May 2024.
Correct.
Now kindly see page 39. In reference to above, please find herewith the relevant order copy regarding non-initiation of any proceeding related to conversion as passed by the Honorable National Green Tribunal, EZ, Eastern Zone, Kolkata on 22/3/2023 in OA number 30/2023 EZ in the matter of Subhas Datta versus the State of West Bengal, which is self-explanatory. But the impugned notification is on the next page. But in compliance with the order dated 23/3/2023 passed by the National Green Tribunal, Eastern Zone, Kolkata in OA number 30 of 2023 in the matter of Subhas Datta versus the State of Bengal, he is hereby requested not to initiate or entertain any proceeding related to record correction and conversion as per order known as Chhatro Bill in connection with the following mojas. That 5 mojas has been marked out.
What is your moja?
My moja is Uttar Jodhpur.
Sir?
Item number 5. Yes, item number 5.
Yes.
My lord, kindly see the order of the NGT at page 41. It starts from page 41, kindly comes to the ordering portion at paragraph 14, page 42.
Yes.
Considering the allegations made, we deem it appropriate to constitute a committee comprising of the following members. This committee is constituted. The committee shall visit the Chhatro Bill and inspect the site and submit its report with regard to encroachment alleged to have been made upon the said water body and it shall suggest remedial measures for restoration of the said water body to its original pristine form, as well as remedial measures to ensure that there is no further encroachment into the water body. In the meantime, we direct the district magistrate Malda to ensure that no further encroachment is permitted in the Chhatra bill during the pendency of the present proceedings. Yes. Now, my lord kindly considers this thing. My lord, the Chhatra bill is a wetland. It has been, all the lands under it, it has been marked as wetland. Those which lands fall within that wetland area are marked. In my land was never marked as a wetland, and it was.
Yes.
Yes. My land, my lord, had seen it is Danga, that is dry land. There is no. Yeah. Kindly see, my lord, there were 2 notifications which were issued after this NGT order.
So how you can say your land is not affected to that?
My lord, because it is Danga, dry land, specifically is mentioned in their own records only. My lord, kindly sees Justice Bhattacharya's order. I'll be referring on, kindly sees paragraph 4. There are some, I'll point out the paragraphs. Kindly sees paragraph 4, page 3.
Yes.
Learned counsel for the petitioner next argues that the property in question is not a water body and has been marked as Bagan, that is orchard, in the record of rights. Learned counsel places reliance on the photocopy of the relevant extract of the record of rights annexed to the writ petition to substantial. My lord, I had shown that it was Danga. Now kindly see paragraph 7. My lord, in this case, what the registrar had done, because of the first notification, registration was stopped. In my case, the registration has been done, but the conversion has been stopped. Here, my lord.
When the registration was done?
2024, my lord. April 2024.
Yes.
Yes. But they said that there is no provision under the Registration Act which allows the magistrate to stop this. My lord, conversion of a land takes place under West Bengal Land Reforms Act. My lord, there is no provision under which the respondent authority would have directed the BLRO, that is the competent authority, that you please do not change any conversion or stop conversion at wholly. And it kindly comes to paragraph 11. The first challenge in the present writ petition is against the memorandum dated April 20, 2023 issued by the Additional District Magistrate Malda to the District Registrar Malda, stating that purportedly in compliance with the order dated March 22, 2023 passed by NGT in OA number 30 of 2023, the District Registrar is requested not to execute any deed as per order and known as Chhatra bill related to 5 Maujas. Paragraph 12 kindly sees the last 3 lines. The District Magistrate Malda was directed in the meantime to ensure that no further encroachment is permitted in the Chhatra bill during the pendency of the present proceedings. Thus, in paragraph 13, my lord, paragraph 16 of the judgment, the NGT had directed the District Magistrate to ensure that no further encroachment is permitted in the.
That's very final. What the court has held.
My lord had held that encroachment was not done. If there was encroachment in the wetlands, then the tribunal had jurisdiction.
Yes.
My lord, kindly see paragraph 15, 14 and 15. The term encroachment has physical connotation and means any illegal trespass or entry into a property. However, such direction by itself cannot operate as a restriction on the district register to stop registering valid documents executed as per law. My title has not been challenged. It is the land is there. The land they have accepted that it is Danga only. Kindly see paragraph 16. The powers of the district magistrate are clearly delineated in the Registration Act. In my case, the powers of the BLRO is given in the West Bengal Land Reforms Act. There was nothing given in that act which would allow the district magistrate to pass such orders, staying everything. And paragraph 23, paragraph 23, 5th line. It has been argued that the Maujas concerned are not a part of Chhatra bill. The petitioner has not only annexed extracts of record of right, but several photographs which were allegedly used by the applicant himself before the NGT, and argues that even as per those documents, the properties in question are not a part of any water body at all. Paragraph 25 says that the report of the committee constituted in compliance with the NGT order dated March 22, 23 has also been annexed to the writ petition and shows that none of the actions suggested by the committee to be taken by the district administration, including restraint on registration of documents. My lord, I have that same writ petition. I've got a copy. It does not show that there was any recommendation to stop full-fledged.
Yes, any further?
No, nothing.
My lord, so far as my lord, the state is concerned, my lord, kindly, my lord, envisage, my lord, one thing, my lord, this, my lord, order of the NGT, my lord, lordship, my lord, is not reviewing judicially that order. So, my lord, so far as, my lord, the conversion of land is concerned, my lord, just one. My lord, my lord, have already, my lord, asked for some instructions which has not yet come, my lord. So, my lord, I prefer, my lord, if lordship, my lord, kindly grants me another day, my lord, to come back with instructions.
How you can interpret the order of the NGT like this?
My lord, I shall come back with, my lord, if there is any notification.
Authority registered the deed. He is not asking for any, he is asking for the conversion, and this is not the wetland.
My lord, the issue is, my lord, that, my lord, just because, my lord, he requires the land, my lord, whether, my lord, I put a question to myself, my lord, whether, my lord, there is any vested right for having the land converted. My lord, his title is not in dispute. My lord, I am not saying that.
Whether he has a right or not, he has applied. The reason which you denied, that is to be seen by the court.
My lord, I appreciate, my lord, I appreciate.
The reason, the court will not say, yes, the reason which you assigned, that is correct or not.
My lord, grants me one opportunity to, my lord, assist your lordship, my lord, kindly gives, my lord, another day. I'll come back with the instruction, and, my lord, I'll complete the submission, my lord.
Please take instruction.
Very well. I shall come back.
Page 40.
My lord.
Is in consonance with the order of the NGT.
My lord, my lord.
Second, whether this is not covered under by the order passed by the coordinate bench.
Very well.
Dated 31st of August 2023.
My lord, my lord.
These are the two questions.
I shall, my lord, address your lord.
Counsel for the petitioner has argued the matter at length. Full stop. Counsel for the respondent prays for time to take instruction. According case is adjourned. When you will come?
But subject to, my lord, your lordship, any day next week, as your lordship please.
Let the matter appear on 9th of December.
I am grateful.
Under the same heading.
Grateful.
Next.
Item number 20.
19 का डेट देगा क्या है? 19 में डेट देगा क्या डेट है? में क्या डेट है ऑर्डर में?
27 তারিখ দেয়া আছে 27 12
ঠিক আছে তোর জানা
ওর নামটা টানা ছিল
27 টা
হ্যাঁ
বলে দে
ওটাই বলছি
20 नवंबर उस दिन नवंबर उसके बाद कैसा है?
বল মাই লর্ড কে বল
कल रख दो कल इस पर रख
item number 19 it has been wrongfully listed on
that's why it will come tomorrow.
My grateful.
Yes, next.
May it please the lordship, my lord, for the petitioner.
Response number 9.
Yes. Have you taken instruction?
I am led by Mr. Sinha, my lord.
Yes, Mr. Sinha. What your bank is doing?
My lord, after the observations made by my lord yesterday, he had discussed with the bank people what actually happened. But here, it is admitted positions in the petition. There is a spurious entry of 6,700. It is admitted positions that within a period of 1.5 months, about 20 lakhs of money transactions were done. It is admitted positions. There's some complaint came from the Cybercrime Authority to the bank. And my lord, the matter dispute, we advise them. They went to the ombudsman. Ombudsman is a creature under section 35A of the Reserve Bank of India. So 35 ombudsman scheme is framed in 2021. And there any deficiency, so it is a deficiency service of the bank, my lord. Bank has not allowed it. So they went to the ombudsman. So deficiency service, they went there, and my lord, that was considered by the ombudsman in detail, and order was passed that you cannot allow that. There is a provision for appeal. He did not file the appeal. Now, money laundering, my lord, all the time happening through this honest account or the regular or the.
Where is the order? He has not stated all the things.
Yes, my lord.
Your friend has not stated all the things.
Order.
Now, this is a new case you have made out now today.
40 and 50, my lord. Pay petition 40 and 50.
Page?
40 and 50. Page 49, my lord, running page 49. 49, my lord, running page.
Yes.
Closure of the complaint, closure of your complaint data. I say, it is observed that paragraph 2, my lord. It is observed that cyber crime complaint is reported against the account of the customer from Bangalore City, West CN Crime PS Home. Hold is suitably placed in the account. Hold cannot be removed until unless the order of the removal received from the court or law enforcement agency.
Correct.
Yes, law enforcement agency.
Correct.
Till that no order is received for removal of the imposed hold, complaint has been suitably addressed regarding the hold placed in the account by RE. Therefore, the RE has acted based upon the notice of law enforcement agency. RE, we acted based upon the notice from the law enforcement agency. This complaint is treated as a non-maintainable and closed under clause 16.1 and 10.1. This RBI Ombudsman scheme.
Correct.
In view, so therefore, my lord, they went to the proper authority created under statute. That authority decided that the hold is proper. This one side. Other side is that I'm looking at the fact that is spurious transactions in the account. 600 admitted 6,700 at least. We are the admitted position is there for statement accounts.
That's why, Mr. Sinha, they pass an order unless an order from the authority or the court.
Yes, sir.
Correct.
Will comply.
That's why I am asking your learned friend for the last 3 days. You take he is telling that the petitioner should come to the bank. We have issued the notice to the petitioner. What is the petitioner will do with the bank?
No. The order is to pass by the court or the.
Yes, your junior, your colleague for the last 3 days only relying upon the notice of the bank, giving the 2 copy of the notice stating that he is not cooperating with the bank, he is not coming with the bank for discussion.
So bank is ready, willing to pay the money.
That's right.
If
No.
they get a property.
So I propose let the bank allow. I am passing an order. This order may be communicated to the police authority from which you received the complaint. If the police authority will not revert any from the order of the court, then you allow the petitioner to operate the bank account, but keeping the 6,700 as freeze.
So first of all, we have to inform to the police authority. This is the order of the court.
Correct.
The court express this thing.
Yes.
If they don't come back, the next day my lord will pass the order.
Because police authority is not coming here.
Yes, well.
So I am passing an order, giving 1 week. Within a 1 week, you can communicate to the concerned authority from where you received the complaint.
My lord.
If the authority received and they will not revert back within a week thereafter, the bank will allow the petitioner to operate the bank account.
My lord.
But the 6,700
Which is
will keep
admitted?
as a freeze account till the disposal.
Yes, because the account also shows what is the amount lying in the account, which is much higher.
Correct.
So there is no
So why?
with regard to the rest of the.
We are
Because
agreeable.
today police is not coming, so the court cannot pass a blanket order. Again, an opportunity. Let the order be
Let the
communicated
police
to the
authority be
Police
apprised.
is coming to you and is stating that, then you
And
communicate
RBI
to
is
the
present
petitioner.
also. RBI Ombudsman, RBI is present. So RBI, so in their presence, madam, that is to be recorded, madam.
Yes, I am telling you, yes, ma'am.
The RBI presence is well.
My lord, may I be permitted to make one humble submission, my lord? My lord, the amount of 6,700, which was the bone of contention, my lord. My lord, I have gone ahead and repeatedly I have said that this is not my money. I want to give it back. My lord, I don't want that in my account, my lord. Let them take it back. They cannot even till date, they haven't even disclosed from where that funds came from.
My lord scored, but there are 2-3 cases are similar there. Money laundering is done like this way.
That I know, but that's why I want to hear the police authority, but they are not coming forward.
And also,
even though that the blanket order cannot be
Direction,
let
proper
you.
direction to the police authority and the Reserve Bank. We are only police. We acted on the basis of police complaint of the police authority. We acted on the order of the Reserve Bank Ombudsman scheme.
My lord, I just want to point out one more thing, my lord. My learned colleague, senior colleague had submitted that I did not appeal. My lord kindly turns to page number 50. It's an unappealable matter, my lord. How can I appeal?
That is I'm sorry. If that is there, but at least there is an order.
The petitioner has filed the presented application praying for a direction upon the upon the respond number 8, that is the bank manager, State Bank of India, Molar Gate branch, to defreeze the petitioner's saving account number 7 times 0 202 440 352 to save and accept the amount to the extent of rupees 6,700, which is a disputed amount in the said account.
পুলিশের অর্ডার হচ্ছে ভ্যারিয়েশন
Counsel for
পুলিশ
the petition submitted.
ওখান থেকে এসছে আর কিছু না
Where is the first information? Where is the first?
There was no FIR lodged, my lord.
No, first you.
My lord, page number 28, my lord. Page number 28, May 8, 2023. That was the first time that the bank had
On
communicated.
28th of May 2023, the petitioner received a WhatsApp message on his registered mobile number intimated that the account of the petitioner has been held for the reason that an amount of 6,700 has been kept on hold. Full stop. After the said hold, the petitioner has made several representations, the bank has not given any reply. To the petitioner. According, the petitioner has filed the present application. Counsel for the petitioner has also brought to the notice of this court to the order passed by. Who has passed the page 49?
One of the RBI ombudsman.
Passed by the banking ombudsman. Dated 30th April 2025, wherein the banking ombudsman held as follows. This paragraph 2, page 49. Set out kar do, full. In spite of the said order, neither the bank nor the police authority from whom the bank has received the complaint for freezing the account of the officer has not taken any action. Full stop. Learned counsel for the State Bank of India submits that as per the order passed by the bank ombudsman, the bank cannot defreeze the account of the petitioner unless and until there is a clearance either from the law enforcement agencies or from the court. Learned counsel appearing for the Reserve Bank of India.
The Bank of India banking.
Reserve Bank of India and banking ombudsman submits that on receipt of the complaint, the banking ombudsman has considered the complaint and passed the recent order on 4th April 2025. At the time of hearing, the learned counsel for this bank has handed over a communication dated. What is the date of your communication, sir?
Undated, my lord.
No, my lord, it was sent on. My lord, there is a postal receipt attached to it, my lord.
Lordship had also recorded
It
that
was sent on
dated
15th November.
On 15/11/2025.
15 November.
And submits that the bank is ready to settle the dispute with regard to the petitioner, with regard to the account maintained by the petitioner in the bank, but the petitioner is not coming forward to explain the situation. And as said, the bank has not defreezed the account. At the learned counsel for the respective parties produce the materials on record. This court find that the bank has freezed the account of the petitioner on the complaint on the request of Additional Commissioner of Police within bracket ACP, West CEN, PS Crime Bengaluru, Karnataka. Accordingly, by an order dated 1st of December 2025, this court allowed the petitioner to add the Additional Commissioner of Police ACP West CN Count Police Station Bengaluru, Karnataka as party defendant and party respondent, and to serve the notice upon the said added respondent. In compliance of the order dated 1/12/2025, the petitioner has added the Additional Commissioner of Police as party respondent in the present date application and served the notice upon this added respondent. This court This court, by an order dated 18/11/2024, has categorically directed the added respondent that after receipt of the notice to file a report before this court explaining why a direction has not been given to the bank, why the direction has been given to the bank for freezing of the account of the petitioner. But no report has been submitted. Considering the above fact, this court finds that due to the as per the instruction received from the Additional Commissioner of Police within bracket ACP, West CN PS Sen Crime PS, Bengaluru, Karnataka, the bank has freezed the account of the petitioner, and accordingly a complaint was made to the Reserve Bank of India, and the bank ombudsman has considered the complaint filed by the bank and passed the above mentioned order. Full stop. This court finds that the bank ombudsman has categorically stated that the hold cannot be removed until and unless an order for removal is received from the court or from the law enforcement agency. In the present case, the notice have been issued to the law enforcement agency on whose request the account was freezed. But the law enforcement agency, that is Additional Commissioner of Police, failed to come forward before this court to submit any report. And thus this report. Accordingly, this court has no full stop. Thus, this court has no other alternative to dispose of the writ application by following direction. With the following direction. The State Bank of India shall forward this order to the Additional Commissioner of Police within bracket ACP West CN Crime PS Bengaluru, Karnataka within a week from the date of receipt of this order. On receipt of this order, the Additional Commissioner of Police within bracket ACP shall forward the instruction to the bank whether further freeze of the account is required or not. The said report be submitted within a week from date. It is made clear that if within a week the Additional Commissioner of Police failed to submit any report to the bank, the bank shall defreeze the account of the petitioner and will allow the petitioner to operate the bank account, save and accept the amount of rupees 6,700. Full stop. It is further made clear if any adverse report is submitted by the ACP for not allowing the bank to remove the hold, the same may be informed to the petitioner, and the petitioner is at liberty to take appropriate steps.
Time frame only 7 days.
1 week forwarding.
We are forwarding that they have to reply
within 1 week. Within 2 weeks,
2 weeks, my lord.
My lord, may I request one indulgence, my lord? My lord, let there be a specific amount of 6,700 rupees regarding that.
Recorded.
I'm grateful, my lord. I'm so grateful.
Recorded. WPS disclosed.
Additional
Highly obliged, my lord. Thank you.
Next. Yes.
Tender my unqualified apology, my.
The 20, my lord, I beg to appear for the petitioner, my lord. My lord, it is that matter where despite having a valid DCR, my lord, e-challan, my vehicle was stopped. And according to the authority, allegation is that my driver didn't produce the valid documents at the time of, my lord, withholding the vehicle. But my lord, my specific case is that he produced that documents as well as in 14, the duration of.
What has happened? Still it is blocked.
It is still, my
Your
lord.
Lordship, I'm for the state respondent.
My lord, vehicle is still in the custody of them.
So you are also kept.
Your Lordship, an order has, as I have already submitted a report, previous dates. Your Lordship, a report has been already submitted before your Lordship.
On my lord, 7th, 11, 2025. authority wrote a letter stating the fact that in my absence they
My
passed.
lord, kindly, if I can submit, your lordship.
Let me finish, my lord. My case. Let me place, my lord. Because what authority is doing, my lord, behind the back, in order to, my lord, shield them, they're doing one after another thing. I need to state all these things before this court. What happened, my lord?
Have you taken the exception?
Yes,
to the
my lord, I have served upon them as well, my lord. This is my exception. My lord, first of all, my lord, kindly take, my lord, page, my lord, 24 of my writ petition, my lord. Because merely, my lord, they passed an order without considering a documents which is available in their official site. Read the position to likhte.
Madam, in the report, where is the notice served to the petitioner?
Your lordship, we have tried to serve a notice. Your lordship, kindly come to first page of the report.
Where is the notice?
Your lordship, we have tried to serve the notice, but as they were not taking the notice, we have done a latkan jari. On, if your lordship kindly come to third paragraph of the first page of my report. We have done a latkan jari over their house, your lordship. Moreover, the BLRO, the permission they are showing, that was actually given by BLRO Jhargram. But your lordship, it has to be given by Kharagpur 1, not by Jhargram. That has to be given by Kharagpur 1.
Then?
And then, your lordship, the petitioner has also not submitted any kind of documents through even their oppositions or their notice they have served upon us.
In which address you have sent the notice?
Your lordship, kindly can
what is the address?
My lord, kindly
your
take
lordship,
page
kindly
8
come
of
to
their...
page 7 of my report.
Yes. Vehicle owner.
It is vehicle owner, registration number such and such, care of Moni Mahato, wife of Joy Krishna Mahato, Amgachia PO, Haritara PS Kharagpur L.
So whether the court will send a notice to you, advocate having enrollment number, Calcutta High Court, it is suffice to serve the notice to you.
Your lordship, it was not submitted to the advocate, it was submitted to the vehicle owner.
Madam, I am asking, kindly come to the address. The vehicle owner, registered owner of so-and-so, care of so-and-so, wife of so-and-so. Whose wife? Care of so-and-so, wife of so-and-so. What is the name of the wife?
Your lordship, it's Moni Mahato is the petitioner, your lordship. We have tried to serve her, but they have not accepted the notice. That why we have mentioned done a latkan jari. Your lordship, kindly come to page 8. Refused to receive the notice, your lordship. If you kindly come to page 8, on the bottom, it is handwritten that refused to receive the notice. Served through latkan jari.
Page 8.
Yes, your lordship. Page 8 of my report.
Yes.
On the bottom, your lordship, it is written
refused to notice.
Yes, your lordship.
Served through latkan
Served
jari.
through latkan jari.
Yes.
Now, your lordship, they were aware about the hearing that was to be conducted on 29th. But they were not present over there also.
Lord, kindly ask my learned senior, my lord, when the writ petition was filed.
Your lordship, if the writ petition has been filed on 27th, if they were aware about the hearings to be conducted on 29th, they could have easily go there and participate in the hearing, your lordship.
Yes, you will do everything behind my back as soon as I filed a writ.
Have you received
No, because your lordship, the driver has also not.
Have you received the notice?
No, my lord. In 27th, at around 9 o'clock, the office staff went to my house without any official stamp.
Which
On
date?
my lord,
Which date?
27th, my lord, November.
Correct.
In my opposition, I specifically October. In specifically, my lord, I took in my opposition at around 9 o'clock. They went to give me a notice without any official seal. And first of all, my lord, kindly take the order they have passed. They are saying send me a notice. I refuse that. First of all, my lord, kindly take page 9 of their report. First order passed on 14/10/2025. And kindly take the, my lord, notice date. 14/10/2025.
Yes.
What prompted them to serve me that notice on 27th, my lord, when they already knows that 25th order is going to be passed? My lord, 14 is going to order has already been passed. One order. Notice would be given after hearing or, my lord, prior to the hearing.
No, 14 they have initiated.
The first, no, my lord, kindly
Your lordship.
12.
12. The
14 they already passed an order.
14 they have initiated the case.
Yes,
They have initiated the case.
my lord, that is my point.
Ah.
14, I also written a letter to them. Kindly take my writ petition, my lord, representation. Page, my lord, 26. My letter is also 14.
Correct.
If they could have taken cognizance on my complaint, my lord, representation, and over there I specifically stated DCR kagozti dekhen. And now, my lord, after filing my writ petition, they came up with a plea that no, nothing was produced by my driver at the time of, my lord, stopping the vehicle. The documents are system generated, my lord. They don't have any copy in their system.
Correct. So
No, your lordship.
And
correct.
first,
14th you have submitted the representation, but they have not taken cognizance of
nothing
the representation.
of that. Rather, my lord, on 14, they
Correct.
passed an order.
Correct.
They passed an order.
Correct.
Now, my lord, kindly take the next one, the impugned order according to them, 29/10/2025.
Correct.
All of a sudden, my lord, the third paragraph, it also appears that the driver of the vehicle, namely so-and-so, submitted a written declaration stating that no valid documents were present before him
Where
during
from
checking
you're
period.
Where from you're
Third paragraph, my lord.
It also appears the driver.
Report, my lord, from the report.
Yes.
All of a sudden, my driver submitted a written declaration to them stating that he did not equipped with any valid challan.
Correct.
And first time, my lord, I am seeing the government officials is receiving something without any stamp. Page 6 of that declaration, my lord. Kindly take in the report. It is a declaration, my lord. Page 6 in the report. Their report, my lord, page 6.
Yes.
Kindly see the declaration. Is there any stamp of the authority? My driver written to them. Neither it's addressing to something, only a, my lord, handwritten note. I also don't know whether whose signature it is. And on a basis of that, they passed an order. And now they are saying that no vehicle would not be released unless I prefer an appeal. I am praying your lordships invoke 226, my lord. This is a glaring example that after filing a writ petition, despite giving them
When you serve the notice?
Around 27.
When the notice was served upon
27. GP office, my lord.
GP office, no, authority. GP will.
No, my lord. They are the service upon.
That's the problem. You are sending to the GP.
My lord, in my affidavit.
Take care of.
Yes, affidavit. My lord, I am telling affidavit of service, sir. Because I sought for leave, my lord. It is, my lord, with the court's record, my lord.
Yes.
Sorry, opposition. Affidavit of service টা কোথায়? দেখাচ্ছিলি তো তখন।
Who is Samjad Ali Khan?
That is according to Samjad Ali.
Samjad Ali.
That is, my lord, the owner of the parking garage where is my vehicle is being parked by them. Respondent number 13.
Private respondent.
কোথায়?
The private respondent is item was delivered 31st day.
There's no report. There's no report.
My lord, I have served upon the GP office, my lord. I not independently, my lord, served upon them.
Then
That is GP office.
not served. Then
My lord, that is GP office. My lord, they itself acknowledge the fact that they got a receipt because
okay, you prepared an appeal.
my lord, my vehicle is being parked by them arbitrarily.
Appeal, I will directly consider the within 3 weeks the appellate authority will consider.
My lord, on basis of, my lord, this order, my lord, I will prefer an appeal where despite I have an.
You take all the points before the
My lord,
appellate
no
authority.
notice was served. I got
That's why
limitation.
you take all the, whether the sitting.
Notice was served, your lordship.
My lord,
As per my report, the notice was served,
I
your
am
lordship.
accepting their point that notice was served on me. My lord,
And
kindly take
moreover,
page-
they have
my
also
lord, kindly-
submitted an opposition. They could have easily annexed the documents that they were
in my writ
providing.
petition, every document is annexed. And my lord, kindly
The-
take their report, page 24. They have annexed the challan, my lord. If they don't have any copy with them, then where from they are getting it?
No, this is a
In their
reference
report.
challan.
Which challan?
In their report,
The
my lord, page
challan has to
24.
be given by your lordship. The challan has to be given by the BLRO Kharagpur one.
No, my lord.
But the petitioner has
It is
got
to
it
the
from
report annexed.
Jhargram, your
My
lordship.
lord, in their report, they have annexed. Kindly say last 3 page, my lord.
We have annexed it from our petition.
The orders
This is-
they are after subsequently.
This is a reference. This is the only annexure of your petitioner, your lord.
Nothing.
My lord, even then, my lord, it's their case that my lord, according to them, I had a challan, I didn't produce it. It is system generated copy, my lord. And for
No,
that
this is
reason,
not,
for
because it
1
is
month,
handwritten.
My lord, for
This
1
is
month,
handwritten.
I am, my lord, suffering. My vehicle is being parked in a parking, and I am not plying my vehicle, and my entire business got stopped.
Correct.
And now, my lord, they are just because they passed an order, they are asking me to file an appeal.
Why you not appeared before the authority?
My lord, 27th, I already filed a writ petition, my lord.
Your
Then
lordship,
say-
they
my
were
lord,
aware of
my lord, I will
29.
come. My lord, I will.
You
my-
are the sufferer. Your vehicle, you know your vehicle is before the authority. What is the first action? You will go to the authority first.
My lord, I lodged I made a representation on 14.
Correct.
Why they didn't pass any order on basis of 14, my lord?
Okay.
On basis of my representation, my lord, kindly consider that aspect. My lord, visualize the situation, my lord, just because, my lord, they passed an order without considering anything. If their case is that Jhargram BLRO issued the DCR, had they made an inquiry upon that DCR, my lord, in the entire order sheet, is there any reflection of that? Kindly take, my lord. Kindly take the order dated 29/10. They just only refer the rules, my lord, then passed an order. It is their case that Jhargram BLRO issued the DCR. I am not disputing that fact. For the sake of argument, I am accepting the point. Have they verified that documents from the Jhargram DCR?
First of all, why you are not appeared?
My lord, I already wrote a letter on 14 that yes,
Correct. No, notice. You have given the.
they didn't
letter,
do anything.
They have sent them.
My lord, kindly consider the one aspect. My lord, submitted a written representation to them.
Correct.
They didn't do anything. I filed a writ petition. Admittedly, I served notice upon the GP office.
Correct.
They received the communication. Immediately, they sent me a notice for hearing. Then, my lord, arbitrarily, they passed an order, not taking an account of my 14
Not arbitrarily, because the petitioner was aware of the hearing date.
Yes,
That
only
was
because
not
you
at all
communicated
arbitrarily.
me at
The
9
petitioner
o'clock.
was clearly
My lord,
aware of
9 o'clock
29th
can a official
November.
communication can be given to any person, my lord.
But
In my
you were
opposition, I
aware of
specifically
the,
my lord,
my
I will
learned
go
friend,
for
you
appeal.
were
Meantime, my
aware of
vehicle
the
be released,
hearing
my lord.
dates.
That's all.
My lord, that is my submission. Kindly consider the fact it is the, my lord, only tactics of the respondent to take a
Madam,
seal, my lord.
you show me the signature which you obtained from the driver.
Arey, eta oder
To
report
whom
annex
it
আছে।
has
Your
been
lordship, kindly come to page
page 6, which you
6
relied
of my
upon.
report.
Yes,
Yes,
6.
your lordship. This was just at the point of the time of inquiry. This was taken by the driver.
And
But your lordship, kindly consider two things, your lordship. The petitioner was aware of the hearing. The petitioner could easily go and place their case over before the authority. That is
I
one
was
point.
not aware, my lord. I was not aware. If they are saying that they
One,
pasted
and the
the
other point
notice
is,
in
your
any
lordship,
auspicious place, they could have taken a
even when
photograph
at the
of that.
time of,
Where is
if
that
your lordship
photograph?
kindly allow me to speak, your lordship. The opposition that has been filed by the petitioner, he could have easily annexed all the documents that he is actually now filing before
all
the
documents are
before
part
this
of my
honorable
writ
court, your
petition,
lordship.
my lord. All documents are part of my writ petition.
You have, my learned friend has
Do
filed
anything.
the.
All the thing will be by the court or the authority. You file the all document and writ petition, and authority will see it and all check.
No, my lord, writ petition, I have documents unnecessarily. Why should I, my lord, my lord, annex all documents
Your
in my
lordship,
opposition,
nothing
my
is
lord?
unnecessary.
I am not,
Nothing
my
is
lord,
unnecessary.
relying on
There is a
any document
remedy
except the writ petition which I filed on
there is an
affidavit.
alternative remedy that a petitioner can approach, your lordship.
Alternative
The
doesn't
petitioner-
barring this honorable court to
The
pass an order
the
in my
petitioner has not got applied his remedy before coming to this honorable court, your lordship.
Learned counsel appearing for the parties not allowing the court to dictate the
No,
order.
no, my
let
lord,
the
my
matter
lord,
go
no,
out
no,
of
no,
the
my
list.
lord, my lord, I am not, my lord,
Yes.
I am extremely sorry, my lord, I am extremely sorry, my lord.
Your lordship, kindly
My lord, I am extremely sorry, my lord.
Call the matter.
My lord, I am extremely sorry.
Your
my lord.
lordship, kindly, your lordship,
Give.
hear out the matter, your lordship.
Yes. Anybody is appearing? Report has come.
Yes, sir, I'm afraid.
Report has come. No report has come. This report was sent to the RJ office. When? Show me when the report was sent to the RJ office. This order was communicated. Take. By an order dated 24/11/2025, this court passed an order. By an order dated 2011, directed the Registrar General of the High Court of this High Court to place the list of the panel advocates of the High Court Legal Service Committee before this court today. But when the matter is called, no report has been filed. When the court has inquired from the officers of the from the ACO of the court whether the order was communicated to RG for compliance, no reply has been given by the ACO. In view of the above, the Registrar General is directed to take appropriate action against the ACO for not compliance of the order passed by this court. Let the compliance report be placed before this court on Mr. Pal, 4th or 8th?
Yes, sir. Yes, sir.
8th?
4th, sir. 4th will be, sir. 4th.
On 4th December at 1 p.m.
So 4th December, sir. Sir, December.
4th December. We are on 1st today.
Okay, okay. Sorry, sir.
Second.
I thought, sorry, sir. Thank you.
4 December. Yes. Call the matter.
Item number 21, your lordship had last time directed us that the CWC is required to be heard, lordship. We have intimated to them. Your lordship was desirous of a report from them, lordship. Just not appearing. Rather.
Lordship, may I make one submission, your lordship?
Yes.
Lordship, I'm appearing on behalf of the state and I'm being led by Mr. Chatterjee, who is appearing physically before your lordship. There is only one thing, lordship, that I need to bring to the attention of this honorable court. Actually, CWC had communicated with me, your lordship. Unfortunately, due to certain miscommunication, the same set of advocates had been appointed for the state as well as CWC. Now it appears, lordship, that the Maniktala PS has a stand which is not consistent with that of the CWC. If lordship kindly allows a week's time to CWC, although I am not representing CWC, but due to the genuine misconception, your lordship, if lordship kindly allows them a week's time, they will come back on the next occasion if lordship keeps it next week so that they can hire a new set of advocates, your lordship.
Lordship, only in the meantime, let the adoption proceedings then be stayed because
It has already been done, my lord, I believe.
if they have been placed for adoption, the child has.
That's why I want report.
Lordship, let it be stayed, lordship.
No,
because
it has
by
been
the time
done.
returnable data.
Adoption already done, my lord.
If it has been done, what would
I'll lordship add the new parents because lordship the CWC.
Okay, you add. If it is done, then you add.
Let us
here.
decide
I am
everything.
fixing next week only. As per the prayer made by the council for the estate, the case is adjourned till 8th of December 2025. Let the matter appear on 8th December, comma. The CWC is directed to file the report on the next date fix.
We are grateful.
5th of December.
8th.
I am extremely grateful, your lordship.
Next.
Item number 20.
কোথায় ও ফাইন বলছে yes
হ্যাঁ দিয়েছি
আমরা সার্ভিস করতে গেছি
স্টেটের থেকে আছে
এইটা আচ্ছা তাহলে ঠিক আছে ওটা আবার
Yes. Blood. I had placed a single judge order blood. Yes. By which a single judge blood clarified that this benefit of EWS should not be confined to blood. Those blood should not be exclude those blood whose blood caste are appearing in the list of OBC list. Blood. Now blood. There is a prohibition in the notification. I have annexed this notification in my supplementary affidavit. Now, blood, difficulty is blood. The list in which my caste has been indicated blood was set aside by a order of division bench by our High Court blood. A bunch of list was set aside by the order blood. Therefore, I was not belong to OBC at the relevant point of time. So I applied for EWS. Now, subsequent to that, again, state has made survey and issues blood fresh notification and included my caste into the category of OBC blood. Now, blood, this notification at page 8, particularly blood page 9, clause 5. Yes. One blood prohibits persons who are not covered under the scheme of reservation SC, ST, OBC. Only he can apply for. But now, I have applied for. Now, they have issued fresh notification. That's why they are not providing me with this copy. In fact challenges this memo in this affidavit on the ground that if I do not want to take benefit of reservation and I don't want to identify myself on the basis of my caste and category, state cannot compel me to identify me. Rather, Article 15 prohibits that nobody can be discriminated on the ground of caste, race, and etc. Now, I do not want to take benefit of OBC. I have applied for EWS. Let the state be provided with a copy of the certificate of EWS. That's my point.
Lordship, on the earlier occasion, it has been elaborately discussed, Lordship, that the petitioner belongs to scheduled caste category, OBC category, and whenever he wants to EWS category, he may forgo the OBC, but that should be forever. But in one scheme I am OBC, in another scheme I EWS, that cannot be. They are possessing two types of certificate, Lordship. Unless one certificate surrender and another certificate opt, that cannot be, Lordship. That is the
record
issue.
my submission that in fact I have given a statement in my affidavit.
And in the particular issue, he is claiming that EWS, Lordship, that before applying the said post, he has to obtain that category, Lordship. At that relevant time, he did not possess that category. Now he is claiming that still he is not get that certificate. So he cannot apply for that.
So how you will apply? Cut-off date is over. No, so far SSC concerned, because of this reason I could not update. This was pending, since long.
But the last date is over.
No, last date so far SSC is concerned, last date is over. This is not a case that because of my lack of diligence, I could not.
What is the stage of the further process of the authority?
They are yet to take any decision.
No. Lordship, so far this notification is concerned, he has to apply the I will forgo.
That's why if suppose the court will allow the directly surrender to the authority,
yes.
And surrender will come, the authority will treat it as cancel.
Yes.
In the subsequent exam he will be eligible.
That's why the petition will be taken as an EWC, not EWC.
Yes, in the subsequent exam.
This for the for the future and he will
lots
not
of-
take the benefit
lots
of the OBC. But
lots.
what about the post? What is the post?
Lordship, that is over. At the time of
Correct.
application, he is not possessing that.
Certificate remains valid for 1 year.
No. What is the last date of the submission of the application?
And that is over. The interview.
What is the last date?
Last date
What was the last date?
Last date is over. The last date of application. My lord, now the interview list is.
That's why I'm asking when was the last date and what is the status of today?
Today, my lord, the candidates are being called in for verification.
Where is the schedule? Where is the schedule? Where we have not prepared the report? Where is the schedule? Last date, schedule, verification, all the things. There will be a date.
It was last date was 26 September 2025. But before that, I have approached the authority and
No, at the time of application,
the verification is the preliminary stage.
he has to apply before applying the application.
Verification.
The interview card and interview letter.
No, that is yet to come.
Written test or
No.
Written. My lord. Written test, then there is interview, then verification, all of this. Now we are in the stage of verification.
But after verification, they will finalize the list of candidates who will be called for written test and interview. No stage has been met.
There are
We
separate lordship panel.
opportunities to edit. If
Yes,
he
yes.
did not possess, if he did not possess, he
Correct.
did not edit also.
At the time of application, he did not possess that
If
certificate.
suppose because he has applied for the EWS but it has not been uploaded because he is not carrying the EWS certificate.
My
He
lord.
was carrying the OBC
My
and
lord.
immediately filed the writ petition praying for
No.
allowing him
Not
to
immediately.
upload the application under the category EWS. Now
No.
the notification has come. He's telling that he has changed this total category. He wants that he will not be treated as OBC. He should be treated.
No, lordship, not immediately.
Let the court explain.
My lord.
Correct. Now, if today, because his application was there, it could not be uploaded due to he was not carrying the EWS certificate, he was carrying the OBC certificate. If today the court allows, okay, you surrender the OBC and you claim the benefit,
That's my
you will not claim any further benefit of
Yes,
OBC in future. If suppose the court will pass an order. So whether he will not be entitled because he has already filed, but due to
Yes.
the certificate disturbance, that's why you want to take it is at the verification stage. You can.
My lord, now it is not possible because in our rules we have said that for consideration of belonging to reserved categories, the certificates issued by the competent authorities of only the government of West Bengal on or before the last date of receiving online applications shall be treated as valid documents. That is
And the
a
report-
part of
The-
advertising.
File the report.
Very well, my lord. I'll file a
Yes,
report.
Mr. Samim, what will happen? Okay, no problem.
That I have applied as EWS
Correct. But
and
if the authority
in terms of the rules. Kindly please,
it will totally upset. Then what would happen?
in every year, in every selection process,
Next session you can.
again the same problem will arise.
No.
Only difficulty
Will not arise.
The court will allow, yes, you will be category
Yes,
EWS
forever.
certificate. Forever, nahi, but as per the authorities given the certificate. If tomorrow he will become a Lakpati, he cannot be EWS.
At page 17, I have applied in the month of July.
That time you cannot. No, I am not a I am claiming the.
I'll never claim. But that's my point. This is an exception.
Now see me file.
It gives me for the 7 days.
Well, in 7,
And again you will say that it
only difficulty is
you file by 4th.
My lord.
but verification will start.
I am fixing on it.
Verification will be starting from 4th possibly.
Okay, let the file of 4th. I am fixing on it.
8th. Well, in the meantime, EWS authority should issue the certificate.
The counsel for we are appearing for the respondent number.
Respondent number 5, my lord.
Counsel for the respondent number 5. That is the West Bengal School Service Commission. Is Directed to file report by number 2025, explaining the last day receipt of the last date of the application, comma, and the present status of the process rules with regard to the recruitment for the post of
assistant teacher.
recruitment for the post of
Assistant teacher.
assistant teacher
In one secondary and senior secondary level.
in the secondary and senior secondary. Let the report be filed by 4th December, serving the copy to the learned counsel for the petitioner. Let the matter appear on 8th under the same head.
Requesting me to submit before lordship. The next matter will take only for 1 minute, wherein my learned friend is ready and willing to give supply to me. Only my brothers are opposing, so that your lordship may dispose it of, directing the authority to give connection if required, take police necessary.
Subject to arrange the food of my court staffs.
I don't want him to submit before lordship. We are the back.
Excuse us. Kindly will not come back himself.
Give. But he requested me to submit.
With the lawyers, we don't have any limit to expectation. In our expectation.
After a long time, we are getting my lord in the appellate side. After a long time, we are getting my lord in this side.
Yeah, I am always here.
No, in the original side. Not.
So what is the prayer?
Well, prayer is to give electric connection on the basis of my application. It is the last connection I had.
Where is your application?
Application is page 31.
31.
Yes, sir.
You paid the amount? No. No amount is
We high have paid. Everything has been done.
Yes.
Only as they are preventing, they are not.
Really, because we are being restrained by their neighbors or friends, whatever they are saying. This is our land. Why are you drawing land, trying to install the pole on our land? That's the dispute between the parties.
Well, I believe a quotation has not yet been raised. They will raise the quotation upon payment.
You have not submitted the report.
No, report will not request. That is the admitted fact. No, they are not disputing.
Private respondent is also appearing.
Yes, you are
Where are they?
What is the concern? What is your objection?
What is my instruction is that it is an undivided property. And
but everybody is living.
Let the electricity be provided and
I have purchased, deed is there, record in my name. I have constructed out.
Without deciding the title, may submit. Lordship kindly allow us.
Your lordship kindly do not record my consent.
I will not, and I will clarify by providing the electrical will not create the right and interest of the party.
It will equity, and only one thing, Milord, the police may also be directed to help us, and they will comply the formality also.
Yes, we will comply. Hey, quotation down.
It's part of.
They'll issue the quotation, we will comply with the same within.
For grant of electric connection from the respondent, particularly the respondent number 5. Respondent number 5, senior manager. Who is the authority?
Station manager come to concern the customer care center. 1 second, Lordship, kindly allow me.
Station manager number 5.
Nando Kumar, 5.
Project manager.
This one number 5, Lordship.
Respondent number 5 is the customer care. That's
the station manager, Lordship.
Respondent number
5, station manager, Nando Kumar, customer care center. Subject to correction, my.
Yes. 5.
No, Lordship, station manager likha hai okhane.
Failed to consider the request of the petitioner, and the same is still pending. Appearing for the WBSCDCA. Submit that.
The problem is
right to inspect the premises, but there was an obstruction from the private respondents, due to which the inspection could not be carried out and electricity could not be provided. Then an advocate appearing for the private respondent submit that. Private respondent submit that. The petitioner is not the owner of the property in question, and he is a legal occupier.
Yes.
He is a legal occupier. He is a legal occupier. And as such, under the private respondents is objecting for grant of electric connection. Consider the submission made by the counsel for the respective parties. This could find that the petitioner has applied for grant of electric connection What is the date? 23rd of June 2022.
My lord, 15th of
It is settled law that
22.
electricity is the essential service.
My last page, 31 page. Date June 15th June 22.
That even the illegal occupier is also entitled to have the electricity connection unless he is evicted from the unauthorized occupation in accordance with police. In view of the above, the respondent number 5 is directed to provide the electric connection to the in the premises of the petitioner within 4 weeks from the date of compliance of all formalities by the petitioner.
Number 6 will be directed, Lord. To protection.
Number
To
6.
provide protection. 6.
It is further made clear that the grant of electric connection will not create any right title and interest of the petitioner over the property in question. The learned advocate appearing for the WBSCDCL submits that there was an obstruction for grant of electric connection. Accordingly, the inspector in charge, Nanda Kumar PS, is directed to provide police assistance to the officials of the WBDCL at the time of inspection of the premises of the petitioner for grant of electric connection, as well as at the time of grant of electric connection in the premises of the petitioner, to avoid any untoward incident untoward incident. Full stop. It is made clear that the fee for the police protection shall be borne by the petitioner.
I'll add one line if required, because if required, otherwise we will unnecessary.
I'm sorry to disturb my lord.
Beyond my lord, once again, lordship.
Your lordship,
my learned friend is my lord saying that my lord is very correct, but beyond our limit, one of our officers, my lord, have been my lord, has been displeased your lordship's my lord regular course of action. If lordship, be not so harsh. Grateful lordship.
তোমার নামটা নিলাম
leave, my lord. I apologize, my lord, at this moment I am bothering your lordship. My lord, under compelling circumstances, I am mentioning a matter, my lord. Want to have a baby. Now, my lord, they have adopted the process of in vitro fertilization. Now, my lord, the female partner is undergoing the last menstrual cycle, my lord. That is, my lord, the urgency.
What?
The female partner is undergoing the last menstrual cycle, my lord. My lord, this is the urgency, my lord. They want to have a baby through IVF, my lord.
So what do you want?
So, my lord, I want, my lord, because the age limit has expired. Now, my lord, I want the relaxation for that. But unless a relaxation is granted by this court, my lord, I cannot undergo the process of IVF.
What is the age?
Age is, my lord, 51.
11 तारीख को करो, 11th को अर्जेंट मोशन में करो.
Wait.
Yes, next call. No further, no. Call the list.
So far as item for my behavior in item number 20.
You persons should remember,
I tender my
you are appearing before the High Court, not the munsibs.
I raise my point. I am tendering my unconditional approval.
Yes, give.
That kindly consider. I have put the is the evidence. Well, the case of new commercial connection.
New commercial connection.
My lord, petitioner applied for the commercial connection and thereafter petitioner also paid the quotation amount. Thereafter, my lord, electricity department has started work, but after some time they stopped the work due to some unknown reason. Thereafter, they communicated one letter, my lord, kindly come to the page.
Whether earlier electricity connection was provided to you?
No, my lord.
Yes.
We have just started to work. After started work. After install it.
Where is the letter? Where is the rejection?
No rejection, my lord. Kindly come to the page number 36. My lord, last 2 lines, my lord. Considering the fact as stated above, you are hereby requested to resolve the ROW issued and let this office known so that the main can complete the rest of work. And my lord, this is the issue of ROW. I am advised to resolve ROW, my lord. I am advised to resolve ROW, right of way.
I tell you, lordship, subject.
So, if you not provide the ROW, how they are?
My lord, this is the Panchayat road. Panchayat road.
Yes.
May I tell, lordship? But this is a case of a admittedly industrial load of 11 kV, bulk consumer. Your lordship knows of the 50 kilowatt is a bulk consumer. Now here it is required the certain piece of work is necessary to be done. We have already recruited the agency for doing the work. It is the admitted position and they have already admitted in the writ petition. 18 pole is to be installed for laying down the wire. And where we have already installed the 10 pole out of the 18 pole.
84.
No, 23. 10 out of
total pole is required?
18, lordship. And 18, lordship. And out of that, we have already installed 10 pole, lordship.
Yes.
Now, at that juncture, in the midst of the doing the work, we received stiff resistance from the local people, lordship. And the workers' life was in jeopardy. So we already intimated to them that wayly permission is required, lordship. And in to that, if your lordship kindly turn to page, thereafter the joint inspection has been held, nothing has been done, and page 39.
Yes.
It appears my learned friend client has already made an application before the concerned district magistrate. It is pending before lordship. Now, if at this juncture, if the district magistrate pass the necessary order, and on the basis of that order, your lordship, police help be given, we are ready and willing, because we are not standing on, we are ready to give the connection, but we are getting the steep resistance from the local authority, lordship. This is the precarious situation we are facing, lordship. But we are getting
on behalf of the state,
My lord, there has been a mass petition stated from the local authorities. Though with regard to this representation, I do not have any instructions as yet, but this representation seems to be pending as of now. My lord, I'm led by
23 required.
Yes.
But
Okay.
the representation is
13
pending
page.
before them, we have already
Okay,
sent it, Lordship. Now, Lordship, let them consider what they are answering.
No, that's why this maybe there is a resistance, but if the person wanted to install the set up a industry and electric connection is required, so it has to be seen by the authority.
My lord.
Only resistance of the public it cannot be. It has to be seen what is the ground of the resistance.
Then kindly, Lordship, guide the representation be considered accordingly.
My lord.
My one correction, I have told you with the but in page 32, it has been specified the 13 pole is required. 23 poles required.
Out of 23, 10 pole already installed, 13 is still pending.
Page 32.
Page 32. My lord, at the top.
Page 32.
Page 32 at the top right side.
Yes.
We have made all endeavor to give the connection, but the surrounding circumstances compel us to register ourselves, Lordship.
13 poles, pending 13, 23 poles is required.
23 pole is required, 10 already installed, 13 pending.
Where is your application?
My lord, kindly come to the page number 39.
39?
Page 39.
No, the grant of electric and this electric connection, commercial electric.
Page 31. Tomorrow application.
31.
Where is your application?
Page 31.
31, my lord.
31.
31 is the quotation issued in the
Sanction
base of
letter.
the. On 10/6/2005 quotation issued, and on the very few days we have recruited the agency for doing the work, Lordship.
It is your recorded land.
No, my lord, Panchayat land.
Land of Panchayat.
Land road, my lord, connect my land, my lord.
It is your land where you want to set up the industry.
Yes,
for
my lord. Yes, yes.
electricity connection.
Yes, my lord.
The petitioner, being the sole proprietor of the newly constructed factory, namely MR Enterprises at village Penita, district Nadia, had made an application before the WBSCDCL for grant of commercial connection for the purpose of his new factory. A quotation was sent to the petitioner by the WBSCDCL for a total amount of rupees. What is the 2 lakh?
It's a 3 lakhs odd, Lordship.
You mentioned 2 lakhs?
No, my lord.
Of rupees 3 lakh
3 lakhs 30,000
232. 32. Full stop. Have you submitted this amount?
Yes, my lord.
In terms of the quotation of the WBSCDCL, the petitioner has deposited the said amount, and the WBSCDCL has awarded the work to the agency.
Yes, on 30 August 2025.
To the agency on 30 August 2025. The agency has started full stop for providing commercial electric connection in the factory of the petitioner. Altogether, 23 poles is required to be erected, out of which 10 poles have been erected, and the agency could not erect the 13 poles due to the agitation by the villagers. Subsequently, the WBSCDCL, by a letter dated 12th of September 2025, informed the petitioner, requested the petitioner to resolve the right of way within bracket ROW issue and to inform the office of the WBSCDCL so that the WBSCDCL shall complete the work for providing electric connection in the factory of the petitioner. Full stop. As there is a agitation from the local public of the said area, and according the petitioner has made a request to the district magistrate Nadia, praying for granting necessary permission for erection of remaining 10 poles for getting commercial electric connection in the factory of
Remaining 30 poles.
remaining 10 for getting electric connection in total, remaining 10 posts, in total 23 posts for getting electric connection in the premises of the factory of the petitioner. Counsel for the petitioner submit that the representation submitted by the petitioner before the district magistrate dated 13th October 2025 is pending. If this court direct the pending and no decision has been taken. Full stop. Learned counsel appearing for the WBSCDCL submit that if the petitioner provide the permission from the concerned authority, the WBSCDCL shall take appropriate step for providing electric connection in the factory of the premises on compliance of all formalities by the petitioner. The learned counsel appearing for the state submit that as the petitioner has made representation only on 13th of October 2025, if a direction is issued to the concerned district magistrate, the district magistrate will consider the representation of the petitioner and dispose of the same. In view of the above, the district magistrate Nadia, respondent is the respondent here.
Yes, yes.
Respondent কত বলে? Four. No, four. Where is the four? ADM is not here.
Being the particular
You're not made party.
district magistrate 8.
Director district 8.
8.
District magistrate Nadia, that is respondent number 8. To consider the representation submitted by the petitioner on 13th October 2025 for grant of permission for effecting new service connection at the premises of the petitioner by erecting about 23 posts. Police. So the district magistrate is directed to consider the submission and consider the representation submitted by the petitioner dated 13th October 2025 within a period of 2 weeks. Within a period of 3 weeks from the date of receipt of the copy of this order. If necessary, the district magistrate can provide an opportunity of hearing to the petitioner and to pass necessary order and to communicate the same to the petitioner within a week hereafter.
My lordship, an opportunity of hearing to the petitioner as well as the concerned authority, lordship.
Opportunity of hearing to petitioners, as well as the connected officials and the persons affected.
I am deeply obliged.
And the persons affected. ठीक है? Okay. Next.
Item number 25.
Dispose of,
for the petitioner lordship. Matter is for new electric connection in favor of the petitioner lordship. The petitioner made a representation, made an application.
Item number
25. Subrata Tar.
Yes.
Lordship, petition.
Have you served the copy?
Eh?
Have you served the copy?
Yes. Delivered.
Not delivered.
Delivered.
WBSCDC is there. Nobody is there. He was present here. Not
Yes, delivered.
Yes.
Firstly, petitioner made an application for the new connection with the permission of the petitioner in the month of February 2025.
Where is your application?
That application is annexed P5 of the page 59, starting from the page 59.
Page 59. Commercial connection. Commercial.
Yes, commercial means plate for the 7 kilowatt load. Right, it comes under the commercial.
Correct, commercial.
So that is after the inquiry, report was submitted, petitioner quotation was issued, and petitioner was directed to submit the 34,447 rupees. Petitioner submitted it. Pole was installed.
Why?
Thereafter, process authority is silent.
Why it has been stopped?
Actually, I do not know what is the reason behind it. I came to know that the 163 BNS Act was lost because of the replacement of the pole. Now I am coming that photograph with the photograph. I came to know that the one application under section 163 of BNS Act.
You do one thing. Who is appearing for the WBSCD? Just you issue the notice to him. Come day after tomorrow.
I do not know who is appearing on behalf of the BP.
Just before the matter. What is the name of advocate का नाम क्या था? Respondents का? Yes, Mr. Madhusudan Shah. Just last matter he had appeared, na WBSCD. You send the copy to him. Because report is required in this matter.
Yes.
Otherwise, it cannot be.
Because of the rule that has been installed, in spite of that, they are providing electricity in favor of the petitioner.
Petitioner has filed affidavit of service showing that copy of the writ application along with the documents have been duly served upon the respondents, but none appears on behalf of the respondents. Accordingly, the petitioner is directed, according petitioner is directed to inform the next date of hearing to the learned advocate of to the authorities and to file affidavit of service on the returnable date. It is made clear that on the date fixed, if none appears on behalf of the authorities, appropriate order will be passed. Let the matter appear on 16th December.
Also, I will serve the authority.
Serve the authority, informing the date.
Yes, intimating the date that the matter will appear on 16th and before that.
Private respondent delivered. You are there after a and now it is like earlier it was. Yes, next.
May it please your lordship. My lord, I am appearing on behalf of the petition in this matter. This is my application, my lord, praying for restoration of electricity supply and installation of a new separate electricity supply, my lord, installation of a new electric meter in my favor, my lord, inside the premises, your lordship. Now, my lord, I am a tenant in a property where respondent number 6 is the landlord. Now, my lord, at the outset, I'll indicate page number 46. My lord, 46 and 47, these are the current electricity bills. My lord.
Why it hasn't disconnected?
Yes, my lord. Now, my lord, also, my lord, I'll indicate, my lord, after filing of this writ petition, my lord, the respondent authorities have issued a notice to me, my lord. My lord, this is the notice which was issued to me, which says, my lord, if my lord kindly takes if my lord kindly takes paragraph number 1, that on 18th, my lord, we received a complaint from the writ petitioner, consumer number such and such, for of supply via docket number such and such. Upon inspection, we found that the existing meter number such and such was burnt. Petitioner has paid the replacement cost of the burnt meter on such and such. Thereafter, we deputed our men on for replacement of the burnt meter, but objection was raised at the site by the landlord, private respondent Mr. Joyantopal, and he locked the meter room. As a result, we were unable to replace the burnt meter. This is the main
difficulty that is happening over there, Your Lordship.
Yes, who is for the private response?
I am for the private response,
Yes.
my lord.
I'm
They
for the
are
state, my lord.
they are occupying around 400 to 500 square feet shop in the petitioner in the Goriahat area, and it is they are just paying 285 rupees or something rent, and that there is a suit is pending. Earlier also burn took place due to their misuse of meters over use of the electricity consumption. This is the last situation how it was there, the meter room. We had around expenditure of 1,50,000. We have give them a notice that verbally notice that this will be, we will make the expenditure, and both there are two tenants, including them, there are two tenants, and my shop is there. We will distribute the cost. Other tenant had paid his part of 50,000 rupees. That is the bill. And here my lord, I have all the invoices, including the GST bills and constructions cost of all the meter box and all. We are just not against their having the electricity connection. Let them, they have verbally initially agreed that they will pay their share. Now they have completely disagreed.
What is the total amount?
Total amount is 1,50,000. They for total construction of the entire electricity meter box, including construction and all the wirings and all, everything was gone. There was no connection, and we had to construct the entire civil engineering works are done. Also, my lord, entire pipe, plywood box, bulbs, everything was there. We have all the bills, my lord. If my lord required, I can submit. All the documents are here with us, including the GST bills of the construction or walls and all.
There is no electric connection in any of the room.
My lord, I
There is
did.
no electric connection in any of the room.
No, right now there is that. Yes, when the electricity.
This meter is of the petitioner only.
Yes, my lord.
Petition, yes, my lord. Kindly see the email. We had mail on the next
Okay,
date also.
This is the meter of the petitioner.
No, all meter box was there.
No, all meter have been burned.
Burned. Then we have
How
to.
you are enjoying the electricity?
We then have to make the construction.
How you are enjoying the electricity was when all the meter has been burned.
Then electricity, we repaired all the entire electric box and meter box, and all the pipelines were changed.
Obtain the new connection.
We got the new connection. Yes, they have initially agreed, my lord. We have also sent the email to the concerned authority that son of the petitioner initially agreed that, okay, I will pay, we will pay our share, you will pay your share, and we'll construct.
That is correct, sir.
After that, they are turning back and saying that we will not pay. When the work is done, now they are saying that we are not pay, and they are paying. And very Goriahat is the one of the heart in the South Calcutta, and they are paying nominal amount. We are not asking for any rent.
That's why I am coming to that. How many meters in there?
3 meters.
3 meters. His meter and all 3 meters burned.
Burned.
Correct. Then you have made an estimation of
50,000.
50,000. So
Other tenant paid.
He had agreed, but he has not
No paid.
Now, now you have changed your meter and you are enjoying the electric connection.
Other tenant is also enjoying there.
All other two are the enjoying. So you are not allowing him because you have not paid the amount. This is the only dispute. If he paid the what is that share?
50,000 rupees.
50,000.
We have the bills. It's not that we are.
Pay the 50,000. You will allow and new meter given and all the things. You will. Yes.
Now, my lord, we'll kindly look at the intimation ones that's made by the CSC. The replacement cost, the cost that was incurred, my lord, that has been already paid. That's the admitted, my lord, by the CSC. CSC authorities, your lordship.
CSC.
Now, my lord, this dispute, my lord, pertains, my lord, this dispute is a long drawn dispute, my lord. Even if your lordship kindly takes page number 33 once, this is the, my lord, prior dispute where the petitioners have previously come up before this honorable court, my lord, seeking directions for a separate meter. Now, my lord, this honorable court was pleased to grant, my lord, the liberty to the petitioners to approach the CSC authorities. Accordingly, a different meter has to be made, my lord, in terms of the order in favor of the petitioner.
Yes.
Now, my lord, this was already done. Thereafter, my lord, in the year 2012, several notices were made, my lord. Even this, my lord, the situation where the electricity meters are burning, my lord, this is nothing but a ploy of the landlord, my lord, to evict the tenants.
Okay, but you admitted that you will pay the amount. Where the
my lord, admitted, my lord, this is their contention, your lordship. My lord, we have already paid, my lord, to the authorities.
But where is the amount?
My lord, it's admitted by the authorities itself, your lordship. Will kindly take the intimation, my lord, which I have just handed over.
Correct. They are not allowing.
Yes, my lord.
Hmm.
Lordship will find
Hmm.
from the first paragraph, second line. Petitioner has paid the replacement cost of the burnt meter on 19th September 2025.
Correct, correct.
To the authorities, my lord, we have paid. Now, my lord,
I'm appearing for the state, my lord.
My instruction, my lord, only I have got the complaint against the burn meter, my lord. We went there for replacement of the burn meter, my lord. But we got objection by the landlord, my lord.
How many meters were burned?
As per my information, one
Only
burn
one.
meter.
This is a petitioner.
Yes.
Other two, there is no replacement.
One burn meter, we have got information, my lord. Others, my lord, we don't have any
No,
information.
because now the landlord is telling that, or the other the person is telling. He's telling that there are 3 meters. All 3 meters were burned. Whether it is correct statement or not.
Yes, we had also received another tenant. This is Nilanjan.
So far as our information, there are 10 meters, my lord. But my lord, we need to check, my lord. Certain others, but not, my lord.
Yes, my lord. Yes, I am appearing for the state, my lord. I have taken a instruction, my lord. Kindly see the next page, my lord. Second paragraph. On 20th November 2025, as per the requisition of Sri Devasis Ghosh Senior Engineer CSC Limited, Calcutta, South District, necessary police assistance was provided. Replacement of burnt electric meter of the petitioner at such and such one Wazir Wahra, son of Mohammed such and so, on behalf of the Mesas Radhu, that means petitioner here, refused police assistance and stated that the petitioner is awaiting the order of the Honorable Court, Calcutta, in connection with the instant date petitioner, so requested not to replace the said meter at this place. As such, entire police force and CSC team returned back. Subsequently, a letter was submitted by learned advocate Srimati Saju on behalf of the petitioner with a request to refrain from taking any steps as the matter is sub judice.
Yes, that's
My instruction is, my lord.
The authority has taken the police.
Yes,
for your
yes,
refuse.
my lord. Yes, my lord. We have also given the assistance.
No, my lord, kindly comes to
The
page number
petitioner
14.
refused
Client
the
is here, not
police
the
assistance.
client is not clean hand.
My lord.
Once the authority went, they have taken the police assistance. You refuse
Yes.
not to
No,
come.
my lord, kindly. Do not take me amiss, your lordship. My lord, what has happened is the police authorities have come only after filing of this writ petition. Now, my lord, my clients
See,
being a
filing
layman.
the writ petition, what is
My lord,
happened?
my lord,
If it electricity provided,
I
then
appreciate your lordship. I bow down.
Then
My lord, my client being a layman, since the matter was
what was
subject.
layman? He's the owner of the one shop.
My lord, absolutely, your lordship. But what has happened is because my lord, she had an idea.
Taking the matter in the month of February.
My lord, kindly, my lord. My lord, that was a mistake on our part. My lord, that was a mistake. Kindly appreciates, my lord, what my prayer is today, your lordship. My lord, only a installation of the electricity meter where, my lord, I am not being obstructed. The meter may be installed in our premises. Any cost, my lord, incurred will be, my lord,
that
will
is
be
not possible because they will keep their shop lock and key. Fire took earlier twice. If fire this time took from their meter, change of meter only one meter, but entire meter box was changed. Entire line had to be changed. If we allow them to give a separate box,
Take information from the department, my lord. Only we got information about the burn meter, only 1 meter, my lord. Nothing else, my lord. Only one.
but we had to change. We had to change the entire box. This is the another.
Authority is telling.
Yes, yes, my lord. We had to change the box. This is the another. Kindly see another tenant. Another tenant had paid the 50,000 rupees.
kindly appreciate, my lord. This is a ploy. Already civil suit is pending.
Why another tenant will pay, my lord? I am just asking myself a question. Why another tenant will pay 50,000 rupees?
That is a ploy, lord.
Why he would pay support me, my lord?
File the present writ application. Praying for a direction upon the respondent number 2, 3, and 4.
Entire meter box they are not paying. Enjoying a
CESC Limited for providing for installation of new meter and separate electric meter in the premises of the petitioner. For the petitioner, the petitioner was enjoying the electric connection, but all of a sudden, when the burning, it was burned, When the meter was burned?
17th September, Your Lordship.
On 17th
17th September 2025.
The meter of the petitioner was burnt according to the
19th, my lord.
applied
17th.
for change of
17th
burnt
September 2025.
to the CSC. The CSC.
No, madam.
But have you deposited the amount of the burnt
Yes, my lord.
meter?
It's deposited. My lord, indicate the page number as well. From page 46, Your Lordship will find the replacement charges, my lord. That's
And
deposited.
according the petitioner has paid the charges for replacement of the burnt meter. But in spite of the same, the authorities has not provided the electric connection by changing the burnt meter fully. And at counsel for the private respondents submit that there are altogether 3 meters, and due to the incident of fire, all 3 meters have been burnt, and according the petitioner and according the private respondent have estimated the cost for change if all 3 meters
Meter box, my lord.
meters and the entire meter box to the tune of rupees 1,50,000, and the son of the petitioner agreed to pay rupees 50,000 being their share. Full stop. The other tenant has already paid rupees 50,000, but the petitioner is not. Now the petitioner is not paying the rupees 50,000 which the private respondent has invested for the meter box and change of the new meter. And at counsel for the CSC submits that has handed over a communication dated 15/11/2025, wherein it mentioned that on receipt of the complaint from the writ petitioner for change of the existing burnt meter and replacement of the new meter, the CSC has deputed their men for replacement of the burnt meter, but the private respondents have raised objection and locked the meter room, due to which the CSC authority could not able to replace the burnt meter of the petitioner.
Right there, thrice, my lord.
Yes, I am recording. Full stop. Subsequently, after filing of the writ petition, again the CSC officials depute the persons on 20/11/2025 for replacement of the burnt meter with the new meter in favor of the petitioner and also requested the police authority for grant of police assistance for supply of replacing of the burnt meter. But the petitioner has not cooperated with the same, due to which the meter could not be changed.
Direction.
The learned advocate appearing for the estate has submitted the report and submitted that on 20/11/2025, as per the requisition of the CESC Limited, the police assistance was provided for replacement of the burnt electric meter of the petitioner, but the petitioner has refused to take the police assistance on the ground that he has already filed the writ petition and he is waiting for the order of this court. At the learned counsel for the respective parties, there is no dispute that the petitioner was having the electric connection, but the same was burnt. On receipt of the request of the petitioner, the CSC authorities are ready and willing to provide the electric meter, but there was some resistance from the private respondent. Subsequently, the CSC has also taken the police help, but the petitioner refused to take the police help on the ground that he has already initiated has filed the present writ application. The claim of the private respondent that the petitioner has to pay rupees 50,000 being the cost for the replacement of burnt meter to that of the new meter as well as the meter box as well as the meter box. The petitioner is denying for the same and he submit that he has already paid the amount to the concerned authority for replacement of the new meter in place of the birth meter. So considering the above, this court finds that with regard to the dispute whether the petitioner is required to pay rupees 50,000 to the private respondent or not, this court cannot decide in the present writ application. Admittedly, the CSC authorities are ready and willing to provide the electric connection, electric connection. Accordingly, not electric connection, replace the burnt meter to that of the new meter. Accordingly, the CSC is directed to replace the burnt meter of the petitioner meter by replacing a new meter within a period of 1 week from the date of communication of this order. Communication order.
At the existing service position, my lord, and my lord.
What? Existing service position.
Yes, my lord. And my
Right
lord,
there.
my lord, if
Yes, providing service.
breaking up the
In
padlock.
the present service position, full stop. If the CSC officers found from any obstruction from any corner, comma, the concerned police, who is the authority? Officer in charge Guardian. The officer in charge Guardian police station shall provide necessary police assistance to the officials of the CSC for replacement of the burnt meter to that of the new meter in the premises of the petitioner. If the authority, CSC authorities require that any lock is there in the meter board and that is to be open and the private respondent are not cooperating for opening of the padlock, comma, the petitioner shall break open the padlock in presence of the police officials only for the purpose of getting the service line to the existing service
Installing the meter.
service line for only for the installing the new meter in place of the burnt meter, and thereafter the petitioner shall put a new lock in the said meter room and will hand over the key to the private respondent in presence of the police officers.
Well, if I may humbly intervene, well, my only
The petitioner, the cost of, if any cost is to be paid for the police assistant, comma, the petitioner shall bear the said cost.
well, my only humble prayer that the installation will be made within my within the tenanted property. Lord.
Which portion is made there? That will be
existing place.
existing
Existing
position.
Existing position is, my lord, is under the control of the respondent number 6. This is the difficulty.
अच्छा पेज चल
This is the dispute since 2008.
Yes, next.
affidavit of service টা দিয়ে দে
Affidavit of service capital.
এটা পেয়েছেন এটা
yes
for the petitioner my lord. I have sought my lord, this is my affidavit of service. I am for the state my lord. In occurs prayer my lord, my petitioners applied for the certificate for the economical weak certificate my lord. Previously
you are not having any other certificate, OBC, ST.
No,
you are
no,
having any other certificate?
no,
No.
that is not petitioner.
Who will issue the EWS certificate?
Additional district magistrate my lord.
So it has to be verified whether you are coming under the
Yes, my lord. Kindly see my lord, the page 18 my lord. Page 18 they have issued 2024-25, but 2025-26 year.
Subsequent your income might be increased.
No, my lord, I am the student, my lord. I am the student.
Where is that?
My lord, last page, my lord. Page 19, my lord, is my application. Applied for pending, my lord. Directed the. Applied, my lord, on my lord, 4th, my lord.
Which page?
Page 19, my lord.
Page 19 and accept P5.
Yes, my lord.
This is the application.
Yes, my lord. This is the application. Firstly, online application was submitted. Thereafter, my lord, print out and my lord, sign and my lord, submitted this.
Earlier it was provided to you.
Yes, my lord.
Where
Page 18, my lord.
18.
Yes, my lord.
This
And
is
accept P4.
Valid for 24-25.
Yes, my lord.
EWS.
Yes, my lord.
So subsequently you are applied again.
Yes, my lord.
On when you applied for?
My lord, July, my lord. 4th July 2025, my lord.
4th July 2025. It
Yes,
has not been considered.
No, my
No.
lord. No.
Yes.
My application is pending, my lord. Basically directed the respondent number 4 to verify and pass the
Issue.
if applicable.
Mandatory.
No, my lord.
Can I pass a mandatory order?
If applicable, my lord, subject to guidance.
Yes.
Yes, my lord. Yes, my lord, they have issued this.
The grievance of the petitioner in the present date application that for the year 2024, the additional district magistrate, Jharkhand, West Bengal, had issued EWS certificate to the petitioner on 28th of March 2025. Subsequently, again on 4th of July 2025, the petitioner has applied for EWS certificate, but the said application is still pending. Neither the authorities have issued EWS certificate nor have rejected the claim of the petitioner. Accordingly, petitioner has filed the full history, rejected the counsel for the petitioner submitted that the application is pending before the additional district magistrate.
Yes, my lord.
Additional district Jharkhand and pray for a direction upon the concerned authority to consider the application submitted by the petitioner and to issue the certificate, issue EWS certificate in favor of the petitioner. Learned counsel appearing for the state.
Yes, sir.
State submitted as the petitioner applied for the certificate, EWS certificate before the additional district magistrate Jharkhand. Accordingly, if a direction is passed, the additional district magistrate will consider the application filed by the petitioner and will pass appropriate order.
My lord, she is already selected, my lord, for the post of SSC, my lord. So, my lord, short time you given.
For the petition submitted, the petition has already been selected in the post of
state level selection. In teacher is a state level selection.
Selected as teacher in the state level selection, and as such, state level selection, but due to unavailability of the EWS certificate from the petition is facing great difficulties. Had the learned counsel for the respective parties, this court find that the petition already made. This court find that on the earlier occasion, the additional district magistrate Jharkhand had issued the EWS certificate to the petitioner, and subsequently again the petitioner has applied for EWS certificate on 4th of July 2025, but the same has not been considered and is pending before the authority. Accordingly, the additional district magistrate Jharkhand, the respondent number
4, my lord.
4 is directed. 4 is the district magistrate. Additional is 5.
Yes, my lord. Sorry, my lord. 5.
5 is directed to consider the application submitted by the petitioner dated 4th July 2025 for grant of EWS certificate, and if the petitioner is entitled to get the EWS certificate, an EWS certificate shall be provided to the petitioner within 2 weeks from the date of receipt of this order. If the authority find that the petitioner is not entitled to get the EWS certificate, he shall give an opportunity of hearing to the petitioner and shall pass reasoned and speaking order within 2 weeks thereafter. Next.
My lord, I am for the petitioner, my lord.
But I am for the state.
My lord, I am appealing on behalf of the private. My lord, here, my lord, the order of the SDO in the capacity of maintenance tribunal has been challenged. Similar matter was filed earlier. Your lordship heard the matter because of some shortcomings in the drafting, my lord, and the prayer portion with liberty, my lord. This petition is being again filed. Now, my lord, when the matter was mentioned before your lordship for urgent hearing, my lord, your lordship indicated that whether there is a appeal provision in the act itself. But I have checked, my lord, the appeal provision is there, that is section 16, but that prefers the guardian. The appeal portion. Yes, sir.
Sixteen,
my lord.
Yes.
My lord, any senior citizen or a parent, as the case may be.
No, but it has been clarified by the division bench of this court. Any person.
Any person, yes, grateful.
There is an order of
Then, my lord, liberty may be given so that, because already we are late. That
60 days,
part was
60 days time is there.
Yes. 60 days time is over.
Ah.
That is why my lord, some concession for the lordship, my lord.
Well, he should prefer a section 5. And no, limitation act একটা এ বার আছে।
Section 50 is there, man. Council, the petitioner submit that.
No,
Due to inadvertent, the petitioner has filed the present date application challenging the order passed by
the SDO, my lord, maintenance tribunal. Dated, my lord, 23rd of September 2025.
September 2025. He submitted. Subsequent to the filing of the present date application, the petitioner came to know that there is an appeal provision under the Maintenance and Welfare of Parents and Senior Citizen Act 2007. Accordingly, pays for withdrawal of the present date application with the liberty to file an appeal before the appropriate forum.
My lord, respondent number 8 is the owner of the residence and the allowed.
My lord, then I will present my case, my lord. This is absolutely wrong placement, my lord. They are challenging their own deed executed.
520 is dismissed.
সেটার জন্য তো আমি কিছু বললাম না।
File an appeal before the appropriate forum. Full stop. If there is a delay in preparing an appeal, the concerned authority will the petitioner shall file an application for controlling the delay. And if any application is filed by the petitioner, the authority shall consider the application in accordance with law. By taking into consideration the petitioner has filed the writ application, due to which he could not file the appeal within the prescribed time.
All the properties, my lord, is next.
If any appeal is prepared by the petitioner, the same WPL is
My lord, the parents-in-law, they have gifted, they have challenged their own gift, my lord.
My lord,
And they have been converted to Christianity. That is the That is why I did not utter a single word. My learned friend is deeply obliged.
Yes, Lordship, I'm for the private respondent number 4, your Lordship.
Who is for the petitioner?
29, my lord. Joyanto Mitra is appearing. Joyanto Mitra is appearing for the petitioner, my lord. He has requested, my lord, only not today, my lord.
Not today.
Your Lordship, my family member has died. I have to go Nadia district, your Lordship. My grandfather has died, your Lordship.
So what do you want? You are appearing for?
I'm appearing from 11th December, your Lordship.
Appearing for 11th. Come on, 11th. As per the prayer made by the council for the respondent, case is adjourned. Let the matter appear on 11th December under same.
Grateful.
11 December?
12 December, 10 December, your Lordship, enter.
12 kori den.
I'm grateful, Your Honor. I'm grateful.
Yes, next.
30, my lord, I am for the petition.
I'm appealing for the state respondent.
My lord, there is a affidavit of service. State is served, not private respondent. Other is affidavit of service. For the matter, but before I start, my lord, may I file one supplementary affidavit? May I file a supplementary affidavit? Some documents, my lord, could not be filed, my lord, at that. I'm serving 30 to 30.
Yes.
What is the prayer? This matter, my lord, relating to appointment of the
about the maintainability.
My lord, may I submit?
It does not lie.
This is my matter, my lord. May I submit first?
Maintainability,
that can may I submit?
No, but maintainability point I'll have to ask first.
Let me argue the first with regard to the
Yes.
maintainability.
Lordship kindly sees the kindly comes
The prayer is very innocuous.
That's
The-
correct.
No, no,
They
no,
are
but-
raising the point of maintainability. Let the court hear.
Lordship kindly comes to
What is the point they are raising?
comes to page comes to Lordship comes to the prayer of the writ petitioner. This is at page
Page 28, paragraph B.
page
prayer
28.
B.
Lordship, kindly have a look. Page
Prayer
20.
B.
Prayer B. Mandamus or direct command respondents to forthwith appoint a public prosecutor for conducting GR case number so and so, GR case number so and so, pending before the learned judicial magistrate, second and third court, Chandanagar, Hooghly. Now, my lord, this is one. Number two is an order directing the respondent to ensure expeditious disposal of the aforementioned GR cases in compliance with the orders of the Honorable High Court. Now, my lord, there is a coordinate bench judgment passed in criminal division matter that is the annexed part of this writ petition. Now, my lordship kindly sees that this is the administrative domain of the LR, legal remembrance, that is the first prayer. And my lord, here the next prayer is the ensure expeditious disposal. This is a matter to be decided under BNSS 529 of the earlier it was section 483 of the old code. Now it is BNSS 529. I have brought the book. If your lordship wants, I can show it. Now, my lord, the writ court is not the forum. If he was expeditious disposal, then he has to avail of the remedy under BNSS 529. Writ is not maintainable in any event.
BNSS.
Yes, I have got it. Lordship kindly sees.
Allegation against the public prosecutor, but add করুন, party add করুন, personal allegation.
My lord, the
529, sir.
5 page, my lordship kindly sees. To put out here. My lord, this is.
No.
I'm sorry, my lord. I'm so sorry, lordship. Gives me a minute. 529 টা দেখো। Just gives me a minute. Page হচ্ছে পেজটা লিখে রাখো। পেয়েছো? This is, my lord, page 369, page 369, page 369 of this book. Hmm. 369. Last year, it didn't.
BNSS लेकिन ये दो बुक में तीन होना ना, एक और एक है। हाँ, BNSS भारतीय न्याय संहिता।
Lordship, BNSS 529.
Yes.
My lord, in my humble submission, my lord, every high court shall so exercise its superintendence over the courts of session and courts of judicial magistrates subordinate to it, as to ensure that there is an expeditious and proper disposal of cases by the judges and magistrates.
Correct.
So this is the, my lord, the forum. The writ is not the forum. So this repression should be dismissed on this ground alone.
What for what forum you as per this? Which forum as per 1229?
Court taking the criminal jurisdiction.
Well, the court taking the criminal jurisdiction.
529, yes. What forum? Just tell me. Every high court shall show exercise its superintendence
Over the courts of session and courts of judicial magistrates.
Expeditious and proper disposal of the cases. So, where said that the high court is not no jurisdiction?
The high court has jurisdiction.
High court has the. I am not saying that.
Then
I am, my lord, then, but I have not been able to make myself clear. It is, my lord, the 529 is the authority, but it gives the power of superintendence in the criminal jurisdiction, criminal divisional jurisdiction, 227.
where that's I'm telling. Show me. It is show that it is a criminal division jurisdiction. Show me criminal. See, criminal division.
My lord, this
normally what's happened? You file a criminal division, court is either
Yes.
dismissing or dispose of, directing the authority. Like the civil also, civil case, you find that there is a delay in the proceeding of the matter, defendant is delaying, the plaintiff is delaying, you are filing a 226 or 227 to the high court and taking a direction. Correct. It is not that this court cannot pass an order. Superintendence, if the court find it has to be disposed of, it has to be disposed. That is not the ground of maintainability, sir.
no. My lord, these are all criminal matters.
Maybe.
They want disposal of the criminal matters in writ jurisdiction, my lord, under Article 226.
Why 226? Whether the quashing is not permissible? Then
It is permissible. I am not disputing that.
so
I'm not disputing
in a
that.
writ jurisdiction, is the quashing a permissible? In a writ jurisdiction, this court is having the superintendent's power over the judicial district judiciary. Whether this court cannot pass an order for directing the disposal of the matter.
No, no,
The
Lordship
court,
kindly sees.
here is not that the court is punishing any order of the disciplinary action against the author, the criminal
Lordship,
magistrate, whatever.
he wants an order which is the administrative domain of the LR.
Okay, okay. I will
That
see.
is why, my lord, I come before your
That is
lordship.
different thing.
Administrative domain, that is
B.
come
That
before your
is
lordship.
prayer B. That is prayer B. That is
Yes,
prayer
I am
B.
on that.
With regard to the appointment of the public prosecutor, he has to go through the section 24. What is the new? I don't know. What is the new?
Section new is section 18, my lord.
What is-
BNS section, here is section 18, my lord.
But after this,
I have, my lord, the copies here.
There are allegations against. Well, there are certain
My lord,
allegations.
may I
against
submit the
public-
fact first, my lord?
Yes, yes.
Or your Lordship is not satisfied with the preliminary point, my lord?
No, with regard to B, you tell me. With regard to paragraph prayer C, I am not satisfied with that. I am
Malad,
not
this is Lordship kindly sees. Appoint a public prosecutor for conducting GR cases.
Correct.
Pending before the learned judicial magistrates.
Correct.
And then directing respect to ensure expeditious disposal of those cases.
Correct.
Those criminal cases.
Correct.
Malad, this is in my humble submission, Lordship kindly not take me amiss. This comes within the domain of section 529 of BNSS.
Okay, okay.
This is one. And Malad, this is Lordship kindly sees if your Lordship takes then administrative. If this prayer is made, then this will frustrate and coordinate judgment of this honorable court. That is part of the writ petition. Kindly have a look.
Yes.
From page 54.
My lord, I have an
It will start from. This is page 54. Lordship, kindly have a look.
Yes, I have an
Page 54. It is P3, page 54.
Yes.
Lordship, kindly sees. I just
Which paragraph?
hurriedly take your Lordship through the. There, Malad, I think same petitioner was there. This is an abuse of the process of court as well, if I may say so.
57, it is well settled.
Lordship kindly says page 57.
It is well settled.
Yes. Lordship kindly says at the top, undisputably an order appointing a person to act as special public prosecutor or additional public prosecutor or removing any person from such duties is purely an administrative order.
Yes.
Article 227 Constitution confers superintending powers upon the High Court over its subordinate courts and tribunals, and Section 482 of the Code was incorporated to clarify that no provision of the Code is intended to limit or affect the inherent powers of the court. These inherent powers may be exercised to prevent abuse of the process of any court or otherwise to secure the ends of justice. Now, my Lordship kindly sees, and I observed earlier, the order under challenge in the present revisional application is a judicial order, is not a judicial order, and has not been passed by any court of law. It is a purely an administrative order, even though it concerns the removal of a person previously appointed as a public prosecutor in respect of the aforementioned cases. Then, the decision I omit that paragraph. Then it is well settled that before initiating any action before a court of law, a person must demonstrate that they have an existing legal right, and that such right has been infringed or violated by the action or inaction of a person or authority. A de facto complainant has no legal right to dictate or compel the state to engage a public or individual of a person, prosecutor or special officer in a particular case.
Correct.
Lordship kindly sees, I just in this connection, I cite one judgment of the Supreme Court. The Lordship kindly have a look. It's a very short judgment and short paragraph I am relying upon. This is my lord.
Number 12.
This is my lord. 1977 one Supreme Court cases 486.
Yes.
My lord, the relevant paragraph is paragraph 9.
Yes.
May I read, my lord? The High Court rightly dismissed the petitions. It is elementary, though it is to be restated, that no one can ask for a mandamus without a legal right. There must be a judicially enforceable right as well as a legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when a person is denied a legal right by someone who has a legal duty to do something or to abstain from doing something. Then, this is the principle of law.
Correct, sir.
That's
why I'm asking with regard to, that's why I told you with regard to the prayer B that you submit, because see, it is appointment of assistant public prosecutor, it is of the domain of the state.
Lordship.
You cannot come to the court and say that the X is to be appointed, Y to be appointed.
Yes, that is not my prayer.
Correct. You cannot say.
Yes.
It is the state has.
Lordship, I bow down to Lordship observations.
Correct.
And the second prayer is, he wants your Lordship to exercise under Article 226 instead of BNSS. That is provision is specific.
I will grant. Yes. Yes. Tell me.
My lord. But there are the petition is a de facto complaint of 3 criminal cases, which is pending since 2012 and 13.
Correct.
The cases has been, my lord, they proceeded before the learned magistrates, but during the trial, my lord, there is a, I mean, the delay in the proceeding. Thereafter, my lord, in several occasions, the complainant petitioner, my lord, come before this honorable court in a criminal revisional jurisdiction for expeditious hearing. So in expeditious hearing, there are 2-3 orders passed. That is here, my lord, I have annexed. I am showing before during the period of, my lord, the proceeding, one special PP was appointed in the year 2024 in my request. Subsequently, after 1 year, this PP was removed. That is not my request. Automatically, it was removed by the order of the learned LR. Thereafter, since then, my lord, no PP is, engaged in those 3 matters, and this has been, my lord, getting, adjourned time to time, and the next date is given. One is in this month on 6th of December, on is 26th of December, and, my lord, in the month of January. So, my lord, the regular PP.
Which court it is pending?
My lord, 3 cases, my lord, pending in Judicial Magistrate, 3rd Court, Chandannagar, and 2nd Court, Chandannagar.
2 courts. In both the 2 courts,
There are 3 matters.
There is no PP.
No regular, the regular PPs are denying to take the brief because there is one special PP appointed. Subsequently, special PP, my lord, as per my knowledge, that is not on the record. He has submitted the original case record before the concerned court. But the concerned court on the last occasion, what I have handed over the supplementary affidavit. Kindly see the last order I have annexed. Last order. Oh, sorry, my lord, that is not the record. But this is the last order. May I hand over, my lord? Okay.
Yes.
That is on 20th, my lord. Kindly see. Today is the date fixed for the order. Accused number such and such. No steps taken by such and such. Learned lawyer for the accused directed to take steps by the next date in default NO. And then it is pertinent to note there is no person representing state at present after receiving the learned special PP such and such. In absence of learned PP, on behalf of the state, matter cannot be proceeded further. But this is the situation happened in 3 courts. So my prayer is, my lord, to consider my prayer and to appoint any PP, not my choice, according to my choice, because I filed the criminal revision application by challenging the removal of the special PP. That was dismissed. I am not on that. I am just on that to appoint a regular PP as per the choice of the learned members, sir. Yes. Only that, my lord, not more than that. Yes. Only regular people, so that they can proceed the matter.
Whether legal remembrance is the party here?
Yes, my lord. My lord, I have the representation in my supplementary affidavit, page number 7.
Yes. That's what about.
Take an instruction whether there is any PP or not. The court, I am not passing any order to, but state has.
Yes, state will appoint.
State has to see whether the PPs are proper, APPs are there or not. As per the order, one PP has given the brief case diary to the concerned officer.
Yes.
So it is the duty of you take instruction whether it has been appointed or not.
Call for a report from the district judge. The LR's office, LR is a party. The LR should furnish a report that whether they have been appointing any fresh people.
Correct.
That solves the problem.
That is a small prayer before your lordship.
But your lordship kindly calls for a report.
Correct. You are appearing for the 2.
Yes, but I am for all the state respondents, including the LR.
I am passing an order. The legal remembrance is directed to submit the report by which date? By Monday?
Well, 6 is the next.
6 is the next date fixed.
Here. Before 6th, 5th, well,
Monday.
Today is Tuesday.
Today is the Tuesday. 4th.
By Monday.
4th. The legal remembrance is here only. 4th.
But I shall ensure that, as government Peter Malad, I'll ensure that.
That is the only. Because one court cannot be without the government Peter. The litigant could not suffer.
I do appreciate Lordship's view, but I subscribe to Lordship's view. But my Lord, this, my Lord, whether it's in a reach court, that's my preliminary point. Your Lordship kindly record my submission.
I will record, I will deal with that.
That
I will deal with that, no problem.
that reach is not maintainable.
Let a person
PNS
who
is
filed a
400
criminal case cannot be unremedied, my lord.
No, I'm not saying that. I misconstrued then. My submission misconceived. I'm saying there is a forum under BNSS. You can avail of that for expeditious disposal. That is normally done.
The grievance of the petitioner in the present writ application to the effect that the petitioner before this court is the de facto complainant in 3 cases.
Man, 3 cases, a defect in 3 cases.
The petitioner is the de facto complainant in 3 cases pending before the London Judicial Magistrate First Class Third Court, Chandannagar, Hooghly, and in other judicial magistrate at Chandannagar. The matter was fixed on 12/20/11/2025. 2025. It was informed.
With your Lordship's view.
It was informed by the state that the special PP, Mr. Apurva Das, has already relieved from the case, and no learned APP has been appointed to defend the case of the de facto complaint on behalf of the state. Accordingly, he made a representation to the concerned authority, including the legal remembrance and ex officio principal secretary, judicial department, but till date no decision has been taken. Learned advocate appearing for the respondents raised an objection with regard to the maintainability of the present writ application on the ground that the petitioner has prayed for direction upon the respondents for disposal of the GR case in compliance of the order passed by this court. He submits that under section 529 of the Bharatiya Nagrik Suraksha Sanhita 2023, he submits that of BNSS, a specific provision has been provided wherein it is mentioned that every high court shall so exercise its superintendence over the court of sessions and court of judicial magistrates subordinate to it, as to ensure that there is an expeditious and proper disposal of the cases by the judges and magistrate. He submits that the petitioner has filed the present writ application, but section 529 cannot be invoked under Article 226 of the Constitution. He submits that the petitioner is any grievances, he can very well invoke the provision under section 529 of the BNSS, 2003 by filing a revisional application before the concerned court, criminal court. Full stop. Consider and full stop. Section 529 of the BNSS reads as follows. Section 529 of the BNSS, even the superintendent's power to the High Court over the courts of sessions and court of judicial magistrate subordinate to it to ensure the expeditious disposal of the cases by the judges and the petitioner is of the view that 529 is provided, section 529 is provided in Bharatiya Nagrik Suraksha Sanhita 2003. Thus, the said prayer cannot be made in the writ application filed under Article 226 of the Constitution. This court failed to accept the submission. This court is not ready to accept the submission of the London Council appearing for 529 provides the superintendent's power. And this court is having the superintendent's power over the Court of Sessions and the London Judicial Magistrate subordinate to it. If this court sitting in the writ jurisdiction finds that some direction is required to be passed for expeditious disposal, it cannot be said that this court is powerless under 226 of the Constitution. The court sitting in the court taking the matter under sitting in the jurisdiction under 226 of this Constitution of India, also having the superintendent's power over the district judiciary. And as such, if necessary, the court can pass an order of directing the concerned district judge / sessions judge or the judicial magistrate for disposal of the cases in the time-bound manner. Thus, the question of mentality, raised by the petitioner, raised by the state, is rejected. Full stop. This court finds that this matter is regard to appointment or engagement of the APP for conducting of the criminal case before the London Judicial Magistrate First Class Third Court at Chandan Nagar, Hubli. Accordingly, a report is required to be filed by the Legal Remembrance and ex officio Principal Secretary, Judicial Department, Government of West Bengal. The respondent number 2 is directed to file the report with regard to the present status, whether any APP has been engaged / appointed to appear before the London Judicial Magistrate First Class Third Court, Chandan Nagar, to defend the case on behalf of the state. Let the said report be filed by 4th. This is the matter at 4th under the same heading.
Public. Or on next Monday, Malad?
No, 4th. Not okay. On 8th.
On 8th.
On 8th. I am keeping this. You take back because it is
This book.
Yes.
Yes, yes.
Clap.
What are the other ones? What are the other ones?
Yes, next.
Public.
That's it.
একে দেবেন বইটা এই যে
So, my lord, so far I am concerned, my lord, I started this. It's Advocate General reply this opposition. Now it's my turn to reply. A very short time I'll take, my lord, I'll take much time. I should say, my lord, a desperate attempt is being made by the Advocate General to justify the conduct of his officers. Because we are helpless with the lawyers. Whatever we get the information, we say, my lord, this is that. So naturally, my lord, we have got no alternative. But a desperate attempt is made. Now just cited to judgment. I have cited to judgment. Judgment for 2 reasons. So far I am
You
concerned.
cited the judgment with regard to your legal right.
At the same time, the power of the High Court.
Power of the
Power of the High Court. Because Supreme Court in his wisdom thought it fit, there must be a distinction between the power of the High Court and the Supreme Court. Supreme Court may be more powerful, but that is only with the blessing of the Constitution, Article 142. Otherwise, so far High Court is concerned, it's much more to some extent powerful. Because a foreigner come and say, see, this is arbitrary action against me, which they cannot do with the Supreme Court. No, my lord, 2 judgment is cited. Excuse my importance to remind your lordship, my lord, I cited 1 judgment of Justice Arijit Paswat, President. My lord may say, why did you cite the judgment earlier at the time of argument as petitioners? I anticipated with my limited experience of 52 years or 53 years. Now they will come here with some judgment to justify. What is that to judgment, my lord? and 2 or 3 paragraphs. That's it. And I'm not talking about that. No, those are reply কি করতে হবে? So much judgment. I cannot show any judgment here. হ্যাঁ, তুই গেল কোথায় ছিল?
Judgment কোথায়?
Sorry? Something funny. এটা থেকে দিতে হবে। জাজেসটা কোনটা? জাজেসটা কোনটা? আর দুধ এটা কোথায় তুমি দেখো?
BC Chaturvedi?
My lord?
Which one you are giving the reply? BC Chaturvedi?
No, we are not giving any judgment.
No. Reply to the judgment.
There are 2 judgments cited and some paragraphs. Kindly see, my lord. There is a basic and fundamental difference with the limited knowledge I have learned. Service jurisprudence is distinctly different from commercial jurisdictions. There's no doubt about it. The judgment which are cited about the service, and I can say, my lord, with all humility, the judgment which are cited has got no manner of applications. It cannot be created a precedent. It cannot stay your lordship's hand to come to conclusions. Either way, I will lose, I will win. That's why I cited the judgment of Arijit Paswa, 2008 Supreme Court. What is precedent? I'm just citing on the last occasions, my lord. So these are the 2 judgments doesn't apply in my case. That's why I started with this. A desperate attempt is made to somehow to justify the conduct of his officers.
Yes.
Now, to save your lordship valuable time, I've just, when I move this, I also handed over on notes. Kindly see, my lord, is my argument. In para 9, kindly see, my lord, it is their argument. তোর আর্গুমেন্টটা বলছে দেখাচ্ছে নাকি না তোর যে আর্গুমেন্ট শোন না বুঝতেই পারবি তোর আর্গুমেন্ট গুলোই বলছি in para I will also got it, my lord. In para 9 of the order of the department, আরে তুই তো আর রিপ্লাই দিবি না তুই নিয়ে রাখ। In para 9 of the order of the department passed on 12th November 2025, it is alleged that suppressions of relevant informations and even concealment of material facts resulted in the first degree offense in terms of clause 11 within bracket D within bracket I of the tender condition of E in it, and as a result the petition is debarred for a period of 6 months. That is the justifications that you have done all this mischief. Very good. Let us see. Clause 11DI provides submission of eligibility requirements containing false informations or falsified documents. I've given you the page mark. Clause 11G provides penalty for offense, and subclause A therein provides for committing first degree offense any of the cases referred under clause 11DI and 5, forfeiture of earnest money and debarment for a period of 6 months if the offense is detected during technical evaluations. Then petitioner case is that none of the documents submitted by the petitioners are either falsified document. How can it be false? You may accept or may not accept. There may be some misconception, there may be wrong, but false is something else. Falsified document or contain false information, and such clause 11D is not applicable.
Yes.
Then the present submission is limited only to few of the arguments of the respondent which have not been addressed in the previous submission by the petitioners. Respondent argument: the petitioner is to satisfy the requirements as clause B, financial eligibility, as PQ credential in proceeding 3 years, such and such, and comply with clause such and such. My reply is this, my lord. Clause 4(2)B, page 77 provides, it is desired that PDF files of all other original documents in support of their eligibility and PQ credentials shall have to be submitted under the OID cover folders as details below. The petitioner has submitted PDF copies of all the documents as recorded in clause 4(2)B, which includes audited profit and loss accounts and the form CCA, 3CB, 3CD as applicable under IT Act. The petitioner has disclosed copies of the intimation 143 Act by the department for the assessment years and such, along with his reply dated such and such. Thus, the petitioner has satisfied the requirements under the clause 4(2)B NIT. So what is suppressions? My lord, I am really surprised. Suppressions, omission, non-disclosures. Non-disclosure is a very serious aspect. Suppression is a serious aspect. We are knowing fully well the document which is very needed for the purpose of proper adjudication or to consider my case. Purposely and motivatedly. The criminal consequences, my lord. I have suppressed this. This is not a case like that. By force, they are trying to apply this. Then next. Page 3. Annual gross turnover is less than such and such, which is 30% of the amount put to tender as rupees such and such. Our reply is this. The addition to submission made earlier is submitted that the amount put to tender, such and such amount of the said arise clause B, the amount put to tender is inclusive of GST, and hence the petitioner has declared annual gross turnover inclusive GST as the audited balance sheet. But this is very relevant. Suppose I committed a wrong. I just included the GST. It's a matter of adjudications. You may advise no, you are disqualified. But you are debarring me. It's a question of violation of Article 21, my lord. You are snatching my livelihood purposely and motivatedly to go to accommodate some other persons.
No, but have you supplied? You got the this bunch. They have supplied.
Causes bunch.
This bunch, no, on that day, the state has supplied to that.
First thing, whether really have committed any serious fault, allegation is there? No. And same mistake, if I'm using a mistake, that was done by other two persons, they are actually accepted. How they are justified? No. You are intentional, he is not intentional. Very funny. This is not it.
No, this one.
They have supplied these two. No. But anyway, my lord is referring to what the argument?
No, because they have shown your income tax document.
Yes.
Their income tax document is page number 67.
Yes.
Page number 67, there is a clause.
My income tax document.
Yes.
Yes.
Correct. In respect of any sum referred in clause A, B, C, D, E, F, or G of section 43B, the liability for which so and so you have shown, state whether the sale tax, good tax, or service tax, custom duty, excise duty, or any other indirect tax levy, cess, import, etc., is passed through the profit and loss. Zero, you have shown yes, but the amount has not been shown.
Amount has
not been shown.
Not been shown. Very well, my lord. Question is this, my lord. What they require, and that will be reflected from the NIT. They cannot travel beyond that. If something is introduced newly, that is not permissible under the law. If they say,
then page 72 in your document, serial number 40, details regarding the turnover, gross profit, etc. for the previous year and the preceding previous year, 20,29,000 you are shown, included GST. So that's why they are referring.
Their basic argument right from the beginning, not the argument, their justification with options. GST not in, should not be included. I'm just asking one question to myself at the cost of repetitions. Did you follow the system right from the beginning? Kindly appreciate, my lord. All along. So what is wrong on my part? Or even I participated including GST. That was accepted. For the first time, they just trying to introduce something which is not even reflect from the NIT. How is it? And in your affidavit, nothing, no affidavit have you showing that. The question is this, my lord, whether GST to be included or not. And in doing so, if I do any mischief, if I made a false statement, if there is a fraud is a question of fact to be gone into. What fraud I have committed? What mischief I have done? What false statement has been made? No, not to give any document is one thing. Document is given, but it is a false statement. There's a quite difference, my lord. Question is this, do I have any obligation to disclose this document? No. Then even if I do that, that will not give any privilege to them. Most interesting thing is this, my lord. I could have understood. They have considered in all cases to justify their misconduct. They say, you are intentionally disclosed, but the others who has been selected, not intentional, by mistake. How is it? It is something funny. that shows their full man of ID. To accommodate that person, she has done it. Then, my lord, only two pages, my lord. In addition to submission, subsequently, as per instruction of the respondent, the petitioner submitted a statement duly certified by the chartered accountant. The respondent proceeded to evaluate 30%, which is such is less than such. As soon. Secondly, the petitioner bid was not accepted and the petitioner was declared disqualified in the order dated such and such, which with the specific remarks, the committee has further reviewed and scrutinized your bid upon received complaint. Can you see the degree of offense which they have committed? Made by some other bidders and observe that average annual such. Who is the other bidders? Did you serve any copy of their complaint to me? It's a basic and fundamental aspect. Never. So naturally, my lord, authority received some complaint. Now they are trying to justify. No, we are passing the order on our own. We have not taken any care of that. Then how did you qualify me initially? Technically, I am qualified initially. Then they started on the complaint. Once they started with the complaint, that means it is very vital for me. I could have understood you on your duty. No. Then why did you qualify me? Technically, then there is no allegation of any aberrations of shortcoming in disclosing GST and such. Whether the annual gross turnover should include GST or not is a matter of separate consideration. If it is held, annual gross turnover should not include GST, then in the event, the petitioner would not be qualified and his bid to be rejected. This is very material, Kalimaktu. The question of debarment doesn't arise. It is not a false statement. It is not a case of fraud. So, my lord, at best they say you are disqualified. But how they can debar me? Subsequently, second colonity, the respondent argument, petitioner did not show the GST in the clause. I admit. So, accordingly, debarred. Does it really require? Petitioner replied, the petitioner was declared disqualified on the alleged ground that the average annual turnover for the last 3 years is less. Is less than the PQ criteria. These aspects has been agreed at the length and is not repeated. After disqualifying the bid of the petitioner, the respondent raised a fresh allegation that only professional tax has been marked it. This is 11. After disqualification, again there is a dispute. Respondent raised a fresh allegation that only professional tax has been declared in clause 26 of the form 3D, but no declaration regarding GST was found there and debarred the petitioner for 6 months. After the said order was set aside on the Honorable Court, the respondent issued a fresh notice and the order of the department was passed. This aspect has not been good. Very interesting. When he pointed out, they say it is for a different tender. What is a different tender? Everything is same because when the court set aside that, they withdrew. And again, the fresh tender, but it's the same thing. Number and other things. Maybe they said it for administrative reasons. I could have understood, but other reasons, quantum is fixed, nature of job fixed, period is fixed, everything is fixed, same, and memo is fixed. So only to a lame excuse. No, this is what. So they are admitting. That means they are admitting there is a shortfall. And they are actually did not follow the proper step. Still, they have been obliged. It's an absolute discrimination by not arbitrary. Then the respondent insists to oust the petitioner from the tender process is very clear from the contact. The respondent, this is it. Respondent, Mr. Chakraborty Construction was disqualified in a separate tender. Petitioner replied, Mr. Chakraborty Construction was disqualified in the same tender. There is NIT number such and such, and also for the same tender work. The said bidder also did not include GST. Can you mark it, my lord? It's very relevant. Total misdeed, my lord. Very unfortunate. It's very unfortunate. Include GST in clause 26 and clause 40 of form CD, copies of which were annexed with the reply of the petitioner. The said bidder has not been debarred and the said bidder has also been qualified. Kindly see, my lord, what type of action is taken by the authority? Very well, kick me out, I don't mind. But at the same time, you are inviting another person. So he has done the same. I cannot say mischief. I say mistake. Very well, because I'm not done any mischief, any fraud, anything. So if all those things are taken together, my lord, at best they can disqualify. Of course, they cannot do that.
how they can debug me. I don't understand. That shows their intention. Because when the first matter was argued by the Lord Advocate General, the court says, Mr. Advocate General, why did you pass such an order without giving opportunity? Even if I give the opportunity, effectively the same. Kindly see the biasness.
That you have pointed out.
I'm grateful.
Thank you.
So if the all
Thank you. Thank you. Anything further?
No. I have.
Hearing concluded? Yeah.
Before your lordship takes up the original side, item 30.
Oh, barely, my lord.
But item 36, the interim order is expiring today. I'm led by
Which
the
one?
Item 36. Yes.
Item number?
36. But I'm led by the Advocate General, my lord. The interim order is expiring today.
Okay.
And we would also be seeking a week's extension to file the report.
No. But kindly extend the interim order for some time, and my lord, please also, my lord, give us this indulgence to pray for extension of time to file the reply.
My lord, I'm for the response, my lord. Actually, our matter is listed on 36, item number 36, and our learned advocate here, he is expected to arrive here within time. Within time, he is expected to arrive here.
3:30. I will take
Exactly,
your
my
other
lord.
side matter. So, what is your any objection?
No,
I am
yes,
extending. I am extending the interim order. Affidavits completed. So I am extending the interim order. Extending the time for filing affidavit. Reply. I am fixing a specific date in the month of January. Come and argue the matter.
No, may I pay for fix it for tomorrow also?
For what?
For only so that we can submit our submission.
Affidavit is not there.
Affidavit we have submitted.
They have not filed affidavit.
We have already filed the affidavit. We have.
You are the petitioner.
No.
You are for the They want to file affidavit in reply.
Acha.
They want to file affidavit in reply. Let them file affidavit in reply.
Acha.
How soon you will file?
Give us 2 weeks time.
I am let that file the affidavit in reply 2 weeks. I am fixing in the month of January. A date is will fixed so that the matter can be taken up for hearing.
For final hearing, my lord.
Final hearing.
Grateful, my lord.
The advocate general. No, you are as an advocate. Yeah. An advocate appearing for the petitioner prays for extension of the interim order as well as time to file affidavit in reply. Let affidavit in reply be filed within 2 weeks after serving the copy to the London Council for the petitioner. Let the matter. January में कोई डेट देखो 2 बजे 5, 6, 7 तारीख. आप खाली है 7 तारीख नहीं है ना 7th January at 2 p.m. The interim order is extended till 9th January 2026 or until further order, whichever is served.
May I have
May
your
My lord, with
36.
my lord, with regard to item number 66 of today's list, original side matters, my lord. This matter was
Original side.
Original.
Let you wait for time. 36 is over. Is over. I extended the time for filing reply and interim order is extended. I have fixed on 7th of January at 2 p.m. for hearing, final hearing.
Sorry for talking today. I may not have been able to convey myself properly. Among other things, my urgency is that in view of the implemented legislation, the state reserves the right to proceed against me and take action for recovery. So therefore, my matter is to be heard. And therefore, I was praying for urgent motion any day next week.
260.
269. So,
ये 269 একটা কাম করো 9 तारीख को रख दो अर्जेंट मोशन 9 तारीख में yes
Not mentioning on notice,
original side please wait yes
My lord, item number and upon notice for a new connection of this thing. My landlord has disconnected. My mother is also very sick and suffering with cancer. I'm praying that let this matter be taken up tomorrow, Lordship, in the original side matter. I have no electricity.
Madam, may I have your lordships kindly to mention item number 55 of your lordship list, my lord. The petitioner is a brain stroke patient, my lord. My lord, he's a primary teacher. For reasons unknown to him, he's being called by the Chief Economic Offences Wing of the state of West Bengal in reference to a company and he has no relation to that company under any circumstances. But if it can be heard out any day, my lord.
what order you what relief you prayed for
To not take coercive steps against the petitioner because he does not have any relationship with a company and he's a primary school teacher. He's an aged person, my lord. Item number 55, my lord.
55
If it can be taken up, my lord, any day, my lord.
how it can be taken
The
how many matters will be taken within hour
that any day this week, next week, my lord, any day, my lord, any day, my lord, fix it.
My lord, with regard to item number 66 of today's list, my lord, though the matter was fixed by my lord at 12:30 today, but it's not.
you not come when the 12:30
not called.
you not mention
Not mentioned, but mentioning is at 3:30, my lord. It is written over there. But the interim order is expiring today, my lord.
which matter
Item number 66.
who is for the other side
My lord, I have served the serve. At last, against the club, my lord. Against the club. But the disputes are already now settled. At my lord's instance, all the disputes are going to settle. Going to settle, my lord. The new members have come, selected. They are going to settle the dispute. I have already filed the Okaladama today, just in course of this day. So, my lord, I cannot make my submissions here now, but my club has instructed me to appear. In that manner, my lord may extend the interim order. Thereafter, my lord may fix any date. Actually, amendment petition is required to be done. My lord, the new incumbent has to be made a party over here, my lord.
amendment
is required to be done because
item number 66 as per the submission made by the counsel for the petitioner the affidavits completed
everything is complete, my lord. But this matter was Mr. Thakkar was appearing and Mr. Bagh was appearing for the club, my lord.
Extended till 19th of December 2025. Let the matter appear on 18th of December 2020. 18th December. 18th.
18 January.
December. You want January?
My lord, we have to carry out the amendment. We have to carry out the application for amendment. Can it be in sometime in January, my lord?
Let the matter appear on 9th January hoga?
9th January.
9th January 2020.
And the interim order is extended till 9th of January.
Till 9th January 2025.
In the meantime, I think settlement will be done.
Yes.
For inclusion in the list, my lord, for inclusion in the list, my lord, accidentally, my lord, it's a mistake on our part, my lord, it was wrongly filed before Justice Riturbrata Mitra, your lordship. Lordship, release the matter, lordship. I'm mentioning for inclusion in the list, your lordship.
Original side matter?
Yes, your lordship.
Lordship, may be permitted to mention a matter, item 58 of today's list. Lordship, I'm mentioning upon notice, this is my writ petition. Lordship, my account has been declared as fraud. Lordship, I'm praying for an upgradation. Lordship, I'm suffering massively because I'm not being able to take any credit facilities. And Lordship, as per the master circular, the RBI is empowered to...
For the other side.
Lordship,
have you served notice?
I've served notice, Lordship. Lordship, if some preference could be given to this matter.
11 तारीख को रख
Grateful, Lordship.
I want to mention item number 11 of today's list. I want to appear in person. I want to appear going to file competency. They asking for leave from court.
Who has given the competency to you?
Company director. I am a director of the company.
Who are you?
I am a director of the company.
Who has given the competency?
Director, resolution by resolution director.
How many directors are there?
3 directors. One of them, I am also one of them.
You are one of the director
Yes,
of the company.
yes. I am appearing previously. After my cancer detection, I hand over to some
What is
item number 11.
What is the case number?
799 of 2023.
Item number 11. Huh? 799 of the original side. कहाँ है? अच्छा अपील साइड. अपील कहाँ है?
Advocate given no objection certificate.
To file the competency in the department. Yes, call the matter.
Item number 1.
My lord's last order because of 12th of September.
The contemners had taken my file away from me, but thereafter yesterday they had come to me and given me the file and given the document that has been short for. One document was remaining. This is the original sanction plan. I am giving it to the court. This may be kept to the records, and I am giving a copy to them because the original is already in there. Already there.
To be given the registrar. The other original papers are with the registrar.
Yes, yes.
You do one
get
thing.
lost.
Put in the seal cover. I am passing an order. When you deposit, when you submit the same to the
Tomorrow, by tomorrow.
By tomorrow. And then the contempt can be dropped.
ওই তো কপি
ভরসা আছে নাকি?
তুমি তো ইন্সপেকশন আবার অর্ডার করাবে
the mother sanction plan.
Mother sanction plan.
The Learned Counsel appearing for the alleged contempt has supplied the copy of the mother sanction plan and has brought the original to keep the original
affidavit of service
in the record of the case. Accordingly, the counsel for the alleged contempt is directed to submit the said original copy of the mother sanction plan for the building in question in seal cover to the registrar of the original site.
No, in the records of PS7.
Yes,
so they should go
yes.
in the testamentary matter, man.
Yes, previously also we had submitted before the testamentary suit.
On or before 5th of December 2025, and the registrar original site is directed after verify the original mother sanction plan of the building shall keep the same in the record of PS7 of 2022. As the alleged containers complied with the order passed by this court, accordingly, PC 77 of 2025 is dropped.
Okay.
Rule if any suit against the alleged container is
Discharged. Discharged.
Deeply obliged, my lord. Deeply obliged.
Discharge. Next.
I'm appearing for HDFC Bank, my lord, defendant number 11. For the respond number 9.
My lord, we come back after a long time now, so there would be a bit of recapitulation required, my lord. Kindly. This, my lord, remembers was the matter in which the petitioners, my lord, my clients had brought stocks through the respond number 1, my lord, the BRH Wealth Creators Limited. The respond numbers 2 to 8 are the present and ex-directors of the company. Respond number 8 is another group company of the respond number 1. Their business was being carried on by this by this brokers. However, my lord, suddenly one day my client receives information that the NSE has suspended its operations. After that, my lord, stage by stage, we come to learn that the SEBI has started a proceeding against it, and it was found, my lord, shocking details emerged that the respondent number 1 had, through itself and through the mechanism of the respondent number 8 group company, and a few other companies, my lord, some of whom have been implemented herein as a respondent numbers 15 to 15, 16, and 17, my lord. They have pledged client shares belonging to various clients of BRH Wealth Creators, my lord, with at least 4 entities that we had been able to find out till that point of time, my lord. These are the HDFC Bank, the Bajaj Finance Limited, JM Financial Products Limited, and the Axis Bank, my lord. Now, my lord, under the institutional mechanism of the National Stock Exchange and the BSE, my lord, my clients were they had pledged, they had filed their claims with the NSE and the BSE, my lord. We had shown, my lord, on the previous occasions that at least 94 to 95% of their claims had been admitted by both this BSE and NSE, my lord. However, under the Investor Protection Fund, they are entitled to only 25 lakhs each, and that's what they have got. Now, my lord, regarding the other part of it, the claim, so SEBI had started a proceeding, my lord, wherein they had proceeded against BRH, passed interim orders and then final orders against it from time to time, passed orders against the present directors of the respondent number 1. However, my lord, when it came to the ex-directors, my lord, respondent numbers 5 and 6, SEBI had stated that we had really not found much on record to come to the finding that they were in fact involved in this practice and they were let go. The other angle to this, my lord, was the angle of the HDFC Bank Limited, because SEBI had started an independent proceeding against HDFC Bank Limited also, because the 4 entities with which we say that this shares were pledged, my lord, maximum of them, about around 90% of them, was with HDFC Bank Limited. HDFC Bank Limited, my lord, continued to hold shares, this client shares, even after the particular dates fixed by SEBI for liquidation of all these shares and returning them back to the clients had expired. So, my lord, there was an independent proceeding by SEBI against HDFC Bank Limited, where SEBI was a number of directions, my lord, had been passed on SEBI, however, on HDFC. However, my lord, SEBI went up to the Securities Appellate Tribunal, my lord, and there it was let go.
Mistakes which
There are, my lord, at present two SLPs pending, 2 civil appeals, which are right now pending before the Honorable Supreme Court of India, by challenging this particular order of the
page
Securities
32
Appellate
of the
Tribunal, my lord.
recognition where they were
One at
supposed to
the
sign the report. Then Nalin,
to mute kore din ta case kar rahe ho.
where? Page. Yes.
Now, my lord, will kindly come to my lord's interim order, my lord, which was my lord had passed on the 8th of November 2024. I'll not go into the facts, my lord, from here, just the orders that were ultimately passed by my lord at the interim stage. My lord kindly comes to para numbers 13 and 14.
Date number 24.
Not without disturbing your lordship, my lord, maybe all.
You are waiting for another matter?
Yes, my lord.
I don't think so. Other matter released.
My lord, this is my lord's order of 8th of November 2024, my lord. My lord, para numbers 13 and 14, my lord. My lord, kindly sees what my lord had passed at this stage. At that stage, my lord, before affidavits were on record. Considering the above, this court finds that the claims of the plaintiffs are admitted by the defendant number 13. This is, my lord, the NSE. Around 96% of the claims are admitted by the NSE. And the defendant number 13 has passed restraint order against the defendant numbers 1 to 3 and 7 to 11. This, my lord, is a wrong recording. It would be defendant number 12. That is same. The plaintiffs have categorically made out a case that the defendants are interested to dealing with their assets and properties in order to render the suit infructuous, and the plaintiffs will not be able to hold the assets and the properties. The plaintiffs have made out a prima facie case and balance of convenience in their favor. The defendants have, in collusion and connivance with each other, committed fraud upon the plaintiffs. In view of the above, defendant numbers 1 to 8, my lord, which is BRH Wealth Creators itself, its group company, BRH Commodities Private Limited. It's two of the ex-directors and, my lord, the rest present directors. 1 to 8 are restrained from dealing with, disposing of, alienating and transferring or encumbering their assets and properties, and from withdrawing any amount, without keeping aside the sum of rupees 29 crore 65 lakhs 95,549. And the different numbers 9 to 11 and 20, my lord. These are the 4 financial institutions, my lord, with whom the shares were pledged. 9 to 11 and 20 are also restrained from dealing with, transferring, alienating or encumbering the securities available with them, if any, save and except for the purpose of returning them to the plaintiffs till 6th December 2024. My lord, after this, affidavits come in. What transpires, my lord, from the affidavits? I'll first, my lord, go into the affidavits, quickly take my lord through the affidavits of the financial institutions, my lord, 9 to 11 and 20. My lord need not look into the affidavits themselves, just, my lord, I had given 3 separate list of dates, my lord, regarding how the transactions were carried on as regards each of these financial institutions, my lord, 9, 10 and 11.
Yes.
My lord will kindly take that up. If my lord takes up the list of dates pertaining to the respondent number 9, that is JM Financial Products, my lord.
Yes.
My lord has found. Now, my lord kindly comes to item number 5.
You're already, you're completed.
Yes, I'll just show, my lord, a few dates. I'll not go through the entire list of dates, just the important date, my lord. Item number 5, my lord, 5th of April 2016. This is the date when, my lord, a securities agreement, a loan against securities agreement for rupees 100 crores was entered into by the respondent number 1 on the with the respondent number 9, with the representation that the pledged securities belonged absolutely to the respondent number 1. And my lord will kindly also see the application contains signatures of respondent numbers 2, 3, present directors, and the PAN and passport copies of respondent numbers 2, 3 and 5. 2 and 3 present, 5, one of the past directors. So, my lord, here, as regards respondent number 9, my only endeavor is to show that when the LAS agreement was entered into on 5th of April 2016, respondent number 5, my lord, who is one of the past directors, was a director of the company. He had resigned in 2018. So when the practice started, so far as the respondent number 9 is concerned, he was very much there and he was one of the kingpins according to the petitioner, my lord. As on 30th of September 2019, my lord, respondent number 9, I had shown this from the affidavits, I'm just only recapitulating, admitted that it had it was still holding pledge valued at 13.19 crores as on 30th of September 2019, which is explicitly in violation of the SEBI circular of 20th of June 2019, which said that by a cutoff date, you have to release all these client shares and give them back to the respective clients. And my lord, there was also a particular, specific record on letter, my lord, which I had taken my lord through at that point of time, my lord, where respondent number 1, that is BRH, had specifically requested JM Financial, respondent number 9, to release its client securities. It was a direct letter from the respondent number 1 to respondent number 9, admitting that all the shares belong to the clients and not to itself, and seeking release of this client shares. My lord, this letter was sent on 30th of September 2019. In spite of that, they continued to hold this. On 3rd of October 2019, my lord, is the final date when they invoked the pledge. That is 3 days, at least 3 days after a specific direct communication has gone to them, has gone to JM Financial from BRH Wealth Creators, saying that these pledges are not of mine, they actually belong to my clients. At least 3 days thereafter, my lord, they went ahead, they invoked the pledge, they started selling the shares. The sale proceeds admittedly were appropriated on 7th of October 2019, a whole week and 10 days thereafter. So all of this, my lord, this is after public knowledge that R1 has been suspended by NSE, public knowledge that a specific interim order has been passed on R1 by SEBI on 7th of October 2019, and the fact that BRH had directly written a letter to them admitting that those shares do not belong to me. So all these actions, my lord, they have taken place before they have invoked the securities on this. My lord, now we'll kindly take up respond number 10, the list of days, my lord. I'm not taking, my lord, through the other events of the day, so that would just for the purpose of recapitulation. Here, my lord, will kindly so respondent number 10, my lord, despite filing of affidavit, it has not disclosed the date when this loan against securities agreement was entered into by it with respondent number 1. So we are in the dark regarding that. However, my lord, what we find from their affidavit is after the suspension of R1 by NSE on 30th of September 2019, and again in this case also, BRH has written a specific letter to Bajaj Finance asking it to release the client securities on the ground that they are not the owners of this. After that, my lord, on 1st of October 2019, the LAS has been recalled by Bajaj Finance.
1st October?
1st of October 2019, my lord. Yes. The letter, my lord will kindly.
Yes.
This is, my lord, serial number 17.
Okay.
So, my lord, 30th of September 2019, my lord, kindly says is the suspension order by NSE.
Yes.
30th September 2019 itself is a letter from respondent number 1 to the respondent number 10 seeking release of all the client shares. The very next day, my lord, LIS is invoked. So full knowledge, my lord, of the fact that what they're invoking does not belong to the borrower who had in fact created those pledges. After this, my lord, on 11th of October 2019, the client securities were sold by this particular financial institution, my lord, Bajaj Finance. 11th of October 2019, my lord will find that.
Yes.
Item number 20, my lord. So this, my lord, I have indicated which paragraph they have said this in. Paragraph number 12 of the AO, my lord. I'm not... I had placed all those paragraphs during that time. So this the sale of client securities also begins after the interim order has been passed by SEBI, my lord. they invoke, they sell, and the balance after appropriating them towards his needs, they actually return it to BRH. So my shares sold in the market with knowledge of the fact that they do not belong to BRH, proceeds appropriated by Bajaj, and balance extra money is returned to BRH, my lord. This, my lord, has been admitted by respondent number 10 in paragraph 12 of its affidavit in opposition, my lord. This I have indicated in item number 20 itself. Also, my lord, from here also we find that in violation of the SEBI circular of 20th June 2019, my lord, they also skipped the cutoff date, my lord. They were holding pledge of this client shares as on 30th of September 2019, my lord. We do not know the amount because they have not disclosed all those particulars. So, my lord, so far as 9 and 10 are concerned, these are the outcomes, my lord, of the two affidavits, both of them totally in knowledge of the fact that the shares pledged with them do not belong to BRH. They went ahead and sold the shares, my lord, and 10 has in fact returned the extra money to BRH. Yes. Now, my lord, kindly takes up respondent number 11, my lord. This is this has a bit of more materials, my lord. Will kindly take this up. Here, my lord, both R5 and R6 were directors of the company. Yes. The two ex-directors were both directors of the company on 7th of October 2005, my lord. See item number 3 of my list of dates. At the time, this financial assistance was granted by respondent number 11 to the respondent number 1. Yes. My lord, kindly comes to serial number 3, 7th of October 2005. Respondent number 1 availed of financial assistance from respondent number 11 against pledge of his client shares. Respondent number 3 fraud declared, my lord, in the overdraft request letter absolute owner. So this representation, my lord, in the same. I am the absolute owner. The sanction letter has been accepted by my lord, respondent numbers 3 and 5. 5 is one of them, ex-directors. And my lord, kindly comes to the last sentence. Respondent number 8, with whom I had no financial transaction at all, is another group company of the respondent number 1. Respondent number 8 also availed of credit facilities from the respondent number 11 of around 17.9 CRs on the basis of the pledge of securities belonging to clients of the respondent number 1. So, my lord, this is done at a point of time when both R5 and R6 are directors of the company. My lord, the SEBI circular comes on 20th of June 2019. We had shown that circular. Immediately thereafter, my lord, according to the affidavit of the respondent number 1, respondent number 1 says that immediately after the SEBI circular comes, respondent number 11 forced the respondent number 1 to sell securities worth about 60 crores, and it took the money. Yes. The securities were, of course, client securities. So immediately after SEBI publishes the circular, 60 crores gone. Yes. And this is according to R1 at the instance of HDFC Bank itself. They forced them according to them. Last pledge, my lord, was created on 27th of September 2019. SEBI circular, my lord, had come on 20th of June 2019. Despite that, on 27th of September on September 2019, my lord, this last pledge was created by respondent number 1, and this pledge was accepted by HDFC Bank. This, my lord, will find at serial number 18, my lord. Yes. On 4th of October 2019, my lord, which is at serial number 20 one, the second one, my lord, the recalling. The second one,
Recall cassette.
my lord. This credit facility is 191.16 crores for the respondent number 1 and 26.61 crores for in respect of the respondent number 8 was recalled on 4th of October 2019. Though, my lord, there was a specific direction, specific request from the respondent number 1 BRH itself, my lord, I had shown that letter that on 30th of September 2019, requesting the same letter that was sent to the others, requesting them to release the shares because they belong to the clients. On 14th of October 2019, my lords, kindly comes to serial number 23.
Yes.
Despite the SEBI interim order, which had already been passed on 7th of October 2019, on 14th October 2019, the respondent number 11 recalled the credit facilities and invoked pledge on client securities worth admittedly 158.68 crores. From the affidavit of my lord, the respondent number 11, it also emerges that between 15th of October, which is the next one in the list, my lord, 15th of October 2019 and 20th of December 2019. It's not a matter of one day, my lord, 2 months this has been carried on. Within this 2 months period, my lord, out of this 158.68 CR, 148.04 CR worth securities has been sold off by the HDFC. Despite, my lord, there being another further request from respondent number 1 to release all the shares on 16th of October 2019. During this period, my lord, it further emerges that Art 12. So not only the BRH, my lord, BRH has written to HDFC saying you return the shares because they don't belong to me. SEBI has written a letter to HDFC saying you do not go ahead with selling the shares in the market because they do not belong to the respondent number 1. That letter, my lord, is also on record. My lord, I had shown that letter. So, my lord, this and today, my lord, according to HDFC's affidavit, as on 14th of September 2023, it held shares valued at rupees 1.82 CRs. Still, that is what they say is still lying with them. So out of 159 crores, today it's only 1.8 crores that's still lying with them. So this is the only, respondent number 11 is the only entity with whom something is lying. 9 and 10, they have already disposed it off. Yes. Now, my lord, kindly comes to the prayers in my petition, my lord.
Yes.
Page 68, my lord, of my interim application.
Yes.
My lord, prayer A is an order be made directing the respondent numbers 9 to 11 and 20 to forthwith return the securities available with them, if any, in favor of the petitioners, and to take such steps in this regard as may be required till the disposal of the suit. Out of this, my lord, only respondent number 11 has disclosed that it has shares worth 1.82 CRs available with it as on the date of filing of their affidavit, my lord. My lord, prayer B, an order be made restraining the respondent numbers 9 to 11 and 20 from in any manner whatsoever dealing with, transferring, alienating or encumbering the securities available with them, if any, save and except for the purpose of returning them to the petitioners till the disposal of the suit. This, my lord, has very graciously passed on the with the interim as an interim order, my lord, on the first day. The respondent numbers 1 to 8 be directed to show cause. Now, my lord, we are talking of the directors, ex-directors, and the two companies, my lord. be directed to show cause as to why they should not be directed to furnish security to the tune of 29.65 CRs. And if the respondents fail to show cause or show insufficient cause, assets and properties of the respondent was 1 to 8 and the amounts lying in the bank accounts be attached for judgment. My lord, I'll place some judgments I'm carrying with me to show why, my lord, they have to be gone after today. Apart from this, my lord, prayer D, injunction, restraint.
How the prayer A can be at this stage?
Prayer A, my lord?
Yes, 9 to 11 and 20 to 40 return the securities to whom?
My lord, in any event, my lord, apart from that 1.82, I find from the affidavits, my lord, there's nothing remaining today. So the purpose, my lord, has to be now to protect the monetary value of the.
Correct.
My lord, which is why prayer C would be very important for me. And my lord, prayer D, injunction restraining the different respondent numbers 1 to 8 from dealing with and disposing or alienating or transferring, encumbering their assets and properties from withdrawing any amount from their bank accounts without first keeping apart a sum of rupees 29.65. This might also, my lord, had granted. It's continuing, my lord.
So at present, you are enjoying B and
D, my lord. B and D.
Okay.
My lord, I had a further interim order which I had prayed for, which was very important according to the petitioners, my lord. Respondent numbers 12 and 13. These are the SEBI and NSE, my lord, be directed to make over a copy of the forensic audit undertaken by Ernst & Young into the affairs of the respondent number 1. Now, my lord, this particular report, my lord, it appears from the affidavits, my lord, had been made over by NSE and SEBI before other courts, before the Bombay High Court, and by BRH itself, before the Bombay High Court, where other matters relating to other investors are pending. But here in this affidavits, my lord, they have all said that, oh, this does not pertain to your client and we are not disclosing it. So I also, I'm praying for, I shall be praying for, my lord, an order in terms of prayer E also. Now, before that, my lord, I'll go into the some of the some judgments that I would want to place to show why today, because my lord has seen from the affidavits, entire the shares are gone, 9 entirely gone, 10 entirely gone, 11 1.82 CRs, which is nothing. NSE, BSE, both of them have admitted that the claims that I had made, my lord, at least 96% of them, both the bodies have admitted. So, my lord, my intention today would be to protect the monetary value of the shares, my lord. So, my endeavor before my lord would be to show that whoever, my lord, was responsible for the irregular, illegal acts undertaken by the company at the point of time when this acts had commenced, my lord, would have to be gone after, my lord, in order to secure the monetary value of this. First, my lord, for this will kindly come to section 27 of the SEBI Act, my lord. SEBI Act. SEBI Act. আমি দিয়ে দিচ্ছি পড়ো। Number volume. My lord, can you give me one more? আর তোমার খেলা এই জন্যই My lord, section 27, my lord, I would want to rely on. This deals with the contravention, my lord. I just have one copy. I'll just read it up and hand it over to my lord. Section 27 deals with, my lord, the contravention by companies. Where a contravention of any of the provisions of this act or any rule, regulation, direction, or order made thereunder has been committed by a company, every person who at the time the contravention was committed was in charge of and was responsible to the company for the conduct and business of the company, as well as the company, shall be deemed to be guilty of the contravention and shall be liable to be proceeded against and punished accordingly. provided that nothing contained in the subsections shall render any such person liable to any punishment provided in this act, if he proves that the contravention was committed without his knowledge, or that he had exercised all due diligence to prevent the commission of such contravention. The only stand taken by the respondent numbers 5 and 6 was, oh, we were directors of the company, but we did not know, we did not deal with the affairs of the company, nothing else. So there is no, my lord, no, not a single strand of effort on their part to show that all these things happened without their knowledge, or that they had exercised any due diligence to prevent the commission of such contravention. My lord, I will make a photocopy of this and hand it over for the time being, my lord. It's section 27, my lord, of this. Hmm. 2024 SSC online. अच्छा ना आ गया 86 वाला. Oh ma.
Yes.
Yeah. So my lord, even under the SEBI Act, my lord, even under the SEBI has today let them go scot-free on the ground we have not found any materials on them. It is an admitted fact, my lord, that all these practices started, so far as HDFC is concerned, during the time when both of them were directors. So far as JM Financial is concerned, my lord, respondent number 6 was a director. Bajaj, my lord, unfortunately has not disclosed the date, so we do not know when the practice started.
Yes.
So, but both of them were there on board, my lord, when this practice was commenced according to the SEBI Act itself, my lord. Both of them have to be proceeded against, my lord. That is my submission. Now, my lord, the lifting of the corporate veil, my lord. So we'll have to get into all that, my lord. We'll start with not many judgments, so 2-3 judgments on that. My lord will kindly see in which cases the escort. 1986, volume 1, SCC 264. This, my lord, is LIC versus escorts. I'll rely on paragraph 90, my lord, because this paragraph, my lord, very succinctly, it captures the law relating to lifting of corporate veil in India.
Yes.
Paragraph 90, my lord. It was submitted that the 13 capital companies were 13 companies in name only. 90. Sorry. They were but one, and that one was an individual, Mr. Swaraj Paul. My lord, I'm showing this because, my lord, remembers there was a chart in the final order of the SEBI. A number of companies, my lord, some of which have been implemented, some of which have not been. Their details were all provided in that chart with directorship details and everything. At one glance, my lord, they would look like they do not belong to the BRH group, because you do not find any of the Agarwalas in this chart. However, my lord, SEBI had found, there's a findings of the SEBI. I'll just indicate the paragraph number from that order. Order, SEBI final order, para number. Very specifically, my lord, SEBI is finding that this particular persons who are directors of this companies, who are in control and management of the company, are employees of these people, my lord, which is why, my lord, we come to this principle. Coming back to para 90, my lord, it was submitted that the 13 capital companies were 13 companies in name only. They were but one, and that one was an individual, Mr. Swaraj Paul. One had only to pierce the corporate veil to discover Mr. Swaraj Paul lurking behind. It was submitted that 13 applications were made on behalf of 13 companies in order to circumvent the scheme which prescribed a ceiling of 1% on behalf of each non-resident of Indian nationality or origin, or each company 60% of whose shares were owned by non-residents of Indian nationality origin. Our attention was drawn to the picturesque pronouncement of Lord Denning in Wallersteiner versus Moir, and the decision of this court in Tata Engineering and Locomotive Company Limited versus State of Bihar, CIT versus Sri Meenakshi Mills Limited, and Workmen versus Associated Rubber Industry Limited. While it is firmly established ever since Solomon versus Solomon was decided that a company has an independent and legal personality distinct from the individuals who are its members, it has since been held that the corporate veil may be lifted, the corporate personality may be ignored, and the individual members recognized for who they are in certain exceptional circumstances. Pennington in his company law states, 4 inroads have been made by the law on the principle of the separate legal personality of companies. By far, the most extensive of this have been made by legislation imposing taxation. The government, naturally enough, does not willingly suffer schemes for the avoidance of taxation which depend for their success on the employment of the principle of separate legal personality. And in fact, legislation has gone so far that in certain circumstances, taxation can be heavier if companies are employed by the taxpayer in an attempt to minimize his tax liability than if he uses other means to give effect to his wishes. Taxation of companies is a complex subject and is outside the scope of this book. The reader who wishes to pursue, so I'll skip this over. The other inroad on the principle of separate corporate personality have been made by 2 sections of the Companies Act. By judicial disregard of the principle where the protection of public interests is of paramount importance, or where the company has been formed to evade obligations imposed by the law and by the courts, implying in certain cases that the company is an agent or a trustee for its members. In Palmer's company law, the present position in England is stated, and the occasions where the corporate veil may be lifted have been enumerated and classified into 14 categories. Similarly, in Gower's company law, a chapter is devoted to lifting the veil, and the various occasions when that may be done are discussed. In Tata Engineering and Locomotive, the company wanted the corporate veil to be lifted so as to sustain the maintainability of the petition filed by the company under Article 32 by treating it as one filed by the shareholders of the company. The request of the company was turned down on the ground that it was not possible to treat the company as a citizen for the purpose of Article 19. In CIT versus Sri Meenakshi Mills, the corporate veil was lifted and evasion of income tax prevented by paying regard to the economic realities behind the legal facade. In Workman versus Associated Rubber Industry Limited, resort was had to the principle of lifting the veil to prevent the devices to avoid welfare legislation. It was emphasized that regard must be had to substance and not to the form of a transaction. Generally and broadly speaking, we may say that the corporate veil may be lifted where a statute itself contemplates lifting the veil, or fraud or improper conduct is intended to be prevented, or a taxing statute or a beneficent legislation is sought to be vetted, or where associated companies are inextricably connected as to be in reality part of one concern, my lord. This is where I lay my emphasis. It is neither necessary nor desirable to enumerate the classes of cases where lifting the veil is permissible, since that must necessarily depend on the relevant statutory or other provisions. The objects ought to be achieved, the impugned conduct, the involvement of the element of public interest, the effect on the parties who may be affected, etc. So, my lord, when one of the cases, my lord, this judgment says where the corporate veil can be lifted, where there are associated companies, my lord, which are in fact so inextricably connected so as to be called a part of one concern, my lord. My submission, my lord, would be, my lord, it is admitted that 1 and 8 form a part of the same string, my lord. Apart from 1 and 8, my lord, 8 and 9, volume 3. My lord, I'll just place that particular findings of the SEBI on the next day because that would be relevant. My lord, after this, if my lord can kindly look into the judgment in 1996 court. This, my lord, is DDA versus Keeper Construction, 1996, volume 4, SCC 622.
On which point?
My lord, on the corporate wealth point only. My lord, kindly comes to para numbers 24 to 28, my lord, of this judgment.
Yes.
24, my lord. Again, my lord, start with the heading lifting the corporate veil.
Yes.
In Solomon versus Solomon, the House of Lords had observed the company is at law a different person altogether from the subscribers. And although it may be that after incorporation, the business is precisely the same as it was before, the same persons are managers and the same hands receive the profits. The company is not in law the agent of the subscribers or the trustee for them, nor are the subscribers as members liable in any shape or form, except to the extent and in the manner provided by the Act. Since then, however, the courts have come to recognize several exceptions to the said rule. While it is not necessary to refer to all of them, the one relevant to us is when the corporate personality is being blatantly used as a cloak for fraud or improper conduct. My lord, that's exactly what has been done in our case. So when the corporate personality is being blatantly used as a cloak for fraud or improper conduct, and then after being used, my lord, resignation, get out of the company and say we are nowhere. Pennington also states that where the protection of public interests is of paramount importance or where the company has been formed to evade obligations imposed by the law, the court will disregard the corporate veil. A professor of law, S. Ottolenghi, in his article From Peeping Behind the Corporate Veil to Ignoring It Completely, says, the concept of piercing the veil in the United States is much more developed than in the UK. The motto which was laid down by Sunborn J and cited since then as the law is that when the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the corporation as an association of persons. The same can be seen in various European jurisdictions. Indeed, as far back as in 1912, another American professor, L. Morris Wormser, examined the American decision on the subject in a brilliantly written article, Piercing the Veil of Corporate Entity, and summarized the central holding, my lord, in the following words. The various classes of cases where the concept of corporate entity should be ignored and the veil drawn aside have now been briefly reviewed. What general law, if any, can be laid down? The nearest approximation to generalization which the present state of the authorities would warrant is this, my lord. When the conception, my lord, kindly marks, when the conception of corporate entity is employed to defraud creditors, to evade an existing obligation, to circumvent a statute, to achieve or perpetuate monopoly, or to protect knavery or crime, the courts will draw aside the web of entity, will regard the corporate company as an association of live, up and doing men and women shareholders, and will do justice between real persons. So, my lord, one, defrauding creditors. Number two, evading existing obligations, because as brokers, they had obligations towards me, towards my clients, my lord, to return the marketed shares, my lord, at the end of the term. My lord, to circumvent the statute, they have circumvented, my lord, not only the general laws of the land, my lord, the SEBI statute, everything. And my lord, to protect knavery or crime. Para 25, in Palmer's Company Law, this topic is discussed in part 2 of volume 1. Several situations where the court will disregard the corporate veil are set out. It would be sufficient for our purposes to quote the 8th exception. It runs, the courts have further shown themselves willing to lifting the veil where the device of incorporation is used for some illegal or improper purpose, where a vendor of land sought to avoid the action for specific performance by transferring the land in breach of contract to a company he had formed for the purpose, the court treated the company as a mere sham and made an order for specific performance against both the vendor and the company. Similar views have been expressed by the commentators on company law, which do not find it necessary to do so. The law stated by Paras 26, my lord, law stated by Palmer and Gower have been approved by this court in Telco versus State of Bihar. Gower has classified 7 categories of cases where the veil of a corporate body has been lifted, but it would not be possible to evolve a rational, consistent, and inflexible principle which can be invoked in determining the question as to whether the veil of the corporation should be lifted or not. Broadly stated, where fraud is intended to be prevented or trading with enemies sought to be defeated, the veil of a corporation is lifted by judicial decisions and the shareholders are held to be the persons who actually work for the corporation. In DHN Food Distributors versus London Borough of Tower Hamlets, the Court of Appeal dealt with a group of companies. Lord Denning quoted with approval the statement from Gower's company law that there is evidence of a general tendency to ignore the separate legal entities of various companies within a group and to look instead at the economic entity of the whole group, my lord. The learned master of rules observed that this group is virtually the same as a partnership in which all the 3 companies are partners. He called it a case of 3 in 1 and alternatively as 1 in 3. The concept of corporate entity was evolved to encourage and promote trade and commerce, but not to commit illegalities. My lord, I rely on 28. Not to commit illegalities or to defraud people. Where therefore the corporate character is employed for the purpose of committing illegality or for defrauding others, the court would ignore the corporate character and will look at the reality behind the corporate veil so as to enable it to pass appropriate orders to do justice between the parties concerned. The fact that Tejwant Singh and members of his family have created several corporate bodies does not prevent this court from treating all of them as one entity belonging to and controlled by Tejwant Singh and family, if it is found that these corporate bodies are merely cloaks behind which lurks Tejwant Singh and or members of his family, and the device of incorporation was really a ploy adopted for committing illegalities and or to defraud people. Here they have gone a step ahead. Employees, drivers, everybody have been made directors of this companies.
Yes.
My lord will continue on the next day, my lord. My lord has already.
It is already fixed.
On 8th, my lord.
Yes.
8th, my lord.
There is already a date fixed.
Obviously, interim order.
Counsel for the petitioner has argued the matter with two short quantity of time completed. The matter occurred on 8 at 3:30.
He used to have a talented junior.